Good afternoon. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the family law docket for Tuesday, June 16, 2026. The time is now 2:03. Court is now in session. Assisting us today are Cecia Rodriguez, court administrator and interpreter. Ms. Cynthia Flores is the family law court coordinator. Video conference co-hosts this afternoon include Ms. Noriega, Ms. Ramos, Ms. Cuellar, Ms. Flores, and Ms. Rivera. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court, because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum. Wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person, and then those online, as measured by your login times. Ms. Flores.
Your Honor, in person is Attorney Andres Reyes, page 6, number 17.
Manuel Torres versus Kimberly Sanchez.
Good afternoon, Judge. They're both present.
2026 FLA 409C3. Court marks Mr. Reyes present in person. Good afternoon.
Judge, we have an agreement with regard to the pending divorce. And we need an interpreter.
Speak into the microphone and tell the court, are you Kimberly Sanchez?
Sí.
Yes. Welcome to the court. The court marks you present in person. Ms. Sanchez, do you have a lawyer?
No, no tengo abogado.
No, I do not have an attorney.
Will you be going forward today without a lawyer?
Sí, el día de hoy voy a continuar sin un abogado.
Yes, I'm going to continue today without an attorney.
Are you Manuel Torres?
Sí. Yes.
Welcome to court, Mr. Torres. Court marks you present in person. The person to your right is your lawyer. Counsel, what is the announcement?
Judge, we have an agreement on the pending divorce, and if we can have the party sworn in, Judge.
Mr. Torres, Ms. Sanchez, the court is going to ask that you raise your right hands. That each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Sí.
Yes, yes.
Both have answered yes. You may lower your hands. Mr. Reyes, one witness at a time. Go ahead.
Yes, Judge. First of all, Judge, with regard to the jurisdictional requirements, they agree that they have been met by both. They've lived here in this county the requisite amount of time and in the state of Texas as well, Judge. The parties agree that there is one child born of the marriage, KNT, a minor child. And the parties agree that Ms. Torres will be, and Sanchez, I'm sorry, Judge, will be a joint managing conservator, and she will have the right to establish a primary residence of the minor. Mr. Torres will also be a joint managing conservator. He will be awarded standard visitation, Judge. Child support will continue as per the temporary orders, Judge. The amount that is being paid is $125 weekly. Mr. Torres will likewise continue to provide insurance for the minor child. Ms. Sanchez had requested, Judge, a withholding be filed with the employer of Mr. Torres so that payment of the child support will be effectuated through that withholding order. And I have informed her that it takes a little bit more than a couple of weeks before that withholding will be in place, Judge. But we will submit it as soon as possible, Judge. There are some debts, Judge, namely the home at 603 River Hill Drive. The homestead will be awarded to Ms. Sanchez. together with any debt or equity thereon. She has expressed a desire that maybe she will be selling that, Judge. Whatever proceeds are generated from the sale of such homestead will be her sole and separate property. Mr. Torres, Judge, will continue also to make payments of $75 towards the daycare for the minor child. That'll be due the first of every month pursuant to the temporary order as well, Judge. Mr. Torres had likewise agreed to $50 for miscellaneous for the benefit of the child. And that will continue in place until the child is out of daycare and is enrolled in a public school. Judge.
Two questions. First question, these amounts, are they in addition to or included in child support?
They are in addition to child support, Judge.
And will they be paid through to the disbursement unit or separate?
I believe that the way that's being accomplished presently, Judge, is being paid separately from the withholding. The employer certainly will not have the ability to make those payments because it's not from income earned, Judge.
Is there an agreed to method of payment transmission?
Well, Ms. Sanchez had requested that the money be paid directly into her account. And I guess that can be done through a transfer from his account to her account, Judge. We'll do it as tidy as we can. Judge.
As long as there is no cash exchanged for credit and there is some electronic paper trail, I think that's good.
Very well, Judge. There's a 2014 Ford Fusion that will be Mr. Torres' sole and separate property. Whatever money and bank accounts are in their possession and they're under the name will be awarded to the party and under whose name it appears. Ms. Sanchez will receive the 2008 Silverado that's paid for, Judge. That's her sole and separate property. She also has a 2015 Chevy Malibu. That'll be her sole and separate property, and it is awarded to her together with any debt or equity thereon. And finally, Judge, First National Bank, that'll be her bank account, and whatever amounts are therein, Judge, will be her sole and separate property as well. May I proceed with some questions, Judge?
Go ahead.
Would you state your name for the record?
Manuel Enrique Torres Castillo. Manuel Enrique Torres Castillo.
Mr. Torres, you have heard the announcement that I made to the court with regard to the custody of your child. Yes?
Yes.
And you're in agreement that you should receive standard visitation so that you can see your child.
Correcto. Correct.
And you're in agreement that Ms. Sanchez be declared the person who has the right to determine where the child lives. Primary residence.
Yes. Yes.
And you have been paying $125 weekly since the temporary orders were entered in this case. Is that true?
Yes.
And you understand that you will continue to have to pay those $125 a week until the child reaches the age of majority or is otherwise emancipated. You understand that?
I understand, correct.
And you're also responsible for providing health insurance and dental insurance for the child. You understand that?
Yes.
Okay. And you heard me announce to the court that we will be filing a withholding order that is going to be delivered to your employer. Do you understand that?
Yes.
Okay. And you heard me announce to the court as well the division of property that, namely the property located at 603 River Hill Drive, that should be awarded to Ms. Sanchez together with any debt or equity thereon. Yes?
Yes.
And also she will receive a 2008 Silverado, Chevy Silverado and a 2015 Chevy Malibu. Yes?
Correct.
Also, whatever funds are in the First National Bank, bank account that is under her name. You understand that?
Yes.
And you will be awarded the 2014 Ford Fusion as well as the Bank of America bank account and whatever funds are in there.
Yes. Yes.
Now, you are asking the court to grant you a divorce based on irreconcilable differences, and there's no expectation of reconciliation. Is that true?
Correct.
And you've lived here in the county at least the preceding 90 days before coming here today, and in the state of Texas for at least the prior 6 months, yes?
Correct, yes.
And do you believe that the division of property that we've announced to the court is a fair and just distribution of the community estate?
Yes.
And you're asking the court to approve the agreement that we have enunciated here today?
Yes.
My question is Sanchez now.
Go ahead.
Ms. Sanchez, will you state your name for the record?
Kimberly Natasha Sánchez.
Kimberly Natasha Sanchez.
Ms. Sanchez, before coming up here, you had an opportunity to talk with me, is that correct?
Sí, correcto.
Yes, correct.
And even prior to that, we had an opportunity to meet and talk when the court entertained the temporary orders, yes?
Sí, correcto.
Yes, correct.
And right from the start, I impressed upon you that you have the right to have a lawyer present throughout these proceedings, is that true?
Correcto.
Correct.
And notwithstanding my representation, you have decided to go forward today and finalize your divorce, yes?
Correcto.
Correct.
Now, you've heard me announce to the court the division of the community property. Do you believe that the distribution division of the community estate is a fair and just division of the assets that have been accumulated during the marriage?
Sobre la casa.
Yes.
Sí, correcto.
Yes, correct.
Just for clarity, you understand that the house is being awarded to you in its entirety,
Sí,
together with any debt or equity thereon.
sí, correcto.
Yes, correct.
And that is the only piece of real property, land, and buildings that you have purchased during your marriage, is that true?
Correcto.
Correct.
Now, you also heard me announce to the court that you will be the person that has custody of your minor child. And that you will have the right to determine where that child lives.
Correcto.
Correct.
And as well, Mr. Torres will be responsible to provide $125 weekly for the support of the child
Sí,
Yes.
and health and dental insurance for your child.
la aseguranza médica corre bajo mi cuenta.
Okay.
Medical insurance goes under my account.
Ujú.
And the amount that is being paid by you is how much?
Pago 75 más o menos aproximadamente por cada cheque.
I pay about $75 approximately per check.
Okay, and do you understand that the court will order that be reimbursed to you for what you're incurring in child medical care? Yes?
Okay, sí,
Okay.
Yes.
And you have requested that there be an automatic withholding from his wages through his employer. Is that your request as well?
no, ¿cómo no? No entendí.
You asked me to have the money being withheld from his check so that you will receive it into your account.
O del cheque de Torres.
Yes.
Sí.
Okay.
Pero solicité que se retiraran los 125 más aparte los 75 que es por semana, no por mes, y también los 50 de manera todo junto en automático, no que él lo transfiera.
I see.
I requested the 125, the 75, and the 50 for all of it to be withdrawn together.
The judge, I've explained to the judge that the order of withholding is for child support payments and the like that should be withdrawn from his earnings. And so that the payment of the daycare as well as the $50 for miscellaneous should be paid directly into your bank account through his bank account. Do you understand that?
Sí lo entiendo, pero anteriormente en la corte pasada nosotros quedamos en un acuerdo en que todo el dinero se iba a retirar automáticamente de la cuenta de él hacia la mía, punto, no por separado para que él no tuviera que transferir de que nada.
I do recall, but last time we had the meeting, the last court, it was that he was gonna get everything together, so we didn't have to do different deposits.
Well, I've explained to the court that I believe that it's not possible through a withholding order from the employer. But the court it feels strongly that there should be a paper trail that is created. And the easier way to create that paper trail is by way of automatic deposit from his account to your account. Do you understand that?
Sí, entiendo. Simplemente me gustaría que fuera todo de manera en conjunto para evitar tener,
I understand. I just would like to have it all together to try to avoid,
para evitar tener algún tipo de retraso y yo asegurarme de contar con los recursos necesarios durante cada semana para las cosas que ocupa mi hija.
to try to avoid some type of delay so I can have all the resources for anything that I need during the week.
That would necessitate, Judge, I believe, not filing the withholding order with the employer and then just doing the direct deposit to her bank account.
That's not going to happen. So it'll all be together. Any other
Okay.
questions?
Well, I don't know that it's possible, Judge, but if the court believes it is, then we'll do it. that way.
Any other questions?
No.
All right. Questions to you, Mr. Torres. Mr. Torres, did you hear and understand all of the agreement that was told to the court by your lawyer?
Sí, correcto.
Yes, correct.
Is that your agreement with Ms. Sanchez?
Sí, correcto.
Yes, correct.
Is that your full agreement?
Yes,
Was anything left out?
no.
Is there anything you want to change?
No, los pagos siempre los he hecho juntos en conjunto, nunca los he hecho separados, siempre los he dado los $250 juntos.
No, I've always made the payments together, the 250 together.
And do you believe that this agreement that you have with Ms. Sanchez is in the best interest of your child?
Claro.
Of course.
Questions to you, Ms. Sanchez. Ms. Sanchez, did you hear and understand the agreement that was told to the court by Mr. Reyes, Mr. Torres, his lawyer?
No, sorry, no entendí.
No, I did not understand.
Did you hear the agreement that Mr. Reyes told the court?
Sí lo leí, pero no entendí si va a quedar todo en conjunto o por separado.
Yes, I did understand it, but I did not understand if it's gonna be together or separate.
I haven't made that decision yet.
Ok, perfecto.
My question is, did you hear what he told the court?
Sí,
Yes,
And is that your agreement with Mr. Torres?
excuse me?
Is that, did he tell the court your agreement correctly?
sí.
Yes,
Did he tell the court your full agreement?
Sí, solamente que mencionó que los 75 y los 50 eran por mes y es por semana.
yes, just that he mentioned that the 75 and the 50 is per month and it's per week.
Bueno, eso fue lo que me traducieron.
Well, that's what they interpreted.
It's pursuant to the temporary orders, that's what I said, Judge.
No.
Mr. Reyes, is it your understanding that 75 and 50 per week?
Yes, Judge.
Okay. And was anything left out of your agreement, Ms. Sanchez?
No.
No,
Do you believe that this agreement is in the best interest of your child?
Sí, solamente me gustaría poder revisar acerca de las aseguranzas médicas, ya que todo eso corre por mi cuenta.
yes, I would just like go over the medical insurance because that goes on my account.
What do you mean by that?
Como las aseguranzas médicas, si podemos poner alguna parte los dos, ya que todo eso corre bajo mi cuenta.
If we can do some part, each of us, because everything goes under my account.
You told the court that the portion of the health insurance that you are paying on behalf and for and attributable to insuring your child is $75, and the court is prepared to issue out that order. The question the court has is it $75 per month?
Es más o menos por cheque,
It's more or less per check,
And how often do you get paid?
por semana.
per week.
All right. The last question I have, Ms. Sanchez, is are you requesting a name change?
Sí,
Yes,
To what name?
Sánchez. Me pido Sánchez. Nunca me le cambié el apellido, pero igual.
Sanchez. I never changed my last name, but the same.
All right. Anything else from any person?
Nothing
Right.
further, Judge.
Right, Mr. Torres, Ms. Sanchez, in your case, cause number 2026 FLA 409C3, the court at this time finds that it has jurisdiction over this matter, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage, but your marriage unfortunately has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that you had one child that was born in the marriage, no other children were born, adopted, or are expected. The court finds that you have an agreement regarding your child. The court hereby adopts and approves your agreement and finds that that is in your child's best interest. Both of you are hereby appointed as joint managing conservators over your child, which means that both of you have the same rights, duties, responsibilities, and obligations over your child, except that you, Ms. Sanchez, will have the exclusive right to determine your child's residence. Child support is hereby set at $250 per week and reimbursement for health insurance at $75 per week. That, Mr. Torres and Ms. Sanchez, will be paid not directly from one account to the other account, but through the state disbursement unit, so that the Attorney General's office has a true and accurate account of what amounts of money have been paid. And the court finds that all of this is in your child's best interest. The court also heard your agreement regarding the division of your property. The court hereby adopts and approves your agreement and finds that it is a just and right division. At this time, Mr. Torres and Ms. Sanchez, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. These are the orders of the court, and these orders are due to the court honor before.
June 29 at noon by submission.
That concludes your case. Do you have any questions for the court, Mr. Torres?
That's it.
Do you have any questions for the court, Ms. Sanchez?
No, that's one.
Anything else on this matter, Mr. Reyes?
Nothing further, Judge.
Any
I'll
other-
submit the decree.
Fantastic. Any other cases for Mr. Reyes?
That is all for Mr. Reyes.
It's good to see you. Have a great
Thank you,
day.
Judge. Good to see you.
Next case, Attorney Elisa Mar Soto, page 2, number 5.
Rocio Arazola versus Mauro Alanis, cause number 2022 FLI 201C3. Court marks Ms. Soto present in person, Mr. Figueroa present in person. Is anybody here on behalf of the Attorney General's office?
Elias Alcantara on Zoom, Your Honor, with the Office of the Attorney
Mr.
General.
Alcantar, welcome to court. The court marks you present, participating by video conference. Speaking to the microphone and tell the court, are you Mauro Alanis?
Yes, I am.
Welcome to court, Mr. Alanis. The court marks you present in person. The person to your right is your lawyer. Ms. Soto, does your client require Spanish language
She
interpretation?
does, Your Honor.
We'll begin Spanish language interpretation now. Are you Rocio Arazola?
¿Es usted Rocío Arazola?
Sí, presente.
Yes, present.
Welcome to court.
Bienvenida al juzgado.
Your lawyer is present in person.
Su abogado está aquí en persona.
1 to 2 sentences at a time. Counsel, go ahead.
We reached an agreement, Your Honor.
That's correct.
Ms. Soto will
Yes.
set out the agreement.
So
Emma?
Judge, on the motion for non-protunct, we've agreed to the corrections that I've prepared on the order. It's just addressing my client's former name to facilitate the change of the child's last name with the Texas Vital Statistics Office. That's the only change that's being made.
Estamos solicitando el cambio de nombre del menor en la acta de nacimiento y creo que ese es el único cambio que estamos solicitando.
Mr. Figueroa?
That's correct, Your Honor, no objection.
Es correcto, su señoría.
So just to be clear and on the record, Ms. Soto, what name to what name?
So-
Soto, para estar claros en la acta, ¿de qué nombre a qué nombre se va a cambiar?
Judge, the order already said Mauricio Arrazola to Mauricio Alanis. That's already in the order. My
No.
cli-
En la orden decía Mauricio Arazola y se va a cambiar a Mauricio Alanis, pero eso ya lo decía en la orden previa.
What happened is when I was preparing the application, I noticed that the birth certificate has my client's maiden name, and that's not reflected in the order.
Lo único que me di cuenta cuando estaba preparando la orden es que el acta de nacimiento tiene el nombre de soltera de mi cliente y eso no estaba en la orden.
And I know that the citizen is gonna kick it back, so I wanna add her maiden name to the order.
Entonces yo sé que el Estado de Texas lo va a rechazar, entonces quería agregar el nombre de soltera de ella.
So what is the new name that will be reflected in the final order?
Rocío Paloma Bartolo Trejo.
El nuevo nombre va a ser Rocío Paloma Bartolo Trejo.
This is the agreement, Mr. Figueroa?
¿Este es el acuerdo, señor
Yes, Your
Figueroa?
Honor, we have no objection.
Sí, su señoría, no tenemos ninguna objeción.
It's approved by agreement. These orders are due to the court honor before.
Está aprobado por acuerdo.
June 29 at noon by submission.
And then there's another second announcement and an agreement.
Hay otro anuncio, un segundo anuncio, otro.
So Mr. Figueroa filed a motion to modify child support. We've agreed that the child support is going to be reduced to $610.07.
El señor Figueroa hizo una solicitud para modificar la manutención y se va a cambiar a $610 con 7 centavos.
And the child is going to be remaining on Medicaid.
El menor va a permanecer en Medicaid.
And Mr. Alanis in the previous order had already been paying $25 towards that fee. We're asking that that remain.
Y el señor Allen está pagando $25 hacia ese costo y solicitamos que ese pago continúe.
Just one sec. Before I get a confirmation from Mr. Figueroa, Ms. Soto, is there a agreed to start date of the modified child support?
Hay una fecha, señora Soto, de donde va a empezar la modificación de la manutención.
We did not discuss that, Your Honor, but I guess July first.
That's fine.
No lo hablamos, pero creo que podemos empezar en julio 1.
Mr. Figueroa?
That's fine, Your Honor. July 1st.
And
Está bien, su señora, no hay ningún problema, julio 1.
And one other agreement, Judge, by agreement, my client already has, each parent has parent's birthday designated as a date of possession.
Cada uno de los padres tiene el día de posesión, el día de su nacimiento, de su cumpleaños.
And we're just asking that on July 4th, that my client be allowed to have that possession for her birthday from 9 a.m. to 11 a.m.
Solamente estamos pidiendo que en julio 4 mi cliente tenga el menor de las 9 a las 11.
For this year only, Judge, and Mr. Alanis and Mr. Figueroa have agreed to that as well.
Solamente por este año. Y el señor Alanis y el señor Figueroa están de acuerdo en eso.
Mr. Figueroa?
That's correct, Your Honor.
Es correcto, su señoría.
Mr. Alanis, is this your agreement with Ms. Trejo?
Señor Alanis, ¿este es su acuerdo con la señora Trejo?
Yes, it is.
Sí, señoría.
Ms. Trejo, is this your agreement with Mr. Alanis?
Señora Trejo, ¿este es su acuerdo con el señor Alanis?
Sí,
Yes.
Mr. Alanis, do you believe that this is in the best interest of your child?
Señor Alanis, ¿crees que esto es en el mejor interés de su hijo?
Yes, it is.
Sí, señor.
Ms. Trejo, do you believe that this is in the best interest of your child?
Señora Trejo, ¿cree que esto es el mejor interés de su hijo?
sí.
Yes.
Well taken and so ordered. These orders are due also on
Así se ordena.
June 29th at noon by submission. That now concludes your case, Mr. Alanis. Do you have any questions for the court?
Eso concluye su caso, señor Alanis. ¿Tiene alguna pregunta para el juzgado?
One question that I have is that Mauricio has been referred to Arrasola throughout all the paperwork. Is it gonna now reflect Bartolo Trejo? Or does it still reflects Arrasola?
Just one question. Mauricio has always been referred in all the paperwork as Mauricio Arazola. Is he going to be referred to as Bartolo Trejo now?
Judge, I can answer that. The child's birth certificate says Arrasola, so there's no need to change the child's name, but from not this day forward, when the Texas changes his name, he's going to be Mauricio Alanis.
El acta de nacimiento siempre ha reflejado a Mauricio Arazola, pero en el acta de nacimiento ahora va a reflejar Mauricio Alanis.
Does that answer your question, Mr. Alanis?
¿Alanis le contesta la pregunta?
Yes.
Okay. Do you have any other questions?
No, I don't.
¿Tiene alguna otra pregunta? No, señor.
Ms. Trejo, do you have any questions for the court?
Señora Trejo, ¿tiene alguna pregunta para el juzgado?
No, gracias.
That now concludes your case. I wish you both well, but more importantly, I wish your child all the best.
Eso concluye su caso. Les deseo lo mejor y más importante, le deseo lo mejor a su hijo.
Any other cases for Ms. Soto? And for Mr. Figueroa?
Yes, Your Honor, Mr. Figueroa is further down the line.
All right, stand by.
Thank you, Your Honor.
From Ms. Soto, page 4, number 11.
Anthony Martinez versus Erika Lorenza Reyes, cause number 2025 FLC 518C3. Court marks Ms. Soto present in person. Anthony Martinez, Erika Reyes, are you present? Are you Erika Reyes?
Sí.
She needs an interpreter.
Yes.
Erika Reyes?
Sí.
Yes.
Welcome to court. The court marks you present by video conference.
Bienvenida al juzgado. El juzgado la marca presente por medio de videoconferencia.
Your lawyer is present in person.
Su abogado está presente en persona.
Are you Anthony Martinez?
Yes, Your Honor.
¿Es usted Anthony Martínez? Sí, su señor.
Welcome to court. The court marks you present by video conference.
Bienvenido al juzgado. El juzgado lo marca presente por medio de videoconferencia.
Mr. Martinez, do you have a lawyer?
No.
Señor Martínez, ¿usted tiene abogado? No.
Will you be going forward today without a lawyer?
¿Usted va a continuar el día de hoy sin un abogado?
Yes.
Sí. Yes.
Ms. Soto?
Judge, the judge set it down for entry of judgment. We did have a trial on this case. I submitted the decree for the court's signature with the terms ruled on by the court. Mr. Martinez filed an objection stating he's not in agreement, but there's nothing that the court did not rule on it. This was not by agreement. It was the court's verdict.
Introduje la documentación de este caso, fue un caso que se fue a juicio. Yo introduje el decreto que se aprobó en el juzgado, pero el señor Martínez antepuso una demanda de que no estaba de acuerdo.
I recall now.
Ya recuerdo.
Mr. Martinez, you had a bench trial in this case.
Señor Martínez, usted tuvo un juicio en este caso.
You and Ms. Reyes didn't agree to the terms.
Usted y la señora Reyes no estuvieron de acuerdo en las condiciones.
So I pronounced and rendered certain decisions into the court record.
Así que yo pronuncié unas ciertas decisiones hacia la acta del juzgado.
And then I tasked Ms. Soto to prepare a final order in this case.
Y yo le indiqué a la señora Soto que prepararon la orden final en este caso.
Subsequent to that, you filed a response, objection, and proposed final order.
Y después de eso, usted introdujo una orden de protesta.
The purpose then of our hearing today The purpose then of our hearing today is the court to hear why you object to this proposed order.
Y el propósito del día de hoy es para que el juzgado escuche por qué usted está en contra de esta orden.
Understanding the following, the court at this juncture can't make any changes.
Entendiendo lo siguiente, que en este momento el juzgado no puede hacer ningún cambio.
Whatever the court pronounced and rendered then is what should be put into writing and signed now.
Lo que el juzgado declaró en esa fecha es lo que se tiene que poner por escrito y ser firmado.
In the future, you and Ms. Reyes are both welcome to request for modifications.
En el futuro, usted y la señora Reyes, los dos pueden solicitar una modificación.
That being the case, Mr. Martinez, what is in the final proposed order that the court did not pronounce and render?
Ese siendo el caso, señor Martínez, ¿qué es lo que está en la orden final que usted no está de acuerdo?
You had given me a deadline saying that the orders that you had signed were temporary. And if I had provided the information you requested, which were that been going to the counseling, my hair follicle test I turned in, and my W-2s and my taxes from last year.
Creo que lo que estaba mencionando es que usted nos dio una fecha para hacer la prueba antidrogas por medio del pelo y la entrega de las W2 del año pasado.
I don't recall that, but if true, that would be the subject of a modification, not an objection to the previous ruling or to the proposed orders.
No recuerdo, pero si ese fuera el caso, sería una modificación, no una objeción a la orden que ya dio el juzgado.
That may be a good and right and just request.
A lo mejor ese puede ser una petición justa y correcta.
If and when made properly.
Cuando se hace apropiadamente, correctamente.
But I can't modify anything that hasn't been entered in yet.
Pero yo no puedo modificar nada que no haya sido introducido aún.
So again, what in the final proposed order is something that the court did not rule on?
Una vez más, que es algo que el juzgado no pronunció en la orden final.
May you rephrase that in a simpler way, please, so I can get a better understanding?
¿Podría repetirme lo último enunciado?
So everything that I ruled on
Todo lo que yo di el fallo
has to get signed.
tiene que ser firmado.
You may disagree with it, and that may be a good and valid disagreement,
Usted a lo mejor no está de acuerdo y puede ser algo válido,
but that's a subject for a modification in the future,
pero eso está sujeto a una modificación en el futuro,
not a redo now.
no que se rehaga ahorita.
So the question that I need to answer at this hearing is there anything in the order that was prepared by Ms. Soto that incorrectly puts into writing something that I didn't say?
Lo que la pregunta es, ¿hay algo en la orden que la señora Soto hizo que esté incorrecto o que haya sido algo que yo no fue lo que yo dije?
Not that I can recall.
No que yo pueda recordar.
All right. The court finding that there are no incorrect entries into the proposed order, the court has signed those orders.
El juzgado encuentra que no hay ningún error en el documento y ha firmado la orden.
To repeat, Mr. Martinez, and this applies to you, Ms. Reyes, and to every other person.
Para repetirlo, señor Martínez, pero eso aplica para usted y para la señora Reyes y cualquier otra persona.
Families are not static.
Las familias no son,
They don't stay the same.
siempre se quedan igual,
They don't stay the same.
no se quedan igual.
So if there's any changes in your situation, Ms. Reyes' situation, or the child situation in the future, I welcome the opportunity to hear and possibly make modifications.
Si hay algún cambio en el estatus de usted, la señora Reyes o de su hijo menor, con gusto escucharía esa petición a futuro.
Do you have any questions for the court, Mr. Martinez?
¿Tiene alguna pregunta, señor Martínez?
No.
No.
Ms. Reyes, do you have any questions?
Señora Reyes, ¿tiene alguna pregunta? No.
Anything else on this case, Ms. Soto?
No, Your Honor.
¿Algo más, señora Soto? No.
Mr. Martinez, Ms. Reyes, I wish you both very well. More importantly, I wish your child all the best. Have
Señor
a great
Martínez,
day.
señora Reyes, les deseo lo mejor y más importante, les deseo lo mejor a su hijo menor.
Ms. Flores,
Yes, next case from Ms. Soto is page 5, number 14.
Angel Benavides versus Jocelyn Liendo, cause number 2026 FLA 90C3. Court marks Ms. Soto present in person. Mr. Rodriguez is also present in person. Angel Benavides, Jocelyn Liendo, any parties present? Court finds no parties present. Counsel, what is the announcement?
Judge, so we're set for final pretrial today, and there isn't anything to pretry. I believe the court's already signed the order. We were here previously on an entry of judgment to go ahead and start the child support and start the safe haven visit. So we don't have anything to pretry.
Mr. Rodriguez?
That's correct, Judge.
All right, this case is on track. I look forward to calling this case on July 28th at 2. Good luck to all.
Thank you, Judge.
Thank you, Judge.
Next case from Ms. Soto. Page 6, number 15.
Gerardo Barrera versus Eileen Hernandez San Miguel, cause number 2026 FLA 395C3. Court marks Ms. Soto present in person. Gerardo Barrera, Eileen San Miguel. Any parties present? Gerardo Barrera, are you present?
He will be present, Judge. The respondent filed a continuous, so we're not opposed.
Ah, Miss, are you Eileen Hernandez San Miguel?
Sí.
Yeah.
Welcome to court. The court marks you present in person. I didn't sign or approve the continuance outright because I didn't know if it was opposed or not. There's just nothing in there. Having heard that it is not opposed, the request is granted. All right, and for the record, Ms. San Miguel is requesting time to have legal aid review her application. It is well taken. Give us a final hearing date, please, a trial on the merits.
July the 9th at 2 p.m.
And just as an, for the court's information, the children at issue here are my client, the alleged father is not on the birth certificate. So we do need genetic testing to establish paternity and then have the trial on the merits.
Well, as it isn't set for today, I can't do it sua sponte unless it's agreed to. Ms. San Miguel, do you have any disagreement or objection to genetic testing occurring in this case?
No.
All right, so ordered by agreement or without objection. These orders are due to the court honor before.
June 29th at noon by submission.
Then give us a later trial on the merits date to allow testing to occur. Late July, early August.
August 11th at 2 p.m.
That should give legal aid some time to also review this case. Ms. Miguel, do you have any questions for the court?
No.
Anything else on this case, Ms. Soto?
That's all I had, Your Honor.
I wish all parties well. Have a great day.
Thank you.
That is all from Ms. Soto.
Thank
Have
you,
a great
Judge.
day.
Good seeing you.
Next, Attorney Jose Luis Castillo, page 4, number 9.
Octavio Garza Jr. versus Veronica Garza, cause number 2025 FLB 1695C3. Court marks Mr. Castillo present in person.
Your Honor.
Good afternoon. Speak into the microphone and tell the court, are you Octaviano Garza Jr.?
Octaviano Garza.
Welcome to court. The court martial present in person. Veronica Garza, are you present? Court finds Ms. Garza not present. Mr. Castillo, what is the announcement?
Your Honor, we're here for, I guess, a final hearing, Judge. We are ready to proceed.
Mr. Castillo, I reviewed the final decree of divorce and the affidavit. And the only reason I didn't sign it before this hearing is because I have one question.
Sure, Judge.
It isn't clear to me if there's anything in the, I'm sure you've done your due diligence. I just don't see it in the record. If there's anything in the record that confirms that respondent Garza is requesting a name change.
No, Judge, there is nothing, Judge. However, I did confirm that she is using her maiden last name, Judge, and I just put it there as an overabundance of precaution in case she would want to do it officially. But the parties are still very amicable, Judge, and they're just, I guess they just went their separate ways, but as a matter of fact, they had lunch today, Judge.
I think this is the second case this week that I found a similar issue on. Help the court figure out how best to resolve it. I mean, I know you've been told that, I'm sure. If not, you wouldn't have put it into the final decree. But what can I do? What can the court do to prevent a respondent woman later saying, why did you change my name?
Well, Judge, what I tell my clients, Judge, if I'm representing the lady, you don't have to change it. Let's put it in there. You don't have to change your name, but I've had occasions where it's not in the decree. And then 10 years later, they want a name change and they have to go through a whole proceeding, the whole expense. And that way it's in there. If you want to change it, you change it. If you don't, just let it ride.
All right. I guess just ask your client that question so that there's something in the record.
Sure.
Mr. Garza, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yeah.
May the lower your hand, Mr. Castillo.
Yes. Mr. Garza, under what name is your spouse or is Veronica currently using?
She's using Veronica Solano.
Did she ever change her name to that?
Lo cambió y luego lo cambió para atrás. El nombre de su papá, Solano.
She changed it and then she changed it right back to her parent name, Solano.
And as far as you know, is she wanting to keep your name? Did y'all have that discussion?
No, she wants nothing to do with us.
That's all I have here.
Mr. Garza, the court is referring to the affidavit found, signed by you and filed by your lawyer. The court in your case, cause number 2025 FLB 1695C3, the court finds that it has jurisdiction over this case. The court finds that you entered into marriage with Veronica Garza on September the 1st, 2023, but you stopped living together as husband and wife in November 2025 on the 29th day of that month. The court finds that unfortunately your marriage has become insupportable due to a disorder, conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were no children born, adopted, or are expected of the marriage. The court finds that there is no community property for the court to divide. The court finds, based on your credible testimony, that your wife does want a name change. Her name is hereby changed to Veronica Solano. And at this time, Mr. Garza, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. Give me a second while I sign your decree. I have signed your decree. Your divorce is final. Mr. Garza, do you have any questions for the court?
No.
I wish you well. Any other cases for Mr. Castillo?
That is all for Mr. Castillo.
Excuse you.
Good to see you, counsel.
Likewise, Judge. Thank you.
Next case, Attorney Fred Trevino, page 7, number 19.
This is Marisa Escobedo Hasso versus Jose Antonio Gonzalez Albumen, cause number 2026 FLB 859C3. Court marks Mr. Trevino present in person. Jose Antonio Gonzalez, are you present?
Yes, Your Honor.
He's on Zoom, Your Honor.
Welcome to court, sir. The court marks you present by video conference. As you can see and hear from your device, your lawyer is present in person in court. Speaking to the microphone, Ms. Hasso, and tell the court, are you Marisa Escobedo Hasso?
Yes, Your Honor.
Welcome to court, Ms. Hasso. The court marks you present in person. Ms. Hasso, do you have a lawyer?
No.
Ms. Hasso, will you be going forward without a lawyer?
Yes, Your Honor.
The court marks you self-represented. Ms. Flores, does the court have Ms. Hasso's email address?
Yes, Your Honor.
Mr. Trevino, what is the announcement?
Your Honor, I believe the court set this hearing or this date for temporary orders. And the court had, on June 5th, had signed a temporary restraining order that I guess the petitioner had applied for. My client was not served with that petition for or motion for temporary restraining order. Your Honor, the court signed it. It affected property, personal property that my client has, including the Jeep that he uses exclusively, and it's requesting, and the quote, I believe she's also requesting temporary spousal support, Your Honor. But this application, it fails procedurally, and it fails to establish any of the legal elements required in an ex parte hearing or for a motion for temporary restraining order. So we're requesting that this order, the order itself, be dissolved. Now, as far as the temporary orders, Your Honor, I was just recently hired. My client was served with notice of this on Sunday, June 14th, and we're requesting a continuance on the temporary orders. But as far as the motion for temporary restraining order, we're requesting the court dissolve, or at least put it in abatement so that we can have more time to prove up all of the allegations of the petitioner. We filed an answer yesterday, Your Honor, and in our answer, we're alleging that there is no marriage, and there's no pleadings that allege the elements necessary for the marriage, either in the petition or in the temporary motion for temporary orders or motion for temporary restraining order as well.
Two questions. Three questions. First question, Mr. Trevino. The only thing that differs, I think, from the temporary restraining order that the court signed and the standing orders in family law in Webb County is the use of a Jeep 2023. Is it your client's position that he should have use of that vehicle?
Yes, Your Honor. He has exclusive use. He's been making payments on it. He currently resides in Utah. He was transferred with the Texas National Guard. I think he was transferred over there for assignment. And that's his personal use of that.
And the vehicle is where?
In Utah with him.
Second question, other than the provision on the Jeep, is there any provision in the orders that the court signed or any orders that you would request in the future that differ from the Webb County standing orders?
Well, Your Honor, they do, because all of the property that was alleged or requested or affected by the temporary orders, both the temporary orders and the motion for temporary restraining order are the personal property of my client. There's nothing on the record. There's nothing in the deed. There's no, we provided by an exhibit A and B that she's on, that
But
she has that.
there's no
property.
specific property listed, only the Jeep.
Actually, Your Honor, she listed, I believe, the residence 15, 21 Sevilla Lane.
Don't speak until I ask questions. Give me 1 second. You'll have plenty of time to. Give me 1
Yes, Your
second.
Honor, it's 15, I believe it's 15,
But that wasn't signed by the court.
I believe it was, Your Honor.
Tell me the date.
On June 5th, that's on the court. If that's the case, then I'm mistaken, then that must have been in the temporary orders.
It might have been requested, but the only property affected, other than things outside of the scope of the standing orders, is the Jeep. Third question. It seems, based on a review of the record, Mr. Trevino, that Mr. Gonzalez was served, and the affidavit of service reflects June 14th. You're just saying that he didn't get served at the time it was entered, but you're not claiming he isn't served now?
He's served now, but he wasn't given adequate notice here.
Sure. Let me give you some time to respond. What would you like to say, Ms. Hustle?
I created an exhibit of, or kind of, of,
Just
Inaudible.
yes.
So speak louder and just tell me.
Sorry. I created a exhibit of everything we shared together. We were a committed relationship for 4 years. We shared 2 homes. One was in a lease, which I was in. We shared a home which I have messages from the realtor where he's including myself. The Jeep, my mother is the co-signer for his Jeep. I shared utilities. I have cash out, so we joined bank accounts. We were engaged. I have pictures. I did create an exhibit of everything we shared within the 4 years.
And may I respond, Your Honor?
Mr. Trevino, have you filed a request for temporary orders?
No, Your Honor, we're specifically denying any marriage exists. We're not doing a counter petition because, again, there's no marriage in existence. That's what we're arguing. And so we're going to be requesting a motion for summary judgment very soon. I just got the case, Your Honor. So I'll be filing that very soon, and then we'll be providing more evidence. As far as the statements made by Ms. Hasso, the lease that she's arguing that she was on there, it says that they're cohabitants. It's mentioned husband and wife, Your Honor. In the deed, the second property, it lists my client as a male unmarried on that, and it only has his name on the deed. And as far as the cohabitation, there's nothing she's going to present is going to show that they presented themselves as husband and wife in public. The only thing that closely could be argued would be that they cohabitated together, but not as husband and wife. There's no children of the marriage.
So let me ask you two questions, Mr. Trevino. First question. You haven't filed a counterclaim, correct?
No, Your Honor, we filed just an answer.
Because you're just going to defend and prove that she can't prove her case. So my next question is, I know you said you're going to file a summary judgment and the court welcomes you to do that. But if you do, then what the court needs to do is schedule a final pretrial hearing and then schedule a final hearing after that. The final pretrial hearing ostensibly would be for the court to give you a deadline to file the summary judgment based on the new Texas rules 166 with regard to summary judgments. If you went that route, a resolution in this case is going to take much longer. If we did this at a final hearing, then the case will be proven or equally defended, and you'll probably get a resolution in the next 45 to 60 days. If we went the MSJ route, the new rules allow for 90 days plus. So what would be your request on behalf of your client?
At this time, we're just requesting a reset for the temporary orders hearing, Your Honor. And then, a final.
I can't do that because, so let me do this because, Ms. Hasso, I find that Mr. Trevino is correct. If service wasn't perfected at the time that the court signed, then, or shortly thereafter, then they should be dissolved. One, two, he's right. There is nothing in the record that shows why you should be given that Jeep. In other words, there are defects sufficient enough to cause the court to grant the request. So if Mr. Trevino doesn't have a request for temporary orders and now you don't have a request for temporary orders, there went that. So somebody here, if you want temporary orders, should file that request.
Your Honor, well, they sent me everything where he was served everything.
Yeah, I agree with you on that. It's part of the court record. I've seen and reviewed it.
For that, it's also for my safety. He does have, I do have police reports in here, harassments where he's harassing me. I didn't leave the house voluntarily. It was harassments. It was, you know, calling my employer. So I am also doing it for my safety.
I tell you what, the thing here is that since you filed self-represented, and since Mr. Trevino did not file a counter petition, no one here ostensibly has been provided the standing orders of Webb County. Ms. Flores, can you print out 2 copies, please?
Yes, Your Honor.
And for the record and for your benefit also, Ms. Hasso, these can be found on the county website to the district clerk under local rules and standing orders. And in those orders, as I've communicated and asked Mr. Trevino, everything that you've requested already applies to this case. There can be no harassment. There can be no threatening communication. Anybody that's found in violation of any of this is subject to sanctions or other penalties by this court. So I'm going to give you a copy so that at least we're all on the same page.
And Your Honor, as far as the residents, Mr. Hasso is attempting to sell the property. He doesn't reside there anymore. It's here. She's left the house as of February of this year. She hasn't resided there, so there's no, she's been residing.
Why are you telling the court this?
What's Your Honor? Because in the standing orders, I believe there's I think, I don't know if it's G or H, that it addresses marital property, and there is no marital property.
There's nothing I can do about that. And the reason I ask why you're asking is because you successfully argued a dissolving of the temporary order. So there's no more temporary orders hearing. There's nothing left for the court to do.
Thank
so you can put it on the record, but the court's hands are tied until we get to a final hearing, unless somebody makes a request in writing.
Your Honor, could we have a final hearing, request a final hearing?
Well, it looks like, I take it back. It looks like Ms. Hasso and Mr. Trevino, this case is already scheduled for a final hearing September the 2nd at 2 p.m. If you need another setting earlier, make the request in writing and I'll be happy to entertain that request.
Thank you.
Anything else on this case, Mr. Trevino?
No, Your Honor.
Ms. Hasso, anything else that you would like to put on the record or tell the court?
No, Your Honor, just, you know, I was just seeking, you know, like I said, I do have a lot of evidence here to where, it does state that we were a committed couple. Bank accounts, I put my 401k, he was in the joint account. So, all this is in here. That's why I was asking the court to preserve the share of property that we had together, because there was an incident where, like I said, there's a police report. After that police report, he locked me out of the home. So I had no access to the house. So everything that we purchased together, everything that we got together, I don't know what he did to it. So the reason why I was saying this because he locked me out of the house. So I had no way to go in the house. I had no way to, I mean, we had furniture, we had, you know, the police department themselves told them that he needed to give me access to the property The only thing he gave me access to was the garage.
So a couple of things, Ms. Faso. I don't know yet if any of that or all of that is true. It may all be true. It may all not be true or something in between. But what's happened here today is that Mr. Trevino successfully procedurally knocked this case out until the final hearing. So at that time, the court welcomes you and Mr. Gonzalez to testify and to present evidence that everything you're saying is true and correct, and then he'll have the same opportunity to do that. What you need to know at this point, two things. First, just take a look at those standing orders. They're effective for you and for Mr. Gonzalez. Mr. Trevino will provide that to Mr. Gonzalez soon if he hasn't done so already. And two, be on the lookout for your email, because at the time that you present your case, everything that you present to the court must be uploaded electronically to Case Center so that there's no surprises at trial. There's no trial by ambush. Everything is fully disclosed. Everything is fully can be fully presented. Do you have any questions for the court, Ms. Faso?
No, Your Honor.
Mr. Gonzalez, do you have any questions for the court?
Excuse me, I do have one question, but I'll speak to my attorney about it.
All right. I look forward to hearing your case, Ms. Hasso and Mr. Gonzalez, on September the 2nd at 2 p.m. I wish you both very well. Have a good day.
Thank you, Your Honor. I believe that's everything I have.
Good to see you, Mr. Trevino. Have a good day.
Next case, Your Honor, is Attorney Luis Antonio Figueroa, page 3, number 6.
Rocío del Carmen Leal versus Joseph David Leal, cause number 2025 FLA 1654C3. Court marks Mr. Figueroa present in person. Good afternoon, counsel.
Good afternoon, Judge.
Mr. Garcia, Juan Garcia, are you present?
Good afternoon, Your Honor. I'm present.
Court finds Mr. Garcia present by video conference. Welcome. Are you Rocío del Carmen Leal?
Yes, Your Honor.
Welcome to court. The court marks you present in person. Are you Joseph David Leal?
Yes, Your Honor.
Let's have, welcome to court, Mr. Leal. The court marks you present in person. Let's have Ms. Leal stand close to her lawyer. Your lawyer is now on your right. Mr. Leal, welcome to court. As you can see and hear from this screen, your lawyer is present and participating by video conference. Court marks Mr. Elias Alcantar present by video conference on behalf of the Attorney General's office. Mr. Figueroa, Mr. Garcia, what is the announcement?
That we reached an agreement as to all the issues except two matters. We'd like to state in the record our agreement, and then the court can decide in a few minutes our two issues.
All right. What is the agreement?
That the parties agreed to that their domicile in Texas and residents of Laredo, Webb County, Texas, that the grounds for divorce are insupportability. They have reached an agreement as to they have one child that's younger than 3 years old. Both parties will be named joint managing conservators of the child with primary residence to the petitioner. Child support in the amount of $945 a month beginning July 1st, 2026 on a monthly basis. Visitation will be as per our local rules under 3 and as per our temporary orders are in effect already. At the age of 3 or older, and will be standard visitation. There is property. There is one home at 5419 Lone Star Loop. Each party will be awarded half of the property with all indebtedness. They have agreed to list the property for sale with Keller Williams, and that they agree on a fair market value to place the home for sale. If they can't agree, we will come back to court and ask assistance from the court. My client will keep all her personal belongings. Her 2024 Hyundai Elantra with all indebtedness. Each party will have half of the home. My client, the petitioner is requesting a change of name to Lopez. Each party is to pay their individual credit cards and debts. And the only issue before the court is we're alleging that the party did not provide any support from the date of separation, which is November 19th, till January. The first payment of child support was in February. So we're asking the court to grant an amount of arrears of $2,362.50 for those 2.5 months, with a payment of $50 per month. And also my client would like an order from the court as to the sale of the home. The respondent has been living there, not paying on the property. There's already an arrears of $5,500 approximately. They've informed us that he has moved out now, but our concern is that if the house doesn't sell, it will continue to drag on. So we'd like to have a time limit for the house to be placed for sale, and if it doesn't sell, then we'd like it to be foreclosed. We feel that the house might be underwater as to any equity in the home. And those are the two issues, and the rest is by agreement.
Mr. Garcia?
Yes, those are the two issues. On the visits, I don't know if I heard correctly, Your Honor, but I think my client was gonna have the extended standard with a 24-hour notice to the petitioner, Your Honor, before he does his visit.
That's fine.
But I guess I missed that. So extended standard, why would notice be required for something in an order?
That way the client doesn't have to be waiting for him to exercise visitation, for him to notify us 24 hours before that he intends to visit. That way they can make arrangements and have the child ready. The child's 18 months.
I guess I don't disagree with that, but it sounds a little like the reverse would be better, no? Wouldn't 24-hour notice that you're not gonna execute? I mean, if I'm gonna put in an order that says you need a visit on days 1, 2, and 3, why would you need to provide notice that you're actually gonna visit on days 1, 2, and 3?
So long as he voices his intent of not saying no, then we need to have notice.
Mr. Garcia, response?
That would be fine, Your Honor. In case he doesn't go, he can tell her 24 hours before.
Yeah, that way the orders are clear, they're enforceable. Mr. Leal, what would
Can
you
I
like to
speak, Your
say?
Honor? It's because at my job, we can't control the mandatory. We get mandatory. We can't control the overtime. Unfortunately, we're short staffed for about 7 months. Therefore, I was putting a lot of overtime, unnecessary overtime. As a matter of fact, as today, they hired about 35 new officers that are hitting the floors.
I understand that.
Oh, yes.
I understand that.
Yeah.
Jobs.
Yes.
Work is good.
Yes.
But usually in almost 100% of cases, the person wanting to exercise visits has to give notice that they're not going to visit.
Yes, of course.
Not that you're going to give notice that you are.
Yes, of course. Of course.
Do you agree to provide at least 24-hour notice if you do not intend to visit?
Oh, yes, sir, of course. But I just wanted to make sure that, during those times, if my mother could pick up my son, if that's possible.
To exercise your visits?
Yeah.
Any objection, Mr. Figueroa?
For now, they're supervised pursuant to our temporary.
Right, but the question.
We have no objection that the mother assist him.
All right, then it's ordered by agreement.
But I have a question, Your Honor. I wanted to fight for unsupervised time with my son.
And that was our understanding, Your Honor, because it's extended standard. So I don't know if it was going to be, we thought it was going to be unsupervised.
Well, I thought I was hearing an agreement. I'm happy to listen to a contested case, but do you all have an agreement as to supervision or not?
My understanding, the child's under 3, unless he agrees.
From my end, I do want to have unsupervised time if that's possible, Your Honor. I do want to spend time, and especially for my son to grow with to meet his grandma and his aunts, which he never able to do that ever since he was born. I never gotten that opportunity to allow my son to spend time with his grandma.
All right, so all this is going to require some testimony so that the court, if you don't agree, can hear what the stories are and what the positions are. So I'm going to mark this as the first contested matter. There are 3 things now that are contested: retroactive child support, the time necessary to sell the marital home and whether visits should be supervised. But I guess I heard from Mr. Figueroa. Let me ask you, Mr. Garcia, anything to add or say on any of these three matters?
No, Your Honor, those would be the issues.
I guess, Mr. Garcia, question when the court calls this case for contested hearing, what evidence would be presented to the court to show payment of child support during the months of November and January?
What my client explained to me, Your Honor, was that he would like to get credit for him paying the mortgage back then, so that could count towards his child support.
Understood.
And can I speak, Your Honor?
Not yet. Stop.
Oh, sorry.
And Mr. Garcia, how much time do you think would be reasonable and necessary for the court to order as the time to sell the home?
About 6 months, Your Honor.
And this is not agreed to, Mr. Figueroa?
5 months, 3 months.
Okay. Okay, so talk to each other during this interim. This is going to be the first contested matter the court calls. Stand by. Good luck.
Thank you.
Thank you, Your Honor.
Thank you, sir.
Next case, Your Honor, page one, number one, with attorneys Alonso Ramos and Edward Dankoff.
Elsa Gomez, Andres Jorge Gomez, cause number 2018 FLA 2421C3. Court marks Mr. Ramos, present in person. Mr. Dankoff, present in person. Good afternoon, counsel.
Good afternoon, Your Honor.
Court marks Mr. Elias Alcantar, present by video conference. He's here on behalf of the Attorney General's office. Step up in front of the microphones and tell the court, are you Elsa Gomez?
Yes, Your Honor. I'm Elsa.
Welcome to court, Ms. Gomez. The court marks you present in person. Your lawyers are on your right. Speaking to the microphone and tell the court, are you Andres Jorge Gomez?
That is correct, Your Honor.
Welcome to court, Mr. Gomez. The court marks you present in person. Mr. Gomez, do you have a lawyer?
I would not currently, sir. I tried, but no, I do not.
And are you going to go forward today without a lawyer?
I have no choice, so yes, sir.
All right, Mr. Ramos, Mr. Dankoff, what is the announcement?
Judge, we're set for trial on the merits today. We're ready to proceed. We anticipate testimony, which would only be, I think, Ms. Gomez, Judge, maybe 20 minutes. The rest of the documents are prior orders of the court, Judge.
Understood. Ostensibly, Mr. Ramos, this case requires a hearing because there is no agreement with Mr. Gomez?
No, Judge, we tried, we communicated on Friday after I confirmed that he wasn't represented by counsel. We tried and we didn't reach an agreement, Judge.
And Mr. Ramos, so I've already marked this case as the second contested matter that the court will hear this afternoon. Mr. Ramos, once the court hears all the evidence, all the testimony, what is your client going to request from the court?
After all offsets and credits, Judge, because when Mr. Gomez was represented by counsel, Judge, payments were made. So on my pleadings, it was an amount higher. So it's less. So after all offsets and credits, Judge, based on my pleadings back in October, it's roughly $38,998.33, save and accept whatever interest was accumulated from October of last year to the present, Your Honor.
And that is, after hearing all the evidence testimony, that is what Ms. Gomez is going to ask the court?
Correct, Judge.
All right, Mr. Gomez, once the court hears from Ms. Gomez, the court is going to cede the floor to you and let you say whatever you'd like, subject to any objections. After you tell the court what it is you're requesting, what is it that you're going to be asking from the court?
Your Honor, the only thing that I asked for, it's pretty simple. It's just I basically only require some kind of arrangement which is what my offer was on Friday. I offered a lump sum. I've been working to try and pay it off since I found out about this on November.
So if I understand you correctly, and none of this is evidence or testimony, it's just it is on the record. So what you're telling the court, Mr. Gomez, is that you don't deny owing some amount. You would like the opportunity to request, you would like the opportunity to negotiate a reduced amount, but you're going to be requesting that from the court. If there is no agreement, just give you some time to pay off some amount.
That is correct, sir. I'm I've made several offers, but not in an attempt to reduce the amount, in an attempt to make them arrangements for payments.
All right, so I tell you what, Mr. Gomez, I'm gonna give you an opportunity to talk to Mr. Ramos or Mr. Dan Cows. In this interim, I'm gonna continue calling cases. Once I'm done with the first contested matter, then the court will call your case. You need to know, Mr. Gomez, as you talk to Mr. Ramos and Mr. Dan Cows, that they are not your lawyers. They will not, and they cannot provide you any legal advice. But what they can do is tell you what, as they have done with the court, what Ms. Gomez is requesting, and together you can reach agreements as to everything, some things, or nothing. Just know, Mr. Ramos, Mr. Dan Cows, and Mr. Gomez, as you talk to each other, what the court is going to be looking for is, number one, what amount is the true and correct amount, if any, that is owed? And two, how much time is reasonable and necessary to pay that off? This court certainly doesn't want to put someone in the position to fail. So I want an enforceable court order at the end of the day. So talk to each other about these things, and this will be the second contested matter the court calls. Good luck.
Thank you, Your Honor.
Thank you, Your Honor.
Next case, Attorney Guadalupe Castillo, page 9, number 22.
This is in the matter of Javier J. Trevino, cause number 2022 PB 679L2. Court marks Mr. Guadalupe Castillo present in person. Good afternoon, counsel. Court marks Mr. Garcia and Ms. Garcia present in person. Court marks Ms. Rachel Garza present by video conference, Ms. Cristina Mendez present by video conference, Ms. Guadalupe Arroyo present in person together with her daughter, also present in person. I believe the court also saw Marisela Rangel is present by video conference. Court is asking you to turn on your video and start your audio. Is there any other person that the court has not identified present?
Judge Oscar Vela, I'm here because I was purportedly appointed as an ad litem to bless a trust that was created. However, there's no court order on file that I have seen, but I've spoken with all the parties and I had agreed to the trust that was proposed.
I apologize for inadvertently omitting your presence. Welcome to court, Mr. Vela. Court marks all those persons present. Ms. Garza, Mr. Castillo, what is the announcement?
Judge, during the guardianship proceeding of Mr. Trevino, the parties met and we developed a mediated settlement agreement. Part of the settlement agreement was the creation of a trust for Victoria Estela Trevino, a minor child of Mr. Trevino, who is now deceased, and also of Maria Guadalupe Arroyo, my client. During that proceeding, Judge, the parties further agreed that Mr. David Garcia, who's present here, would be in charge of drafting the agreement, the trust agreement, and also that he would be serving as trustee for Victoria Estela Trevino. Subsequent to that, Judge, the court approved the mediated settlement agreement on October 26th October 26, 2023, the MSA was signed by all the parties, and then subsequent to that, the court signed off on it. That was in the guardianship. Later, it was brought to the attention of everyone that there was a minor involved that needed an ad litem. That order, however, was entered in the divorce proceeding that had been instituted by the guardian of the person and of the estate, Cristina Mendez. The order in that case appointed Mr. Vela, Oscar Vela, as ad litem to review the trust agreement and to either approve it, make changes, suggestions. He did, Judge, and he emailed parties, subsequent to that, that he approved of the, trust. And that's where we're here today, Judge. Basically, it's now ministerial. Basically, everybody has approved. I've signed off, Maria Guadalupe Arroyo has signed off on the agreement. Mr. Vela has not, Judge, but he indicated he would if either today or subsequent to the hearing. I don't know his position now, Judge, but that is the history behind this. The document is ready for the judge's signature. Mr. Garcia, who's here present, wanted the court to also sign off on this trust agreement just to make it more enforceable in the various legal respects. And Mr. Well, I don't know if the judge wants to inquire of his position.
Mr. Vela, what, if anything, would you like to inform the court of?
Judge, I had already agreed with the language in the trust. I reviewed it, and it was just pending my signature. I will note that there was a typographical error on page 11 where it talks about his principal versus her principal, or her relating to the beneficiary, Victoria. But I approve of Mr. Garcia, and I approve the language in the order. And if the court requires me to sign the document, I could submit my signature this afternoon.
Anything for the record, Ms. Garza?
No, Your Honor, I think that Mr. Castillo had an accurate, recitation of the history of this and the parties' agreement in this case.
Well, I'm satisfied that Mr. Vela's confirmation is sufficient on the record, although somebody's gonna have to pull the transcript if it becomes an issue in the future. So let me just give you a due date so that it's part of the written court record as well. Let me just ask one other question. Is there any person present that objects to any of this? All right. Court hearing no objection, finds that there is an agreement. The court hereby adopts and approves the agreement, finds that it is good, right, and just, and in the best interest of Victoria. These are the orders of the court. Those orders are due to the court with Mr. Vela's signature on or before
29th at 12 noon by submission.
All right, that is as to the trust. Anything else?
Judge, I would just like to disclose to the court that there are certain minerals that I believe are gonna be in this trust. And
Inaudible.
there are certain minerals. Trust 1/3 of what the miner's father owned. And I represent the decedent's sister and the decedent's sister-in-law with regard to those same minerals. So I just wanted to disclose that to the court. I don't, I would think they'd be similarly situated, but I am currently, working with the oil companies on those same minerals. And I just wanted to disclose that to the court.
Well, I think the disclosure fulfills not only the disclosure, but due diligence. So I guess let me ask this. Is there any person here who would like to be heard on that disclosure, or against, or anything in between?
Your Honor, this is Marisela Rangel. I know I'm present with the guardian of the estate. I know that part of I will review that aspect that Mr. Garcia just noted. Obviously, my intention as we terminate the guardianship matters to then become the dependent administration, that I will follow up and possibly contact Mr. Garcia if for any reason I don't have enough information concerning the interest that he just noted. I know I have information concerning the ranch. I believe that might be the same mineral interest he might be referring to. I will double check the MSA, all of the other matters to ensure that there's a complete transfer to the respective heirs pursuant to that MSA.
Well, and tell me if this is incorrect, Mr. Garcia, but it sounds like you don't have the ability to change any of the ownership. You would just be legally helping them to administer and make sure that all the I's are dotted and T's are crossed. In other words, the work that you are performing on behalf of your clients maximizes the benefit to both, and there's nothing that you can do to change the division, correct?
That's right. The parties are similarly situated. I would probably be trying to get the same deal for the trust that I'm getting for everybody else.
Right.
But I just wanted to make it clear that I do represent those people.
Inaudible.
But one more time, Mr. Garcia, much
I just
louder.
wanted to make it clear that I represented those related people.
All right. That's the impression that the court has, and it's now been confirmed. Would any other person like to be heard on that issue?
Judge, I don't see a conflict with Mr. Garcia. Like the court alluded a while ago, that the interests are similar. Each one gets 1/3, 1/3, 1/3. The fractional interest of the oil and gas minerals would be the same. You cannot change those. The title opinion is there. Now, Mr. Garcia would actually be an asset to all the parties here because he is also excellent in the oil and gas related issues, and he does a lot of leasing for other clients. So he is an asset to the trust and to the whole administration, basically.
All right, so noted. All
Judge,
right.
may I ask a question of the court? Because I was appointed in the divorce proceeding, which has now been dismissed, and I was doing the services on behalf of this order, do I submit a bill to the court, or do I submit a bill to the trust, or do I submit a bill to the guardianship? Just so that we don't have that issue hanging.
Who has that answer, or who would like to be heard?
Judge, I believe it belongs to the estate because it was a combined guardianship. The divorce got transferred into this court from another court, or we were trying to transfer it. I take that back. I was trying to transfer it to another court, and that was denied. It belonged in this court. The guardian of the person in the estate is the one that filed for the divorce, or it's a estate-related issue.
The financial obligation to provide the legal services for the minor belongs to the estate. Do you agree or disagree with Ms. Garza?
We agree with that.
Mr. Angel?
No concerns, Your Honor. I know that these were issues that came before the court, before my appointment as guardian of the estate. But obviously, with provided the court provides me the proper order, which I know the court will, I will proceed and pay Mr. Velez's fees. I'm assuming based on what this court receives and approves.
Without objection and confirmation, the court finds that the obligation, this financial obligation to the minor child, is an obligation now of the estate. The court making that finding, it is so ordered. Mr. Vela, Mr. Angel, as the administrator, can properly review, assess, and take care of that claim.
Thank you, Judge.
I have a similar question. I drafted all that trust and I worked on that trust stuff, and I don't think I've been appointed yet. Like about 3 years ago or something. Where would I submit that bill?
Who has the answer to that
I'm
question?
not a trustee yet.
Judge, I believe the mediated settlement agreement tells us the answer, and I believe it says that the trust will pay Mr. Garcia's fees for the drafting of the document and for being trustee as those fees occur.
Would anybody here like to lodge an objection?
No, Your Honor, that is as guardian of the estate. I believe that is my recollection as well, Your Honor. Obviously, if for any reason that's not in the MSA and we're mistaken, I will be sure to bring before the court to ensure that there's proper closure of the estate matters.
And Your Honor, we agree with Ms. Rangel on that. I believe that Mr. Castillo is right that is that it was addressed in the MSA, and so we would just ask that the way that it's addressed in the MSA is how it ends up being effectuated.
Without objection, the court approves that finding or that non-objection and agreement. It is so ordered.
Okay, well then I would pay myself out of the trust, or they're gonna pay me, because I don't feel comfortable writing checks.
Subject to, well, that's a good question. Who would review? I tell you what, any objection, Mr. Garcia, to just circulating whatever that information is to all the parties to the all the signatories to the MSJ, excuse me, to the MSA? In other words, if you just disclose to the signatories of the MSA, whatever fee statement and whatever check you write, any objection to making that disclosure?
No,
I have no objection, Your Honor.
Mr. Garcia, any objection?
you mean from now on, whatever, or just with regard to this?
Judge, I think the MSA recites that that it's only the fees. The UTMA account shall cause the payment of all attorney fees and expenses charged by David Garcia in preparing the trust document and funding the trust from the UTMA funds. After that, Judge, the trust instrument
Is effective.
Correct.
Right. So, and that's the only issue before the court. The only issue, the only question posed by Mr. Garcia is payment for legal services provided in preparation of the trust. What the court is finding is that as long as there is full disclosure of whatever fee statements and checks are made to Mr. Garcia on his behalf with regard to the preparation of the trust, if disclosed, I think that would be sufficient. After the trust is effective, the trust then, what's the word? The trust holds. All right. Anything else left pending for the court to consider, review, or approve?
Your Honor, I do have my motion. I don't know if the court would like to address my second application for payment of fees and expenses for my services as guardian of the estate.
I think that's one of the reasons we were here. What would you like to tell the court, Ms. Rangel?
Yes, Your Honor, I did file my second application, Your Honor. I know in regards to same, I know in accordance with Texas Estates Code Section 1155.052, an attorney who serves as guardian and also provides some legal services in connection with the guardianship may receive payment. In reviewing my work, I know I had previously been paid for my services from November of 2023, I believe, through November of 2024. My second application covers a time period, and I did file an affidavit, Your Honor, in regards to all of this with my application. These are necessary legal services that I submitted from the time period of November 27, 2024, up and through, I considered it up until through May 31st, 2026. And that amount, Your Honor, pursuant to as filed by my affidavit, as necessary legal services was $25,448 and includes an expense of $1,620 that I paid over to CNA for my surety bond. In addition, Your Honor, I did submit a detailed transaction report concerning those services that were attached to my application and circulated to all parties. In addition to that, Your Honor, in relation to Texas Estates Code 1155.003, I am permitted to, as guardian of the estate, to also receive reasonable compensation and a fee of 5% of the gross income of the estate or 5% of all monies paid. I did a calculation, Your Honor, in relation to that type of work. I submitted payments out in the total amount of $248,959.54, of which 5% would be $12,447.98. And I'm asking this court to allow me to submit payment to myself in terms of my legal services and expenses and for the work done in making those payments in a total amount of $37,895.98, Your Honor. Again, I did submit all information, including an affidavit as to all of these matters. I am a duly certified attorney in the state of Texas and believe that these are just and reasonable and request the court to consider same for payment.
Would any person, lawyer, or party like to be heard on this matter?
Your Honor, we have no objection to the fees requested.
Mr. Castillo, Mr. Vela?
Judge, I represent Maria Guadalupe Arroyo, and no objection on her part, even though she legally will not be involved in the estate. It's the daughter would be, and that would be, in this case, Mr. Vela, to the extent that he's still would be the ad litem.
Judge, I have no position. I don't think I have the role in this particular matter because I was appointed limited for the sole purpose of approving the trust that was created. And so I have no position on the request, Judge.
All right, Ms. Rangel, the court has considered your second application for payment of fees. The court finds that you have performed services through May 31st, 2026 with regard to this case, the estate, cause number 2022. Excuse me, with regard to the guardianship, cause number 2022, PB 679L2. The court finds that reasonable and necessary fees are found in the amount of $37,895.98. It is so ordered. If any person, and I guess we're only here for the guardianship, not for the estate, but I guess just for the record, if any person in the estate case finds that it would be reasonable, necessary, right, or just to have the minor child represented by a lawyer, just please make that request so that there's a signed order in that case as well. And Mr. Vela will have clear indication of what, if any, his role should be in that case. I don't know that it is, but I'll certainly consider it if filed. Anything else on this case, Ms. Garza?
Nothing from us, Your Honor. Thank you.
Mr. Castillo?
Nothing from us, Judge. Thank you.
Ms. Rangel?
Nothing further, Your Honor. I did intend to file a final account today, considering the judge's order as to my fees, but I am just going to await now Mr. Vela's information. I would like to close everything up as neatly as possible without having to file further accounts thereafter. So my hope is that I will receive information from Mr. Vela soon enough and that I can close things up on the guardianship and then simultaneously transfer over to the probate administrative matters.
All right. Anything for the record? Anything else for the record, Mr. Vela?
No, Judge. I'll go ahead and submit my request to Ms. Rangel.
Anything for the record, Ms. Mendez? Court has seen no. Mr. Garcia? Court has heard no. Ms. Garcia? Court has heard no. All right. Any other person? All right. I wish all persons well. Have a great day. Ms.
Thank you, Your Honor.
Noriega?
Be giving a deadline for the final amended, the amended final account, Your Honor?
Yes, those,
Do you want to give that an orders due date, or is that going to be a?
how much time would be reasonable and necessary for that final accounting, Ms. Rangel?
Your Honor, like I said, I think pretty much I have the form ready. I'm trying to get everything done before June 27th, because that's the date that my bond would have to be renewed. So I'm obviously pushing myself on my deadline because I would like to obviously not have further expense, any unnecessary expense to the estate, I guess, whether it be guardianship or probate administratively. So I'm hoping that as soon as I get the stuff from Mr. Vela, I'll complete all payments as necessary and hopefully file that within the next few days, Your Honor. Obviously, before June 27th is my hope and plan.
Well taken. The orders are due to the court honor before,
June 29th at 12 noon by submission.
and that way it's also on our radar. Thank you all. I wish
Yes, Your
everyone
Honor.
a good day.
Thank you.
Thank you, Judge.
Next case, Your Honor, is Attorney Fernando Sanchez. Page 3, number 7.
Elizabeth Adriana Fernandez versus Jose Antonio Fernandez Perez, cause number 2025 FLB 1530C3. Good afternoon, Mr. Sanchez.
Good afternoon, Judge. Nice seeing you again.
Likewise, court marks you present in person. Court marks Mr. Juan Garcia present by video conference. Good afternoon to both.
Good afternoon, Your Honor.
Are you Jose Antonio Fernandez Perez?
Yes.
Court marks you present in person. The person to your left is your lawyer. Elizabeth Adriana Fernandez, are you present? Court finds Ms. Fernandez not present. Mr. Sanchez, what is the announcement? I think this is your motion.
Yes, sir. We filed actually two motions, a motion for new trial and a motion to modify or correct the judgment. It basically says two things. Mr. Fernandez was pro se in the divorce. The decree was signed on May 6th. There's some properties that were not divided. So those were left out. And there was a CD where Mr. Fernandez was to get a portion and Ms. Fernandez was to get another portion, and she got everything. So we're trying to correct that. That's what we're here.
Response, if any, Mr. Garcia?
On this case, Your Honor, I did file an advisory to the court that I was no longer representing Ms. Fernandez Alos. In this proceeding, Your Honor, I had finished with the divorce decree and I did let her know about that.
There was a procedural snag, and that's why I didn't sign your motion outright. Let me see if I can figure out what that was. Now I know what it was. So in this case, the motion to modify was filed on May 20th, well within the required time to request a new trial. Since it's part of the e-file system, service was effectuated on Ms. Fernandez through Mr. Garcia. So maybe the more proper procedural vehicle to make the request is to a motion to withdraw, because the problem, Mr. Garcia, is that if the court signs your advisory and withdraws you, you're still on the hook. In
Your
other words,
Honor?
yes,
Elizabeth Fernandez in the waiting room.
court will admit her now. Thank you. Mr. Cuellar, I see that the device is joining and is logged in as Spanish speaker. Court is admitting a second device. Ms. Fernandez, you're joining us by video conference. The court is asking that you unmute your device and that you start your video.
Señora Fernández, el juzgado le está solicitando que prenda el video y que le ponga el volumen.
Sí, ya tengo volumen.
I have volume now.
Are you Elizabeth Fernandez?
¿Es usted Elizabeth Fernández?
Sí, su señoría.
Yes, Your Honor.
Ms. Fernandez, I called this case.
Señora Fernández, yo llamé a este caso.
Present is Mr. Fernando Perez in person.
Aquí se encuentra el señor Fernando Pérez en persona.
And the person to his left is his lawyer, Mr. Sanchez.
Y la persona a su izquierda es su abogado, el señor Sánchez.
Also present is Mr. Garcia by video conference.
También está el señor García por videoconferencia.
He represented you in the divorce.
Él le representó a usted en el divorcio.
There are
Sí,
two
su señoría.
questions. There are two questions before the court.
Hay dos preguntas en frente del juzgado.
The first is whether the court should grant a motion for new trial and possibly a correction and modification.
La primera es si el juzgado debe de conceder un nuevo juicio o una modificación.
And the second is whether Mr. Garcia represents you in this case.
Y el segundo es si el señor García la representa en este caso.
I guess let me start with the first.
Déjeme empezar con el primero.
Do you have an objection to the court holding a new trial in this case?
¿Usted tiene alguna objeción con que el juzgado tenga otro juicio en este caso?
Sí, tengo objeción porque no veo el caso de que se reabra, ya que todos estuvimos de acuerdo. El único factor que el señor Fernández, bueno, basándonos en su trastorno bipolar de hace 7
Let me
años,
hear translation, please.
Espérame esto porque nos traducí. Sí le veo un problema porque ya se había acordado todo, ya lo habíamos firmado. Lo único es el problema que tiene el señor Fernández de ser bipolar.
Okay, so I just needed to know, now I know that there is an objection.
Solamente necesitaba saber si había una objeción y ahora ya lo sé.
The second thing that the court needs to resolve is whether Mr. Garcia does or does not represent you in this matter.
La otra cosa es, necesito saber si el señor García la representa a usted en este asunto o ya no la representa a él.
Mr. Garcia says that he only represented you in the divorce
El señor García nos mencionó que él solamente la representó durante el divorcio
and has not been
Sí.
re-engaged to represent you in this new portion.
y él no ha sido recontratado para representarlo en esta parte.
What would you like to tell the court?
¿Qué es lo que usted le quisiera decir al juzgado?
sí, no sentí la necesidad de volver a solicitar los servicios del licenciado García, puesto que no aplica, ya todo estaba en orden. Lo único que pues traspapeló todo o afectó a mi esposo psicológicamente fue de que el día 5 de mayo se vencía un CD o
Espérame.
una cantidad
Can we hear a
a
translation,
plazo
please?
fijo.
No, I did not find it was necessary to rehire my attorney. Because everything has already signed and applied for. The only thing was that there was some misleading on some paperwork that I believe was signed May 5th. Continue.
Expired.
Expired.
Sí,
Expired May 5th.
y el CD se reflejó en una cuenta mía personal.
And
Yo
the
tomé,
CD, reflected in my personal account.
ujú, yo tomé lo que ordenó su señoría, el señor Villarreal, tomé la cantidad que ordenó y le dejé ahí su dinero al señor José Fernández. Mi hijo le,
I took my part that was ordered by Mr. Villarreal, and I left the other part there for Mr. Fernandez.
Mi hijo le pidió que me esperara porque yo salí por compromisos personales y le dijo, espera a mi mamá, deja que llegue digamos, le dijo de sus vacaciones.
Let me hear a
And
translation.
and the only thing is my son told him to wait because I was away, let's say, for example, on vacation. And the only thing is that my son told him to wait until I return from vacation.
I guess that's the question that Mr. Sanchez is posing to the court.
Esa es la pregunta que el señor Sánchez le está interponiendo al juzgado.
Was that CD ever disclosed to the court, whether as community property or as separate property?
Ese CD se le dijo al juzgado que era propiedad comunitaria o propiedad por separado.
No, era ahorro de los dos, era matrimonio mancomunado. Y su cantidad, yo retiré lo mío y dejé ahí su cantidad
hear a
y ahí
translation,
está en el
please.
banco.
It belonged to both of us. It was community, it was our savings.
That wasn't the question, though. The question was it disclosed?
Esa no es la pregunta era, ¿se le divulgó al juzgado?
Sí, quedó asentado en la de divorcio, quedó asentado que el día 5 de mayo se iba a liberar ese dinero que me iba a proporcionar a mí la cantidad de 59,950 y él se quedaba pues con el resto, más lo que él tiene en su cuenta personal.
Yes, it was disclosed that on May 5th, the CD was gonna mature and I was gonna get 59,950 and he was gonna keep the rest.
Page 3, paragraph R2. Mr. Sanchez?
Página 3, párrafo R39.
Correct, Judge, I have the decree here. This was a community property, and the decree speaks of the division,
Sí, es comunidad propietaria, el decreto sí habla de la división
and my client has received it.
y mi cliente no ha recibido nada.
No, porque yo le fui a
Ms. Sanchez,
decir
I'm not asking questions.
No,
Give me 1 second.
No estoy haciendo preguntas, señor Sánchez, dame un momento.
So if it was disclosed and addressed in the decree, how is it a correction and not an enforcement?
Y si se declaró y no, ¿cómo es un esfuerzo? una división, si no es una división, ¿cómo lo puedo enforzar?
Well, that's just part of my request, Judge. The other part goes to the division of properties that were not included.
Esa es una
The decree.
parte de mi solicitud, su señoría. Esa es una parte, sino también de las otras propiedades que no se dividieron.
And because the court still has jurisdiction over this case,
Y como el juzgado aún tiene jurisdicción sobre este caso,
I decided to put that issue, so hopefully we could resolve this without having to file an enforcement.
entonces lo quise incluir para poder si lo podíamos enforzar sin tener un nuevo juicio de enforzamiento.
Ms. Fernandez, Mr. Sanchez says that there were certain properties that were left out of the divorce.
Señor Fernández, el señor Sánchez dice que hubo algunas propiedades que se dejaron fuera del divorcio.
You're not under oath, but do you believe
Que
that
me
is
diga cuáles, que
you-
me diga cuáles, porque en la prueba, en la Exhibit A, ahí puse mis pruebas de que todas las propiedades que teníamos se
Ms. Fernandez, I
dividieron.
haven't asked you
y
a
que-
question.
Señora Fernández, aún no le hago una pregunta.
perdón.
Mr. Sanchez says that there were properties that were left out of the court dividing.
El señor Sánchez dijo que hubo propiedades que se dejaron fuera del juzgado para que fueran divididas.
Do you believe that to be true or not true?
¿Usted cree que eso es cierto o no es cierto?
No, no es verdad.
No, it's not true.
Mr. Sanchez,
Just yesterday, I went into Webcat, pulled it out. They're still in both.
into the microphone.
I said, just yesterday, I went into Webcat and I pulled out the properties. There's 4. Actually, there's 3 in Webb County and there's 1 in Bear County.
Hay 4, ayer verifiqué en WebCat y hay 4 propiedades. 3 en Webb County y una en el condado Bear.
And specifically, the addresses are as follows.
Y las direcciones son las siguientes.
In Webb County, it's 220 Asturias Courts.
En Webb County es 220 Asturias Court,
It's 120 Asturias Courts,
120 Asturias Court,
and she'll recognize this as being some apartments.
y va a reconocer eso siendo unos apartamentos.
Also, apartments located at 122 Asturias Court.
Y departamentos en 122 Asturias Court.
There's actually 4 properties in Webb County.
Hay 4 propiedades en el condado de Webb.
And 4518 Sepulveda Lane.
Y 4518 Sepúlveda Lane.
And then in Bear County,
Y en el condado Bear
it would be 14024 Wisdom Road,
sería 14024 Wisdom Road.
which the Bear County Appraisal District records show that this property is in both Miss Elizabeth and Jose Fernandez's name, as well as their
Y en Bear County se refleja que esta propiedad está en nombre de la señora Elizabeth y el señor y de su hija,
Fabiola.
Fabiola.
So those are the properties that were not disposed of.
Y esas son las propiedades que no se divulgaron.
¿Puede ver la Exhibit
Ms.
A?
Fernandez, do you agree or disagree with any of that?
Señora Fernández, ¿usted está en acuerdo o en desacuerdo con algo de eso?
Completamente en desacuerdo y está acreditado en la exhibición A, la A, que yo le proporcioné a su señoría.
Because it's all in Exhibit A that I provided to your honor.
Judge, I do see in the docket sheet that somebody filed some exhibits after we filed our motions, but I was never served with that.
Sí veo que se introdujeron unas pruebas, pero a mí nunca se me notificó de eso.
2 questions, Mr. Sanchez. Mr. Sanchez, attached to the motion for new trial, did you attach any exhibits?
2 preguntas, señor Sánchez. Una pregunta de ellas. En la notificación de un juicio nuevo, ¿usted puso alguna notificación de evidencia?
Let me check. No, just a verification for my client.
No, señor, solamente la verificación de mi cliente.
And were the WebCat documents uploaded to Case Center?
¿Se
No, sir.
subieron los documentos de WebCat a filings? No.
All right, Ms. Fernandez, Mr. Perez, let me do this in the interest of justice.
En el mejor interés de la justicia, señor Fernández, señora Fernández, déjeme hacer eso.
Because under the rules of this court, the court can't hear the argument or the defense unless they're uploaded to Case Center.
Porque por la política de este juzgado no puede escuchar nada si la evidencia no está en los archivos de case.
So since you don't have an objection, Ms. Fernandez, to your lawyer withdrawing, I have signed an order and he is withdrawn from this case.
Como usted no tiene ninguna objeción, señora, de que su abogado se retire, he firmado la orden.
And we're going to come back on Thursday at 9
Y vamos a regresar el día jueves a las 9
to hear this case.
para escuchar este caso.
But all of your exhibits that you want the court to consider, Ms. Fernandez, and all of the courts that you want the court to consider, Mr. Fernandez, must be uploaded to Case Center so that there's a full disclosure.
Pero toda la evidencia que quieran comprobar, señora Fernández, señor Fernández, deben de estar puestas en el sistema Case
Center.
Center.
Ms. Flores, does the court have Ms. Fernandez's email address?
¿Tenemos el correo electrónico de la señora Fernández?
Yes, Your Honor.
Sí, sí.
All right, so be on the lookout for your email address, Ms. Fernandez and Mr. Sanchez.
Señor Sánchez.
Upload your evidence,
Estén pendientes de su correo y por favor suban toda la evidencia
and you will both have access to each other's documents.
y van a tener los dos acceso a los documentos.
I'll call this case. I'll set it for hearing Thursday at 9. Do you have any questions for the court, Ms. Fernandez?
Lo voy a poner el jueves a las 9 de la mañana. ¿Tiene alguna pregunta, señor Fernández?
Este jueves sería,
It would be this Thursday.
This Thursday at 9.
Este
Yes, ma'am.
jueves a las 9.
me podré presentar por Zoom porque no me encuentro dentro de la ciudad del país.
Can I appear by Zoom because I'm not in the city, I'm not in the country?
¿Podría darme otra fecha la próxima semana?
Could you give me another date next week?
Ms. Flores, how many cases on July the 1st?
The pro se docket, Your Honor?
Yeah.
15.
Any objection to July the 1st at 2 p.m., Ms. Fernandez?
Julio primero a las 2 de la tarde, señora Fernández.
Muy amable, gracias, te lo agradezco.
Thank you very much.
Any objection to that day, Mr. Sanchez?
You have a setting in federal court.
Sí tengo una audiencia en la Corte Federal.
Exactly at 2.
Exactamente a las 2.
Any objection to July the 7th
¿Alguna objeción a julio 7
at 2 p.m.?
a las 2?
Por mi parte está bien.
On my behalf, it's okay.
You have setting.
Council Sanchez inaudible.
I'll work it out on the 7th, Judge. I have some CPS cases in CC1, but I'll be able to be here.
Lo haré funcionar, su señoría. Estaré aquí.
Ms. Flores?
So this be an in-person hearing, Your Honor?
Yes, in person, July the 7th at 2 p.m.
Va a ser en persona, julio 7
The
a las
court,
2 p.m.
the court takes judicial notice that the deadline for the court to decide on the motion for new trial is July the 20th, so we're well within the guidelines.
La fecha límite para decidir si hay un juicio nuevo es julio 20 y estamos dentro de las fechas.
But just one more time, Mr. Sanchez and Ms. Fernandez, make sure that all of the evidence that you would like the case to consider is uploaded to Case Center.
Una vez más, señor Fernández, asegúrese que toda la evidencia que quieran presentar sea introducida al sistema Case Center.
You have any questions for the court, Ms. Fernandez?
¿Tiene alguna pregunta, señora Fernández?
No, nada, yo ya metí toda la evidencia que tenía, se supone que debe estar en mi expediente.
No, I already uploaded all the information. It should be on file.
No.
No.
I'm telling you, you need to file it into Case Center, which is the evidence sharing platform.
Le estoy diciendo que necesita introducirlo al sistema Case Center, que es donde se comparte la evidencia.
Please look at your email for a notice from Case Center.
Por favor, revise sus correos electrónicos para una notificación de Case Center.
When you file documents into the case, they're not admitted, they're not evidence, they can't be used.
Cuando usted introduce documentos al caso, no son evidencia, no pueden ser utilizados.
And I don't want to put you or Mr. Fernandez at a disadvantage when you try your case.
Y no quiero ponerla a usted ni al señor Fernández en una desventaja cuando veamos su caso.
That's why I'm saying this for the third or fourth or fifth time. please upload all evidence to Case Center.
Por eso se lo estoy diciendo por tercera, cuarta, quinta vez. Por favor, introduzca toda su evidencia al sistema Case Center.
If you don't see that email, please call the court to have it resent.
Si no ve ese correo electrónico, por favor, comuníquese con el juzgado para que le reenvíen el correo.
Do you have
Muy
any other,
amable.
do you have any other questions for the court, Ms. Fernandez?
¿Tiene alguna otra pregunta, señora Fernández?
No, su señoría, gracias. Le agradezco el cambio de fecha.
No, Your Honor. I thank you for the date change.
Yes, ma'am. Mr. Fernandez, do you have any questions?
Señor Fernández, ¿tiene alguna pregunta? No, sir.
Anything else on this case, Mr. Sanchez?
¿Algo más, señor
Quick
Sánchez?
question, Judge. She claims that she dropped off the check, but she claims that she dropped off the check with somebody. If we could just clarify that so we can get that over.
La señora dice que le dejó un cheque a alguien. Si pudiéramos aclarar a quién.
Ms. Fernandez, Mr. Sanchez is asking so that he can, and you can forget about making those arguments to court, is who did you transmit or deliver the CD check to?
¿A quién? Nomás para el señor Sánchez está preguntando para aclaración del juzgado, ¿a quién se le entregó el cheque del CD?
A nadie, está en mi cuenta. Yo tomé lo que su señoría me ordenó y dejé lo restante para el señor Fernández. Fui con el señor Sánchez en persona y le dije, ¿le puedo extender el cheque? Me dijo, no, nos vemos en la corte.
No, it's in my account. I took my part and I left his part in my checking account. And then I went to saw Mr. Fernandez and I asked him if I could extend a check to him. And he said no, that we would see each other in court.
If you're coming on to court on that day, why don't you just bring a check and just resolve it that way?
Si viene ya que va a venir al juzgado ese día, ¿por qué no nomás trae un cheque para ya acabar con eso?
You can put it on the record. This is a check for this amount. I'm giving it to this person, and that resolves that.
Y lo ponemos en la acta. Este es un cheque por tal cantidad, se lo estamos dando a tal persona y ya terminamos.
Sí, yo le ofrecí al señor, al licenciado Sánchez y no quiso.
Okay, all right.
She went to my office, Judge. She was still technically being represented by Mr. Garcia. I could talk to her. I told her to show up in court. We'll figure it out.
Cuando ella fue a mi oficina, técnicamente todavía estaba siendo representada por el señor García y por eso fue la situación.
I look forward
Claro
to,
que no, claro
look
que
forward,
no, yo no estaba representada.
I look forward to hearing this case on July the 7th. Good luck to both.
Los
You're
espero
excused.
Julio 7 y buena suerte a los dos, ya se pueden retirar.
Court will stand at
Gracias.
ease momentarily.
All right.
Good afternoon. Court is back in session. This is Webb County Court at Law 2's Family Law Docket for Tuesday, June 16, 2026. The time is now 4:26. Court is once more in session. Ms. Flores, who is the next lawyer present?
Yes, sir, that'll be Attorney Ruben Arce, page 8, number 21.
Juan Ortegon versus Jasmine Rodriguez, cause number 2026 FLE 459C3. Good afternoon, Mr. Arce.
Good afternoon, Your Honor.
Court marks you present in person. Court marks Mr. Elias Alcantar present and participating by video conference. Juan Ortegon, Juan Ortegon, Jasmine Rodriguez. Any parties present?
I believe that he was attempting to get on Zoom, Judge. I'm not sure if he's in the waiting room possibly.
Court finds. Are you Juan Ortegon?
Yes, sir.
Welcome to court, Mr. Ortegon. The court marks you present. You're participating by video conference. As you can see from your device, your lawyer is present in person. Jasmine Rodriguez, are you present? Court finds respondent Rodriguez not present in person, not present by video conference. Mr. Arce, what is the announcement?
Your Honor, I've been in contact with Ms. Rodriguez, Judge. In fact, I just spoke to her this week in reference to her coming by the office and signing a waiver on this matter, Judge. We did file an unopposed petition to terminate parent-child relationship, Judge, because of the fact that I did speak to her and she's unopposed. She's explained to me, Judge, that she stepfather wants to adopt the child. So that's what we had been speaking to her about, Judge. Hopefully her filing an intervention and getting that done so we can try to get everything done at the same time, Judge, determination and adoption. So we're just asking for some time on this matter.
Sure. I think you know the answer to this because I think they have a very consistent position. But Mr. Alcantar, what is the Attorney General's office position at this point?
At this point, Your Honor, we'd have no objection for more time. We'd also like to file a motion in firm arrears in case the termination is granted.
And Judge, I know that the position is usually termination on as far as the Attorney General's office is concerned, Judge, and that's why we wanted to see if we could do the adoption. That way they wouldn't have any hiccups and we could get it all squared away.
As long as you know that that is the default position of the Attorney General's office, there will be no surprise if and when the AG's office makes that objection to the termination without an adoption, but the court will do whatever's in the best interest. Well taken. All right. Give us another sitting on the petition to terminate, Ms. Flores.
Yes, sir. How much time?
Give us
we can have it 45 days, Judge.
yeah, I was going to say 45 to 60, Ms. Flores.
August the 20th at 9 a.m.
Any objection to that date, Mr. Arce?
No, Your Honor.
Mr. Alcantar? Do
No, Your Honor.
you have any questions for the court, Mr. Ortegon?
No, sir.
All right. I wish you, Ms. Rodriguez, and the child in this case very well. Have a good day.
Thank you.
Any other cases for Mr. Arce?
That is all for Mr. Arce.
Good to see you, counsel.
Thank you, Judge.
Have a great
I'll
day.
have my back to you.
Yes, sir.
Next case is Attorney Daniel Walter, page 2, number 4.
Bernardo Karim Trad versus Noemi Trad, cause number 2021 FLA 1036C3. Court marks Mr. Walter present in person, Mrs. Cotto present by video conference. Good afternoon to both.
Good afternoon, Judge. Madeline Escoto for Ms. Galliano now, Judge.
I'm sorry, for Ms.
Galliano now. Her last Galliano.
All right. Speaking to the microphone and to the court, are you Bernardo Trad?
I am, Your Honor.
Welcome to court, Mr. Trad. The court marks you present in person. The person to your left is your lawyer. Noemi Galliano, are you present?
Judge, I released her. She was here since 2, but we reached an agreement, so we'll announce that momentarily.
Go ahead.
Judge, again, Madeline Escoto for Noemi Galliano. We filed a Rule 11 agreement with all of the terms for purposes of temporary orders. We're asking that the court sign the same. In addition to that, Judge, after conferring with Mr. Walters, we think it is appropriate that the court grant my motion for the guardian ad litem. And we have agreed to appoint Elisamar Soto with the court's permission. We signed an agreed order appointing Ms. Soto, and that has also been filed with the court, and we're asking that you approve it.
Mr. Walter?
No objection, Your Honor. That's correct. Hard at work.
I just want court staff to confirm that that was audible. Did you hear that, Mrs. Cotto?
I heard no objection, Your Honor, but
I think he said no objection, but
No objection. Yes.
All right, the court has received, reviewed, and considered the Rule 11 agreement. It is granted. It is signed. The court finds that that is in the best interest of the child and children. I have signed the order, the agreed to order appointing Ms. Elisa Mar Soto. We'll come back for final hearing on July the 30th at 2. The only thing that,
I'm sorry, what time, Judge?
July the 30th at 2?
Yeah, I should be back, Judge.
All right.
Yeah, I have a vacation. It finishes, I think, July 28th, so I should be fine. Okay.
I see that. The only other thing that was pending before the court, and you don't have to agree on this, we'll just leave it pending for the future. I just need to put on the record that it's not being moved on, is child custody evaluation request.
That was mine, Judge. Mr. Walters and I believe that hopefully with the assistance of the ad litem, that should be sufficient. And then if it isn't, then we'll come back and I will submit a fiat for my motion.
As a matter of practice, I think that would be in the interest of judicial economy and probably the finances for one or both parties. Well taken, and you're welcome to present that in the future as necessary. All right, Mr. Drad, do you have any questions for the court?
No, Your Honor, thank you.
I wish both you and Ms. Galeano well. Have a good day.
Thank you, Judge.
Oh, I'm sorry. Wait. I've signed off the agreement, the Rule 11. Those are the temporary orders that are due in final form to the court. Honor before.
June the 29th at noon by submission.
All right. Good to see you all again.
Thank you. May I be
Thank you,
excused, Your Honor?
Judge.
Yes.
Thank you.
Mrs. Cotto's further online. Next attorney is Attorney Jonathan Garcia Davalos, page 7, number 18.
Janelle Paredes versus Edgar Martinez, cause number 2026 FLA 871C3. Good afternoon, Mr. Garcia Davalos.
Good afternoon, Your Honor.
Court martial present in person. Mr. Chu, are you present?
Good afternoon, Judge. Nathan Chu present for Ms. Paredes. She's logged in at my office, Your Honor.
Good afternoon, Mr. Chu. Good to see you as well. Court martial present by video conference. Are you Edgar Martinez?
Yes, sir.
Welcome to court, Mr. Martinez. Court martial present in person. The person to your right is your lawyer. Speaking to your device and tell the court, are you Janelle Paredes?
Yes.
Welcome to court, the court martial present by video conference from the office of your lawyer. Mr. Garcia Davalos, Mr. Chu, what is the announcement?
Your Honor, I just got retained, Your Honor. I filed a motion for continuance on both the temporary orders and the temporary restraining order. I believe that we should be able to resolve most of the issues before we have the hearing. And so I'll be asking if I can get a 2-week, or I don't know what the TRO can be extended to.
Thoughts, comments, or response, Mr. Chu?
We have no objection, Judge.
This is counsel for appearance by policy of the court. The request is well taken. This TRO temporary orders are scheduled for
June 30th at 2 p.m.
Any objection, Mr. Garcia Davalos?
No, Your Honor, and I did file a proposed order, Your Honor, in my motion.
I'm writing in right now. Any objection to that date, Mr. Chu?
No objection, Judge. That's June 30th at 8:30?
At 2:30. Excuse me, at 2.
At 2, okay, great. Thank you, Judge.
All right,
you.
Mr. Paredes, excuse me. Ms. Paredes, Mr. Martinez, I wish you both well. Have a good day.
Thank you, Your Honor.
That is all for both attorneys.
Good to see you, Mr. Garcia Davalos. Good to see you, Mr. Chu.
Good to see you, Judge. Bye-bye.
Next attorney, Javier Montemayor, page 7, number 20.
Caroline Martinez versus Roberto Ramos Jr., cause number 2026 FLC 812C3. Good afternoon, Mr. Montemayor.
Good afternoon, Your Honor.
Court martial present in person. Mr. Garcia, are you still logged in?
I'm here, Your Honor.
Court martial present, participating by video conference. Speaking to the microphone and tell the court, are you Caroline Martinez?
Yes, sir.
Welcome to court, Ms. Martinez. Court martial present in person. As you can see from that device, your lawyer is present and participating by video conference. Roberto Ramos Jr., are you present? Court finds that he is in the waiting room. Court is admitting that device now. Mr. Ramos, the court has called your case. You're now present, or at least a device is logged in with your name. I'm asking that you start your device and you turn on your video. Excuse me, unmute your device and start your video, Mr. Ramos. Court is making that request electronically now. Court is being notified that he will start the video later. I don't think so. Mr. Ramos, start your video.
Hello, how's it going?
Are you Roberto Ramos?
Correct, yes, Your Honor.
Welcome to court, Mr. Ramos. The court marks you present. You're participating by video conference, as you can see from your device. Your lawyer is present in person. Mr. Montemayor, Mr. Garcia.
So, Your Honor, we've conferred, and this is a recent, I guess, separation of the parties. They have 3 children, 7, I want to say, one's going to be 6, and the other one is 7, 5, and 3. And so we've reached an agreement for temporary orders, Your Honor. And so the temporary orders, from what I understand, are.
Give me 1 second. He was unspotlighted, which means staff believes that he is driving. Mr. Ramos, are you driving?
Yeah, I'm about to pull over right now. There we go.
No, you're in the waiting room now. You're excused. All right. Mr. Montemayor, go ahead.
So temporarily, Your Honor, the parties are to be appointed joint managing conservators with all rights, duties, and obligations. The petitioner will establish the primary residency of the 3 children. The standard visitation will probably be included for both within 100 miles and in excess of 100 miles. There is what I'm hearing is that the petitioner has already established a residence out of Webb County. And so we will be asking for confirmation and verification of where she will be residing, what the transition will look like for those 3 children. We'd like addresses, we'd like schools that she plans to, and all the accommodations, all the who, what, when, and where, and we'll leave that for the final hearing. The current pickup and drop off of the children will take place in Cotulla, Texas at the Taco Palenque. This will be Friday at 6, Sundays at 6 on the 1st, 3rd, and 5th weekends of every month. From Friday at 6 to Sunday at 6 on the 1st, 3rd, and 5th weekends of every month. She will drive down from San Antonio, and Mr. Ramos will drive from Laredo to Cotulla to exchange the visits. The visits will start this weekend, Friday at 6 to Sunday 8 o'clock because of the Father's Day period. We are going to be requesting our 30 days in July this year. We will be requesting the FaceTime communication with the children from 6:30 to 7 o'clock on Monday, Wednesdays, and Fridays. We will be requesting that the parties communicate through the app close application, that they download it and that they communicate there. Child support will be based on the Texas Family Code guidelines, based on Mr. Ramos's income. And I'm not sure, I'd like to verify with Mr. Garcia if his client has insurance or not. If not, we'll verify to my client's employer.
Mr. Garcia.
That's correct, Your Honor. And I think for the daily, or I think for the telephonic or video conferencing, we could be for both, for the party not in possession, to have telephonic or video conferencing.
Any objection?
No.
It's good for one, it's good for both. So ordered. As to Mr. Montemayor's question, Mr. Garcia, does your client have the children on health insurance?
I haven't asked her, Your Honor. I apologize.
Ms. Martinez, are your children insured medically?
They're on Medicaid.
Medicaid. All right.
So we ask that continue temporarily, and we'll make the appropriate arrangements through the on the orders, and we will advise the attorney general.
Understood, and we'll take. And anything to add or put on the record, Mr. Garcia?
No, Your Honor.
This is the agreement of the parties, Mr. Garcia?
Yes, Your Honor.
Court has heard confirmation from both lawyers that this is the party. The court hereby adopts and approves that agreement, finds that it is in the children's best interest. These are the temporary orders that are due to the court on or before
June 29 at noon by submission.
Do you have any questions for the court, Ms. Martinez?
Oh, yeah.
Ms. Martinez, I wish you, Mr. Ramos, and your 3 children all the best. Ms. Flores
Final hearing,
is on
August 11th at 2 p.m.
Any objection to that date, Mr. Montemayor?
Not at this time.
Any objection to that date, Mr. Garcia?
At 9 p.m.
No, Your Honor.
August 11th at 2 p.m.
I look forward to calling this case then. Any other cases for Mr. Montemayor?
That is all for Mr. Montemayor.
Good to see you, counsel. Have a good day.
Next case, Attorney Francisco Tamés, page 5, number 13.
Rebecca Isabel Cruz versus Humberto Magallanes, cause number 2025 FLE 1326C3. Court marks Mr. Tamés present in person, Ms. Melissa Salania present by video conference, Mr. Rodolfo Santos Jr. present by video conference. Rebecca Cruz, Humberto Magallanes, any parties present?
Yes, I'm here.
My client is present. He's a Spanish speaker. He needs a translator.
Oh, I see. Give me 1 second. Are you Rebecca Cruz?
¿Es usted Rebecca Cruz?
I am, Your Honor.
Welcome to court. The court marks you present by video conference. Ms. Cruz, who is the person on your left?
My husband,
And what is his name?
Roberto Von Ziegler.
I'm sorry, Roberto.
Von Ziegler, Your Honor.
Von Ziegler.
Spell that for me, please.
Sure. It's V as in Victor, O-N, then it's Z as in zebra, I-E-G-L-E-R.
Thank you, Mr. Von Ziegler. The court marks you present, participating by video conference from the device of Ms. Cruz. We'll begin Spanish language interpretation now. Are you Humberto Magallanes?
¿Es usted Humberto Magallanes?
Sí, yo soy.
Yes, I am.
Welcome to court. The court marks you present by video conference.
Bienvenido al juzgado. El juzgado lo marca presente por medio de videoconferencia.
As you can see from your device, your lawyer is present also by video conference.
Como puede ver por su aparato, su abogado también está presente por medio de videoconferencia.
This is being translated, so one sentence at a time. Go ahead, counsel.
Your Honor, this is a termination proceeding involving an 8-year-old who's been pretty much raised by Mr. Von Ziegler. We are seeking termination in this matter for the respondent's failure to support the child within the 6 months prior to the filing of this lawsuit and within his ability for the year prior to the filing of this lawsuit as well.
Translation, please.
Esta es una audiencia por una terminación de derechos de un menor de 8 años. La terminación de derechos se está solicitando ya que el padre no ha mantenido al menor por los últimos 6 meses antes de la solicitud de esta petición y más de 1 año.
Ms. Salania?
Yes, Your Honor. So in Ms. Cruz's petition to terminate, she also included another ground, which is voluntarily left the child alone or in the possession of another. I'm asking Mr. Santos if they are dropping that ground.
En la petición de la señora Cruz también se menciona que él voluntariamente abandonó al menor o lo dejó en el cuidado de alguien más. Le estoy preguntando al señor Santos si están retirando esa petición.
No, we are not. He's also left the child in the presence with the other parent without providing adequate support.
También dejó al menor con el otro padre sin proveer por él.
And also remained away for a period of at least 6 months.
Por un periodo de mínimo de 6 meses.
So what is the announcement, Ms. Salania?
Entonces, ¿cuál es el anuncio, señora Saldaña?
Yes, Your Honor. Mr. Santos and I briefly conferred this morning, and there is no agreement in this case, so we will need a hearing.
El señor Santos y yo hablamos en la mañana y no hay un acuerdo en este caso. Vamos a necesitar una audiencia.
Anything for the record, Mr. Tamés?
Your Honor, for clarification, so I was appointed as attorney ad litem under the court's order. I think the parties intended to write in guardian ad litem, so I needed some clarification that was the purpose of the appointment.
A mí se me puso como guardian ad litem. Estoy queriendo aclarar nomás cuál fue la posición que se me incluyó a mí.
Your Honor, our understanding was that it was guardian ad litem. My client's already gone so far as to meet with Mr. Tamés and talk to him without his present. So we thought that our understanding was that was in furtherance of his duty as guardian ad litem, and that we would be provided with some sort of report, which was also referenced earlier.
Nosotros estamos bajo la impresión de que él se le adjudicó como guardian ad litem y que él iba a proveer algún tipo de reporte para nosotros.
Your Honor, if I could finish first. I know we have a translation, and so that's why I was interrupted. I understand that that's the party's understanding. I just want to make sure that the order that was submitted by one or both counsel mistakenly put in that my appointment was as attorney ad litem. I have met with the parents. I do have a report. I have not filed it until I get clarification from the court.
Nomás quería que aclararlo porque en la orden que hizo uno de los abogados se me puso como attorney ad litem, que es abogado ad litem en vez de guardian ad litem. Sí tengo un reporte, pero primero quería una aclaración.
So let me ask you, Mr. Tames, the order that the court signed, what is that appointment for?
Déjeme le pregunto, señor Tamés, la orden que el juzgado firmó, ¿qué indicaba?
Your Honor, the order says attorney ad litem, signed February 24, 2026.
La orden decía
Attorney,
attorney ad litem, firmada febrero 24 del 2026.
Any objection to that order, Mr. Santos?
¿Alguna objeción a esa orden, señor Santos?
Your Honor, I'd have to look at the order itself, but my understanding is it was respondent's request and it was for guardian ad litem. If there's a reference to maybe attorney ad litem in title, that might be the case. But my understanding and our understanding all along in proceeding is that this has been a guardian ad litem appointment.
Mi entendimiento era que era guardian ad litem. Ese ha sido nuestro entendimiento durante todo el acuerdo. A lo mejor decía attorney ad litem, pero siempre estamos bajo el entendimiento que era guardian ad litem.
You signed it, Mr. Santos. You prepared it, Ms. Saldaña. It says attorney ad litem, and for that reason, I wrote it in again. So it says attorney ad litem in two places. Mr. Tames is correct.
El señor Tamés está correcto. Usted lo escribió y usted lo firmó, señor Santos y señora Saldaña. Dice, se indica que es attorney ad litem.
So I'm going to ask one more time. Any objection to any of this, Mr. Santos?
Le voy a preguntar una vez más, ¿alguna objeción a esto, señor Santos?
No, should he wish to serve as attorney ad litem, that's fine as well.
No, su señoría, si él quiere servir como attorney ad litem, no hay ninguna objeción.
I think his point is he doesn't have a choice. He's going to do whatever the court says, and we need to figure out what that is before proceeding.
Correct.
Creo que él no tiene ninguna otra alternativa. Él tiene que hacer lo que el juzgado le indique.
I would have to the guardian attorney ad litem. If it was our submission, then that was our error. It was a clerical error. We should have written guardian ad litem since the child is 8 years old. It was just a clerical error. It happens.
Creo que fue un error de nuestra parte si le pusimos attorney ad litem. Si ya que el menor tiene 8 años, debió haber sido guardian ad litem.
Yeah, and I would agree with that, Judge. I just wanted to clarify because the appointment says one thing, and obviously we have a child that's 8. I don't think the child met with the mom and the child. I don't think that the child has the maturity, the capacity at this point to understand the brevity of the situation.
Y creo que ese era mi entendimiento, nomás quería clarificarlo, ya que el menor tiene 8 años y no creo que tenga la capacidad de tomar en cuenta la gravedad del asunto.
Mr. Tames brings up a point. Ms. Saldaña agrees.
El señor también nos menciona el punto y la señora Saldaña está en acuerdo.
Do you have an objection or a position different from any of this on behalf of your client, Mr. Santos?
Señor Santos, ¿tiene una cuestión, un punto de vista diferente a cambio por su cliente?
I do not, Your Honor. In order to facilitate this and hopefully get this case tried and adjudicated, we want to do everything possible to get it, be as cooperative as possible. So if it's guardian ad litem that's going to be the appointment, then that's fine as well. We just want to go forward.
Para facilitar y adjudicar este caso y hacerlo lo más rápido posible, no tendríamos ningún problema con el guardian ad litem.
All right, so let me do one thing for the record before we proceed.
Déjeme hacer una cosa más para la acta antes de continuar.
I've taken the original agreed order, I've written in amended, I've put in guardian, and I've given it today's date. I'm tendering that order to the clerk for purposes of the record.
He tomado la notificación y la he corregido a que diga guardian y se le ha entregado a la secretaria del juzgado para la acta.
All right. This is a contested matter.
Este es un asunto del que vamos a estar, se va a hablar más. Sí.
All right, then this is the third contested matter the court will be hearing today.
Entonces, ese es el tercer caso que va a escuchar el juzgado.
Ms. Cruz, Mr. Magallanes, are you both in Webb County?
Señor Cruz y señor Magaña, ¿los dos están en el condado de Webb?
I am,
Yes,
Your
I'm
Honor.
here in Webb County.
Yes, I'm here in Webb County.
Any objections to you all appearing in person?
¿Alguna cuestión en que aparezcan, se presenten en persona?
No objection.
No.
No.
It appears to me we're going to have a contested hearing. It sounds like this is going to go at about 6 or 7 or 8 tonight. I think everybody should be here in person.
Vamos a estar aquí como a las 6, 7 de la noche. Creo que todos deben de estar aquí en persona.
All right, so let me call this case and I hope to see you all very soon. All right, so
Espero verlos
stand
a
by.
todos pronto.
Thank you.
Next case, Attorney Guillermo del Barrio, page 3, number 8.
Valentin Palomares versus Sandra Leticia Palomares, cause number 2025 FLB 1582C3. Court marks Mr. Del Barrio present in person, Ms. Garcia present by video conference. Good afternoon to both.
Good afternoon, Your Honor.
Good afternoon, Judge.
Valentin Palomares, Sandra Palomares, are the parties present?
I don't believe so, Your Honor. I know my client was on earlier, but after speaking with Ms. Garcia, I believe neither party were going to be present.
That's correct, Judge. My client isn't at work.
I'm sorry, I missed that. What?
My client is at work, Your Honor, at the correctional facility in Petula. She could not get out for this afternoon.
What is the announcement?
Your Honor, we are requesting a little bit more time. Myself and Ms. Garcia have been in communications and trying to work out a deal. I think she did provide me an offer over the telephone earlier today. She's going to put that in writing, Your Honor. I do believe it's a case that would probably get resolved. My client does not reside here in Laredo. He actually resides out of state. I don't recall the exact state he resides in right now, but
Maryland.
yeah, Maryland, that's correct. So I will provide that information to him and we will try to work out something. There's no minor children involved anymore. The oldest child or the youngest child already graduated just recently and I believe doing very well. The parents are in communications with regards to that. So we're just asking for a short reset, Your Honor, based on that to see if we can in fact reach an agreement. I believe really the only issue is a home. In speaking with Ms. Garcia, it does sound like the offer is reasonable. So it's maybe something that my client will take.
All right.
Just need some time to go over with him.
Anything else for the record, Ms. Garcia?
Nothing, Your Honor. That's absolutely correct. Judge, if we can please have something not sooner than the first day of July, perhaps. The parents are taking their son. He was awarded the Bill Gates scholarship fund. He's going to Arizona to receive that. And then they're going to A&M at College Station for a full scholarship. So everyone's going well together. So
Doing good, yeah.
Sounds like there's good vibes and communication. Very, very well taken. This is the third setting. So let's do a couple of things. Ms. Flores, give us 2 dates. Give us a date well after July the 1st at the party's return.
I'll be out last week of July.
Give us first setting in August.
That'll be August the 11th at 2 p.m.
Give us a dismissal setting in late August, September.
September 1st at 2 p.m.
So let's get this done on or before August the 11th.
That's right. We should have hopefully an agreement. And if there's not, it'd probably be something minor that the court can resolve for us.
I certainly, I think I foresee that happening in this case. Very good. Any other cases for Mr. Del Barrio or Ms. Garcia?
I don't believe it.
That is all from Mr. Del Barrio.
Good to see you, counsel.
Thank you, Judge.
Have a great day.
Have a great day.
thank you, Judge. Have a good day.
Next case, Your Honor, Attorney Madeline Lopez Escoto, page 4, number 10.
Rogelio Martinez Jr. versus Erika Lynn Martinez, cause number 2025 FLB 1790C3. Court marks Mrs. Scotto.
Yes, Judge, I'm
by
present.
video conference. Mr. Lozano, Sergio Lozano, are you present? Court finds Mr. Lozano not present. Rogelio Martinez, Erika Martinez, are you present? Court finds parties are not present. Mrs. Scotto, go ahead.
Judge, we have been trying to diligently finalize this case, but we have hit a major roadblock. There was a motion for continuance filed, and And Mr. Lozano and I have conferred probably incessantly for the last days and even the weekend. We're asking that the court, if the court can provide us an informal settlement conference date, it should not last more than an hour and a half. Time is of the essence as the marital home has been foreclosed.
But none of this is evidence, but do you know if there's any equity in the home, or was any equity?
There was, Judge.
Huh? And are you asking for a settlement conference with Associate Judge Martinez or the court?
I think the court, Judge, I think that it's my experience, at least with something as delicate as this, Judge, I think that that we need your assistance.
Ms. Flores, how many cases on July 28th and 30th? Which one has less?
July, July, we have less July the 30th.
And Judge, is Judge Letty available anytime sooner than the court, Judge?
Let's find out. Without knowing anything else, it looks like by a week. It looks like July 20th and 21st. Or I can do it on the 30th.
I'm available on the 20th, Judge.
All right.
Or the 21st.
Let's do Monday.
At 1:30, Judge?
Yes. So into her calendar is 2025 FLB 1790C3. All right, it is on her calendar. And now let's place this back on mine. Give us a setting after July the 20th, Ms. Flores.
July the 28th at 2 p.m.
All right, we'll take all counts.
Just because, Judge, I don't want to, that's the day before I travel back. Is it possible, do you have another date right after that, Judge?
You have a setting already on the 30th, right?
The 30th, yes, we can do the 30th, Judge.
All right, July the 30th at 2 p.m. Just make a note, Ms. Flores, let's set, if Mrs. Cotto has anything else, just avoid anything before the 30th.
Thank you, Judge, appreciate it.
Yes, ma'am, any other cases?
I'll text Mr. Lozano, Judge, with the dates.
Sounds great. Any other cases for Mrs. Cotto?
Yes, Your Honor, page 6, number 16.
Ricardo Gallardo Soto versus Clarissa Yvette Gallardo, cause number 2026 FLA 401C3. Court marks Mrs. Cotto present and participating by video conference. Mr. Eduardo Romero also present and participating by video conference. Ricardo Soto, Clarissa Gallardo. Any parties present? Finds no parties present. Counsel, what is the announcement?
Madeline Escoto for Mr. Gallardo, Judge. We filed an agreed motion for continuance. We were supposed to go to mediation with Judge Hale. However, the parties had informed us that they were attempting to reconcile. And then at least I was informed that the attempts did not proceed as they thought. And so Mr. Romero and I conferred today, and we'll go ahead and reschedule the mediation. So maybe if we can have a date in 30 days.
Mr. Romero?
That's correct, Your Honor.
All right, well taken. Well, this is a final pretrial. You're set for trial on August the 11th. Do you want to keep that setting?
That's fine with me, Judge.
Yes, Your Honor, as the final pretrial, correct?
Well, as the trial on merits,
As the
we can
trial?
change it to a final pretrial if you want, but ostensibly that's for discovery motions that should have been heard before the mediation.
I think my preference would be to keep it as a pretrial, Your Honor, instead of the trial.
Any objections, Mrs. Cotto?
No objection, Judge.
Final pretrial hearing is scheduled for August the 11th at 2 p.m. Final hearing will be on
How much time after that, Your Honor?
late September.
September the 29th at 2 p.m.
Any objections, Mr. Romero?
No, Your Honor.
Objections, Mrs. Cotto?
No, Judge.
All right, so ordered. Good luck to everyone at mediation.
Thank you, Judge, and that's all I have. May I be
Any other-
excused?
That is all for both attorneys.
Good to see you both. Have a great
Good
day.
to see you, Judge. Stay
Thank you.
safe.
Next case, Attorney Juan Jose Garcia, page 5, number 12.
Luis Antonio Estemera versus Hilda Rivas, cause number 2025 FLC 1065C3. Court marks Mr. Garcia present by video conference. Mr. Del Rio, are you present?
I am, Your Honor.
Mr. Del Rio, welcome to court. The court marks you by video conference as well. Luis Estemera, Hilda Rivas. Any parties present?
Yes, I'm present. I'm just trying to get my camera going here.
That's Miss Rivas, Your Honor.
And I think my client is also present, Your Honor, but he has his camera off. But we have an agreement, Your Honor.
Ms. Rivas, for you to be before the court, you need to turn on your video, start your audio. Same thing for you, Mr. Luis Antonio Estemera. Court is making that request electronically to both parties now.
I don't know if my camera is working.
Are you Luis Estemera?
Yes, Your Honor.
Welcome to court. The court marks you present by video conference. Ms. Rivas, I'll mark your device present, but you're not properly before the court unless you can turn on your video.
Okay. Okay,
Thank
yes,
you.
I'm working on it. I'm not sure. Save drink.
As Ms. Rivas does that, Mr. Garcia, Mr. Del Rio, what is the announcement?
Your Honor, we've filed an executed order regarding the suit, a final order and the suit affecting a parent-child relationship, Judge. All parties have signed. The only thing was left that we wanted to put on the record was establishing Your Honor's jurisdiction over this case. My client, the respondent of this, has jurisdiction. She's resided in Texas for the 6 months, Webb County for 90 days. That includes the child as well. And so we did want to offer her testimony for purposes of records to ensure that Your Honor has jurisdiction over this case.
It looks like we're not going to be able to do that. I can't take her testimony unless she starts her video, but I think jurisdiction could be established through Mr. Estemera. Would you all like to do that? Mr. Estemera, would you raise your right hand? Do you solemnly swear or affirm that the testimony that you will give in this cause will be the truth, so help you God?
Help you. Yes, sir.
You may lower your hand. Who would like to ask Mr. Estamera some questions?
I can ask him, Your Honor.
Go ahead.
Thank you, Your Honor. Is your name Luis Estremera?
Correct.
Okay, and you signed off on the order that we presented to the court today?
Yes.
Okay, and Ms. Rivas has been living in Texas for more than 6 months,
Yes.
and she's been living in this county for also for more than 6 months, right?
Yes.
And the child currently lives here in Webb County,
Yes.
and the child's also been living here more than 6 months.
Yes.
Okay, and currently you live in New York, is that correct?
Yes.
Okay, no further questions, Your Honor.
Your client is now available. Ms. Rivas, I'm going to ask that you unmute your device.
Right. Yes, sir, it's done.
It's done, but your camera is off. There you go.
One more time. Unmute your device, please.
Okay, there, I got it.
Would you raise your right hand, please?
Yes, sir. Right
Do
hand.
you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
You may lower your hand. Mr. Del Rio, go ahead.
Thank you, Your Honor. Ms. Rivas, it's true that you've been residing in state of Texas for 6 months in Webb County for the last 90 days, correct?
Yes, sir.
And your child, who is the subject of this suit, has also been residing with you during all that time?
Yes, sir.
And you've read, signed off, and agreed to the final order that's been filed with this court?
Yes, sir.
You believe that order is in the best interest of your child?
Yes, sir.
I have no further questions, Your Honor.
Any other questions for any parties, Mr. Garcia?
Just one more for my question, for my client, Your Honor.
Yes, sir, go ahead.
Thank you, Your Honor. And you also, and there's nothing that was left out of the agreement, is that right, Mr. Estremera?
Yes.
That's all the question I have, Your Honor.
Any questions for any parties, Mr. Del Rio?
No, Your Honor.
Ms. Rivas, Mr. Estamera, in this case, cause number 2025 FLC 1065C3, the court at this time finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider this request. With regard to your child, MAE, the court finds that you have an agreement. The court has received, reviewed, and considered that written agreement. It has been testified to by both parties and told to the court by the lawyers, and it is signed by both parties and both counsel. The court hereby adopts and approves the agreement in full and finds that it is, in fact, in your son's best interest. The court has signed off on that agreement, and these are final orders. Anything else for the record, Mr. Garcia?
No, Your Honor.
Anything else for the record, Mr. Del Rio?
No, Your Honor.
Mr. Estamera, that concludes your case. Do you have any questions for the court?
No, Your Honor.
Any questions, Mr. Rios?
No, sir.
I wish you both well. More importantly, I wish your son all the best. Have a great day.
Thank you.
Next case, Attorney Marcel Knotson.
Any other cases for Mr. Garcia or Mr. Del Rio?
That is all, Your Honor.
Good to see you both. Have a great one.
I have another one on recall, Your Honor, but I'll wait.
Correct.
Thank you, Judge.
Next case, page 1, number 2.
This is Alma Alicia Salas Vasquez versus Anthony Bouvier, cause number 2018 FLI 1884C3. Court marks Ms. Saldana present in person, Mr. Knotson present by video conference, Mr. Elias Alcantar present by video conference. Alma Alicia Salas Vasquez, are you present?
Sí.
Yes.
Court marks you present by video conference from the office of your lawyer.
El juzgado la marca presente por medio de conferencias de la oficina de su abogado.
Speak into the microphone and tell the court, are you Anthony Bouvier?
Yes, I am, sir.
Díganos si usted es Anthony Bouvier. Sí, sí.
Court marks you present in person. As you can see from this screen, your lawyer is present by video conference.
Como puede ver por la pantalla, su abogado está presente por medio de videoconferencia.
Counsel, this is a final pretrial. What is the announcement?
There's nothing to pre-try, Your Honor.
Este es un juicio antes del juicio final. ¿Hay algo que tratar? No, no hay nada que tratar.
Mr. Knotson?
That's correct.
Es correcto.
All right, and this case moves on to a final hearing
Este
on
caso se mueve al juicio final,
June the 18th at 9 a.m.
junio 18 a las 9 de la mañana.
Court will interview this child at 11.
El juzgado va a entrevistar al niño a las 11.
Anything, oh, Mr. Alcantara, anything for the record?
No, Your Honor, thank you.
No, su señoría.
Anything else, Ms. Alanya?
Not at this time, Your Honor.
¿Algo más, señora Saldaña? No, su señoría.
Mr. Knudsen?
Señor Knudsen?
No, Your Honor, I just would like to, if we have anything that we need to e-file beforehand, we get that done by tomorrow.
Nomás si necesitamos introducir algunos documentos, e-file, lo hacemos el día.
Tomorrow morning.
Well, you're scheduled for hearing on the 18th at 9, so just upload any evidence before tomorrow at 9.
Tienen el juicio el día 18, nomás introduzca cualquier documentación antes de mañana a las 9 de la mañana.
If I may, Your Honor, my office is having some difficulty with the scanning, so we're gonna have to go to a store to scan. If we could have till at least noon Wednesday.
Mi oficina está batallando con el sistema, si no sé si tendríamos que ir a una tienda a hacerlo, no sé si nos podría dar hasta el día 12, el día miércoles.
I would request the same, Judge. I don't think hopefully there's not going to be voluminous documents. I think we already have exchanged most of what we got.
No, yo solicitaría lo mismo, señora. No creo que hay volúmenes muy grandes de documentos. Creo que ya hemos intercambiado todo lo que tenemos.
It's just a few photos. Yeah, I think the bulk of it we've already entered into case line.
Creo que solamente son un par de fotos. Creo que la parte más extensiva ya se introdujo al case line.
Court will approve the request to extend the deadline till noon tomorrow for both equally and mutually.
El juzgado va a aceptar la petición, va a extender la hora hasta las 12 para las dos partes.
Mr. Knudsen?
And are we the only ones set at 9, or how much time will Your Honor give us each side to present the case, just so we're prepared?
¿Somos el único caso que está a las 9 o cuánto tiempo nos va a dar su señoría para tratar el caso?
It's impossible to know how much time, because if nobody has a contested hearing, then you can have 2-3 hours. Ms. Flores, how many cases on the 18th?
Es casi imposible saber porque si no hay ningún caso a tratar después, a lo mejor le podría dar 2-3 horas. Señora Flores, ¿cuántos casos tenemos ese día?
22, Your Honor.
22 casos.
I'd plan for about an hour total between the two parties.
Yo pensaría una hora entre las dos partes.
Anything else from any person?
¿Algo más?
All right, Ms. Salas Vasquez, Mr. Bouvier, I wish you both well. We'll see you on Thursday.
Señora Salas Vázquez, señor Bouvier, les deseo lo mejor. Los veo el jueves.
Thank you.
Thank you.
Excused? I think that's all I have, Judge.
Yes, have a good day. Good to see you.
Your Honor. Bye-bye.
Your Honor, we just have the recall cases that are pending.
Page 2, case 3, Bradley Johnson, Sandra Johnson, cause number 2021 FLA 100C3. The court received, reviewed, and considered a Rule 11 agreement. It is well taken. This case is rescheduled for July 28th at 2 p.m. with the interview with the child at 1 p.m. All right, we have 2 or 3 contested matters.
3, Your Honor.
Which one is number 2?
2 is
I
the one on
lost that
page
place.
1, number 1.
Found it. All right. Proceed to the first contested matter. Page 3, case 6. Rocio del Carmen Leal, Joseph David Leal, cause number 2025 FLA 1654C3. Court marks Mr. Figueroa present in person, Mr. Juan Garcia present by video conference, Mr. Joseph David Leal present in person, Ms. Rocio del Carmen Leal present in person. She needs or requires Spanish language interpretation. Mr. Elias Alcantar is present and participating by video conference. Give me a second as I spotlight all the necessary parties. All right, we'll begin Spanish language interpretation now. Mr. Figueroa, Mr. Garcia.
Yes, Your Honor, I believe the respondents are asking for overnight visitation for a child younger than 3 years of age. I'd like to present briefly some testimony. We'd like both parties to be sworn.
Is that the only contested issue, Mr. Figueroa?
Also, the issue of child support arrears from the date of separation, which is 2.5 months.
I think also the sale of the house, Your Honor.
All right, Ms. Carmen Leal, Mr. David Leal, I'm gonna ask that you both raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
Yes, Your Honor.
You may lower your hands. You are the petitioner, Mr. Figueroa. You may commence.
Yes, Your Honor, I'd like to call the respondent. Testify, Your Honor.
Mr. Leal, you're being called to testify. You can remain there since everybody's on the lower bench. Mr. Figueroa, when you're ready, go ahead.
Please state your name for the record.
Joseph David Leal.
And you're employed with Geo, is that correct?
Yes, sir, that's correct.
You stated a while ago you were working a lot of overtime.
Mandatory overtime as of now, but now they hired new people, so the overtime will slow down drastic.
So how many hours do you work a week?
It's not something that I could predict because it's not consistent.
Yeah, more or less, how much do you work a week?
I cannot give you a number because it's not consistent, but I do put maybe an average of about 100 hours or perhaps. Oh, a week? I'm not sure, sir, to be honest.
Well, you see your paycheck every week.
I do have my check stubs here available.
Hold on, sir, let me finish the question. Do you work more than 40 hours a week?
Yes, I do work 40.
Yes or no?
Yes, sir.
And how many hours do you work overtime on an average?
I cannot average because it's not consistent, how I said.
Do you understand what average means?
Yes, there's no average number that I could give you.
I'm not asking you that, sir. Average is the dividing the amount of work you do by weeks and come out with a number that represents more or less what you make in a week. Would you understand that?
Yes, I understand that, sir, but I cannot give you a number from top of my head.
Okay, so how many hours did you work last week?
I cannot recall, but I do have the people here in front of me.
And you understand the child? Have you ever changed his diaper?
Yes, sir, I have changed his diapers.
Isn't it correct that in the last 6 months, you've seen him 5 or 6 times? Yes or no?
I try to see him as much as I can.
Is it a yes or no?
Can you give me that question again, please?
Is it correct that in the last 5 to 6 months, you've only seen the child 5 or 6 times?
I try my best because work, they mandate.
Sustained. You need to answer the questions.
I can't recall how many, but I do try to see him as much as I can.
When is the last time you saw your son?
This past weekend.
And how many times have you seen him this month?
I missed the last one due to my work of being mandated.
Objection on
out of my control.
Sustained.
You need to answer my question, sir. How many times have you seen him in the last month?
This last month, I only seen him once.
Okay.
Because I had a polygraph examination I had to take out of town.
Objection, unresponsive.
Overruled.
Who do you live with, sir?
I currently had to go back with my father.
And who else lives here?
Just my father and I.
Your father's a convicted felon?
No, sir.
He's been arrested, correct?
I can't recall.
Do you know what time does the child wake up?
Yes, like around 7 in the morning, I believe.
Have you seen him wake up?
No, but I was told by Rocio through the app.
Objection, hearsay. Do you know what he eats?
Yes, they serve him food, homemade food, and sometimes he still drinks from his bottle.
What kind of food does he eat?
He likes to be served homemade food.
Have you seen him eat? Yes or no?
But during what time period? Because you're not explaining it. During what time have I seen him eat?
The whole day, sir. Have you seen him eat?
Yes, sir. I have seen him eat.
Have you fed him?
I have fed him myself. Yes, sir.
You fed him a pizza, correct?
Yes, because I was told that he could eat slices of pizza.
Okay, he's 18 months.
But I gave him the milk that was provided.
Sir, you need to answer my question.
I gave him milk that was provided in his backpack.
Objection, unresponsive.
Sustained. You need to answer
the witness, Your Honor, to respond The request instead of being evasive.
Mr. Leal,
Yes, Your Honor.
you really need to answer the questions that are being asked.
So it's a
if-
yes or no? Okay,
to listen to the question.
Yes,
You
sir.
don't need to rush. I know this is a new experience and it's not very comfortable, but don't be quick to answer. Just listen to the question. If the question is improper, your lawyer will say objection. If he does, you can pause. If he doesn't object, then you should answer.
yes, Your Honor.
At the end of these questions, Mr. Garcia will come back and he'll ask you some questions and he'll rehabilitate any damage that he thinks that Mr. Figueroa might have done. He may not, or he may do, I don't know, but your lawyer will then get a chance to ask you some follow-up questions. Mr. Figueroa, when you're ready.
Yes, Your Honor, thank you. What type of formula does he drink?
The type of formula that he drinks is usually she provides it in her backpack, so I just use whatever provided from there.
So you don't know?
Well, I could easily ask, I could easily ask and search on Google or ChatGPT to find that answer.
Objection, Your Honor, unresponsive.
Overruled, he answered.
What kind of formula does he drink? He doesn't know.
Was I use the one that's provided in the backpack, so I'm sure that's the one that he drinks.
What hours does he take a nap?
I know that he goes to bed at 9, but I'm not too sure what time he takes a nap, but I'm sure it would be throughout the middle of the day.
You assume?
Yes, because
Thank you, sir.
because I don't have he's with her currently, so
Have you ever given him a bath?
yes, I have.
When is the last time you gave him a bath?
When he used to before they
When
moved,
is the last time you gave him a month, a week, 3
before
months ago?
before they moved out. I cannot give him a bath when we're having visitation at a public setting. How am I supposed to give him a bath during
You
during-
separated,
since that's the temporary order? I have to abide by the temporary order.
unresponsive to the question.
Well, Mr. Figueroa, Mr. Leal, you're both talking over each other, right? I was very clear that just
Yes, sir. Sorry.
pause.
Try my best.
You're talking over me now. Just pause. Just listen to the question. Let him finish the question. Whenever you're ready, Mr. Figueroa, you may proceed.
Thank you. Have you ever given him a bath in his 18 months of life?
Yes, Your Honor, I have.
What shampoo or soap does he use?
Usually she would buy it, so I knew which it was the baby shampoo. And it's common sense.
Do you have a bed for the child? If he lives with you or visits with you?
No, but I could easily buy one and provide anything that he needs, because I'm trying to be the best parent that I could be.
What type of diapers does he use?
Well, I know he's growing rapidly, so I use what's provided in the backpack. It's hard for me to, to figure that out unless there's communication from the mother, from her part.
You know what medicines he takes?
Well, whatever is prescribed from the doctor, which is something that's recommended because I'm not a medical expert.
Do you know he has any medical condition?
What I was advised by her through the app close, she stated that he had trouble speaking.
Have you gone to the doctor with him to see what he needs?
No, I wish I could. I want to be there present as much as I can, but of my work, how I mentioned earlier, it's hard for me to do all that.
Do you know that the child needs a special diet?
No, I was never aware of that.
Isn't it true that the police were called to your home because you assaulted your wife?
That's the accusations that she was putting on me, but I was the one that called the police and made the report.
And they told you to leave the house, correct?
I decided
Yes or no?
to speak. I'm trying to answer your question. I tried.
Did they tell you to leave the house?
No,
Yes
I,
or
I,
no?
I told them that I was gonna leave so it won't escalate. That's those agreement.
You left the house.
I decided to leave, yeah.
Isn't it true every time you visit the child, he returns with soiled or wet diapers? You never change them, do you?
That's not true. I did change him. I do change him, and I did change him the last time we went to Chuck E. Cheese. And my mother was present there as well.
With all the overtime you're working, what time would you have to visit the child overnight on the first, third, and fifth weekend? How would you do that?
I'm sorry, could you rephrase the question?
How would you're working a lot of overtime, you work at a detention center. How would you squeeze that, divide your work and taking care of the child starting Friday at 6, ending Sunday at 6, first, third, and fifth weekends of the month? How would you do that?
I try my best to go in early if it's possible, because the overtime is under not in my control. But if there's space to go in early to not get mandated, I do try my best to do that. And if I wouldn't make it, I would have my mom, my mother, be there from pick up my child.
But you live with your father.
Yes, sir. But I have a good relationship with my mother and father, so that doesn't there's no problem between that.
Isn't it correct that when the police were called for this incident, that assault happened, your wife was pregnant?
Yes, that's why I made the report. I called because of those accusations, because I never assaulted her. I don't know why she said I assaulted her, that's why when the investigator checked that case, it was immediately dismissed.
When was the last time you made a full payment on your home?
It was actually the day before yesterday, but I made a partial payment of $400 since we had to go into forbearance, since I'm suffering financially as of now with a mortgage payment, because I have that burden on myself, which the mortgage is under both of our names. So
if you understand the question, when is the last time you made a full payment?
Full payment? I haven't made a full payment. I'm trying to make a full.
How many months, sir?
Because I was trying to catch up on child support. Because on your end, you guys were saying you were going to file some sort of motion. I'm not sure how that works for me because of the child support, but it's hard to keep up with everything, on my plate and be paying my lawyer and everything all at once.
So how many months have you not made the payment, full payment?
I believe maybe it was about, if I'm not wrong, if I could calculate a full payment, maybe like a good 3 months.
Isn't it correct that you owe $5,500 right now on your home?
It should be
Yes or no?
$400 short since I made a partial payment, so maybe about 4,800, 900 estimated.
You're in agreement that the house be set for sale by agreement, is that true?
Yes, but my biggest concern is the storage that we purchased during our marriage, which is 12 by 20. It was supposed to be an investment property. That we still owe about $9,000. It's under, we took it out during our marriage together, but of course it's under my name. But I want to see what's going to be the situation on that as well, because I cannot remove that storage anymore. So we're hoping if we could sell it with the property, but if it doesn't sell, how is that going to be divided?
And you're not willing, let me rephrase that. You were separated since November of 2025, is that correct?
Yes, sir, that's correct.
And you provided not a single dollar in support for the end of November, December, and January.
That's not true. I've been trying to provide support as best as I can. But for her end, there was no communication. If there's no lack of communication, I cannot force anything because, I did my part. From her part, there was no communication at all. Luckily, she came through around December. I was able to go to her parents' house, step into their house. I was able to take him the stuff that he need, food, diapers, toys. But other than that, after that, they didn't, there was some sort of no more communication after that.
You never provided any support for those months.
No, I did try to provide support
But try is not giving.
because there's no communication from her end. You know, there was no response or anything. She just kept saying, we're gonna wait till we settle this in court. So what am I supposed to do if she's telling me that?
Do you understand that your son needs money to eat and pay bills?
Of course, I'm trying to be the best father that I could be since day one. That's all I've been trying to do, you know, as a husband and as a father. That's all I've been trying to do since day one.
You could have mailed the check to her, couldn't you?
How am I supposed to do that if her and her parents they were selling their property during our divorce marriage. They were selling the property. I'm not sure if, if there's lack of communication. So what am I supposed to do from that moment of time?
So you're not willing to pay what you are behind in providing support to your wife, which is $2,362. Is that correct? You don't want to pay her, period.
No, because there's other circumstances that come into play.
That's all I have. That's what we do.
Cross-examination, Mr. Garcia.
Thank you, Your Honor. Mr. Leal, how many months are you asking so that you can sell the house together with the shed?
All I need is to give it a try, at least 3 months. That's all I'm asking. Nothing too long or too short. I just wanted to give it a try.
But I think you were asking for 6 months before?
If it's 6 months, I don't mind. Yeah. So whatever is reasonable, to try to attempt to sell the property.
Okay, and you want the house, the shed, and there's also some cameras that you also want included in the sale.
Yes, because those are things we acquired during our marriage.
Okay, and then when it comes to the child support back pay, did you pay the mortgage for the months of November, December, and January?
Yes, I did make all those payments. I was always on time. I started falling behind when the temporary order kicked in.
How much were the monthly payments?
About approximately 1,317, I believe.
And were you also paying the water and the light at the house?
Yes, and also the storage in the back, which is another additional, I believe it was another $400.
Okay, and how much was the water and the light each month from November, December, and January?
Yeah, I think it was an average of the light was about 200 and, if I'm not mistaken, 230, 40. Yeah. And the water would come out to 172, around there approximately.
Okay, and at that time, were you guys living together?
I'm sorry, during what time?
At that time, you were living together.
Objection, vague question. One time.
Mr. Leal, you can answer if you understand. If you don't understand, you should say that, and then you can ask for a clarification. But
Can I please have a clarification? Like what time?
Sustained, it is vague. Mr. Garcia, rephrase.
Yes, Your from the months of November, December, and January, you guys were living together at that home.
No, she left November. She walked out during November.
Okay. Also, when it comes to your child, you're asking that you have the first, third, and fifth weekend of every month. Is that correct?
Yes, that's correct.
And you're asking that the visits start Fridays at 6 and that they go Sundays at 6.
Yes, that's correct.
Okay. And right now, what is your current the visitation schedule that you have?
It's every first, third, and fifth Saturday of the month, from 2 to 4.
Okay. And is it supervised or unsupervised?
Right now, it's currently supervised.
Okay, and in the months from February, February, March, April, and May, let's say in May of this year, how many times did you see your son?
I believe I only missed twice. I think about 2 times, or yeah, that I could recall. 2 or 3 times due to being mandated in the last minute that something I couldn't control.
And in April, how many times did you see your son?
During April, I believe I saw him all the times. Yeah.
And in March?
March, also, I think I might have missed one during March, if I'm not mistaken. Due to
Okay,
due to my work, yeah.
and when you live together with your spouse, I mean, would you take care of your son?
Yes, I would always take care of my son. Yes, sir.
Okay, and so you're able to take care of your son during the entire weekend without supervision from the mother, right?
Yes, sir.
Objection.
Yes, sir, but the mother was always present.
Sustained, you can rephrase.
Yes, sir,
Give me
but
1 second, Mr. Garcia, go ahead.
Yes, Your Honor. So are you able to take care of your son for the weekend that you're at, or for the 3 weekends that you're asking a month without supervision from the mother?
yes, sir.
And you're also requesting, and you have not been arrested, is that correct?
No, sir, I haven't been arrested. Only back in 2000, was it? I'm sorry, back into 2000, maybe like 5 years ago prior, for DWI, but it got dismissed.
Okay. Um, and why do you believe that it's in the best interest of your son that you have visitations every first, third, and fifth weekend of the month?
I believe it's important to be present in a child's, life, especially their upbringing, at a young age. I want to be the best, father that I could be. I want to make sure, I believe family is number one to everything, their upbringing, and I just want to be present in his life as much as I can.
Okay. And have I left anything out, Mr. Leal?
No, sir.
You answered,
I have no further questions.
anything on redirect?
Oh, yeah.
Any other witnesses, Mr. Figueroa?
Yes, my client, Rocio del Carmen Leal.
Go ahead.
Please state your name.
Rocío del Carmen Leal.
And you have a son, is that correct?
Yes,
And he's 18 months old?
yes,
He's still using diapers?
yes,
And is he verbal? Can he talk, explain things?
no.
What can he say?
He says, mama and dada.
Is that all?
Yes,
Does your present husband, who see it here next to us, does he know the routines when he eats?
no,
Does he have the routine as to when he naps?
no,
Have you ever seen him change diapers when your son?
no,
Has he ever put him to sleep?
no,
Has he ever given him a bath?
no.
How many times has he seen the child since we came to court on February the 4th?
Around 6 times.
And that's been in how many months? About 4 or 5 months?
Yes,
And how many times has he canceled not to see the child?
most of the time.
Right.
Around 6 times.
6 times in a period of how many months?
5 months.
So he hasn't been very consistent in visiting the child, is that correct?
Yes,
And there has been family violence against you, is that correct?
yes.
And who called the police on that incident that we discussed earlier?
I call the police.
And were you expecting child?
Excuse me?
Were you pregnant?
Yes,
How far away were you pregnant?
I was already 9 months.
You were 2 weeks before childbirth?
Yes,
Who takes the child to the doctor?
myself.
Has he ever taken him to the doctor?
No,
You were making arrangements to take him to speech therapy, is that correct?
yes,
Has he done it? Has your husband done anything to help you with bills or take him to the doctor or to get the speech therapy that he needs?
no.
Why do you think it's in the best interest that the visitation be restricted and with no overnight until the child turns 3? Why?
It's not convenient right now because it would interrupt the child's routine,
su dieta,
his diet,
y estoy preocupada por el ambiente del lado de la familia paterna del bebé.
and I'm worried about the paternal parents' environment, family environment. Alcohol, drugs, and the use of anxiety pills. Alcohol and drugs.
You have seen this at his parents' home?
His dad's home.
That's his,
He's my baby's grandfather.
yes. Have you ever seen him feed the child or prepare a meal for your son?
No,
Do you think your son would, how does he react when he visits, your son visits with the fathers? Tell the court what happened.
Pues el niño no lo conoce, no sabe qué es.
Well, the child doesn't know him. He doesn't know he's his father.
Does he cry?
Yes.
Do you feel that's good for the child?
No.
No.
So are you asking this court that the visitation continue as set out in the temporary orders? And that the respondent not have any overnight visitation until the child turns 3, is that correct?
yes,
Regarding support, did he ever provide support from the date of separation, which was November 19th of 2025? Did he miss 2.5 months of support?
yes,
And he owes you $2,362, is that correct?
yes,
And you're in agreement that the house be put for sale and that 3 months would be a reasonable time for the house to be sold, or that you agreed to return the house through foreclosure, is that correct?
yes.
Any other questions?
I believe that's all you.
Cross-examination for Ms. Leal, Mr. Garcia.
Thank you. Ms. Leal, when you talk about routines, I mean, did you get any special training on feeding your baby?
Can you repeat the question?
Yes, earlier you were talking about routines. Did you get any special education on how to feed your baby?
Si yo recibido,
If I have received?
Yes.
Yes, I do attend 2-week programs and I do take online classes that they teach me what to feed the baby.
Okay, and do you also get any special training on how to change the diapers of your baby?
Just in the week programs.
And is that something that Mr. Leal can learn quickly if he doesn't know how to do it?
Objection leads to speculation, not within her personal knowledge.
Ms. Leal, don't guess, don't speculate. If you have an opinion, you can certainly give that opinion. Go ahead.
puede aprender, pero por el momento el niño no tiene conexión con su papá.
With time, he can learn, but right now, the child does not have a connection with the father.
Okay, but wouldn't he ever start having a connection if he starts having more visits? Wouldn't it be better for, I guess my question is, wouldn't if he have a relationship with the father if he starts having more visitation?
Sí, pero es con el tiempo. Si él quiere, yo le puedo que él tenga más visitas supervisadas y cuando.
Yes, I would. If we would like to have, I would like to for him to have more supervised visits.
Y ya cuando el niño tenga más conexión con él, que él ya cambie más sus pañales, le sepa dar de comer.
And then once he has a better connection with the child, then he already changes his diapers and feeds him.
Y el niño ya se exprese,
And the child can express himself.
él ya podría tener unsupervised.
And then he could have unsupervised visits.
Now, you want my client to continue having visitation as it is in the temporary orders, is that correct?
Yes,
Now, do you realize that it's just 2 hours every like a Saturday out of the first, third, and fifth Saturday out of the month?
Sí, pero por eso ofrezco que si él quiere verlo más, está bien por mí, si su familia quiere estar,
Yes, that's what I'm offering if he wants to see him more and if his family wants to.
puede ser supervisado
They could be supervised
hasta que el niño tenga la edad.
until the child has the age.
Now, you mentioned supervision, but has my client ever injured your son?
Él tiene comportamiento que me preocupa y su familia también.
He has behavior that worries me and also his family.
Y él nunca ha estado solo con el niño.
And he has never been alone with the child.
Cuando estábamos casados, yo renuncié a mi trabajo para criar del bebé y yo siempre estaba presente cuando él estaba.
When I got pregnant, I quit my job to take care of the child, and I was always present when he was.
I understand, Ms. Leal, but has my client ever injured your son?
No.
Does my client, I guess, has he ever used drugs in front of your son?
Drogas no, pero alcohol.
Drugs, no, but alcohol, yes.
Okay. And when it comes to child support arrears, did he provide any type of money to for your son in the months of November, December, and January?
Yo le decía las cosas que necesitaba del niño y no me las traía tarde.
I would tell him what the child needed, and he would not bring him. He would bring him in late.
So he would bring you in some stuff.
Un mes después.
A month later.
And what did he bring you?
Una-
A box of diapers, toys.
Did he bring anything else besides that?
La primera vez que lo llevó, le llevó pañales,
The first time he took him diapers and baby food.
y yo le había mencionado que el niño se caía mucho porque necesitaba unos zapatos para caminar mejor.
And then I had mentioned him that the child would fall a lot because he needed some special shoes so he wouldn't fall.
Y me decía siempre next time.
And he'd always tell me next time.
Y también le pedía car seat y me dijo un mes después que quizá lo necesitaba.
And I also mentioned I needed a car seat, and then a month later he asked me if I still needed it.
I have no further questions, Your Honor.
That was cross-examination. Anything on redirect?
No, Your Honor, nothing further.
Mr. Alcantar, any questions for either party?
No, Your Honor, thank you.
All right, this is a divorce, is it not, Mr. Figueroa?
Yes, sir, it is.
You already stipulated to the jurisdiction. Let me just ask briefly, Ms. Leal, you filed this divorce November 19, 2025. On that date, had you lived in Texas for 6 months?
Yes, Your Honor.
Had you lived in Webb County for 90 days?
Yes, Your Honor.
Is there any reasonable expectation that you reconcile with Mr. Leal?
No, Your Honor.
Any other questions, Mr. Figueroa?
No, Your Honor.
Any questions or objections to any of this, Mr. Garcia?
No, Your Honor.
Does anybody want to close? I think I've heard the information necessary to make a decision. Anything you want to put on the record, Mr. Figueroa?
The court has heard to both parties. I think there's enough for the court to decide. We feel that the child needs to grow up a little before the father takes over completely. Overnight.
Mr. Garcia, anything to put on the record?
Yes, Your Honor. Our position is that my client hasn't had, because of the temporary orders, he really hasn't been able to exercise the visitations that he wants to exercise. He wants to be with his son. He loves his son. There was no evidence that was provided that he's a danger to his son. And so he would like to have the unsupervised visitations and be able to exercise his rights as the father. There was also some evidence that was provided that there was some assistance provided towards the child support back pay, some form of diapers and other things that he provided. And he is also requesting that if the house and the shed can be sold, I think 3 to 6 months, Your Honor.
If we have no objection that the shed go along with the house, that's no problem. He accepted 3 months already, so I think that's. The court can see the demeanor of both parties. He's very evasive when I ask questions. And he just doesn't want to answer and basically accept that he's not ready to take care of his son.
Anything else to put on the record, Mr. Garcia?
Yes, Your Honor, only that, I mean, he has provided answers and he wants to be there for his son. I believe it's more that the mom just doesn't want to have his son go with his father.
Objection, there's no errors.
Anything to put on the record, Mr. Alcantar?
Your Honor, we just ask that the court make appropriate rulings in the best interest of the child.
All right. Ms. Leal, Mr. Leal. Ms. Leal, are you requesting a name change?
Yes, she is.
Yes, Your Honor.
To what name?
Back to-
Lopez.
yes.
You had said that. I have it in my notes. All right. I don't recall, but I did write it down. All right. Ms. Leal, Mr. Leal, in your case, cause number 2025 FLA 1654C3, the court at this time finds that it has jurisdiction over your case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage. Unfortunately, the court finds that your marriage has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there was one child born in the marriage, no other children were born, adopted, or are expected. The court hereby appoints you both as joint managing conservators, meaning that both of you have the same rights, duties, responsibilities, and obligations over your son, except that you, Ms. Leal, will have the exclusive right to determine your child's residence. The question becomes on visitation, whether it's overnight supervised or not. I think the evidence is clear in this case. If the court acts in the child's best interest, I think the court, I don't find that your questions are evasive. I disagree with Mr. Figueroa that your questions are evasive. What the court focuses on is the direct responses that you actually made when asked at 519, Mr. Leal, whether your father is a convicted felon. Your response was, I don't recall. And the question or the concern that the court has is, given that you work at GEO, which is a detention facility for federal detained persons, it's clear to the court that you have substantial knowledge, or at least specialized knowledge about persons being accused of crimes, but yet your answer wasn't no, or I don't know. The answer is, I don't recall. So at some point, you knew the information and just don't recall whether your father was arrested, not arrested, convicted, or not convicted of any crime. That just is incredible. So because the record is not clear, the court finds that it is in the best interest of your son to restrict visits to no overnights and supervised because of your response. You should know the answer. Regarding the second contested matter, whether child support should be paid between November, January, and February, the court finds several things. One, your testimony did reveal that you worked overtime at some point in the past, in the very recent past. Based on your testimony, the court can see that that may change in the future. So one, the court doesn't think that you should be penalized for working overtime, but the flip side of the coin is that you shouldn't have a windfall for working these hours. That is child support that is due to your son. It doesn't belong to Ms. Leal. It's for the use and benefit enjoyment of your son. And the court did hear that you did provide some assistance with items, but as the Attorney General's office aptly reminds us that there are no credits for informal payments. You can give extra. That's a good, right, and just perhaps even a moral obligation. But legally, you need to give the minimum, which is minimum child support, whatever that number is in your case. The court hereby takes that judgment for arrears as testified to in the amount of $2,362. You should repay that in the amount of $50 per month. Regarding the other issue, the court finds that there's an agreement to sell the home, and the court finds that there's an agreement that that home should be sold within 3 months. I think that's good, right, and just, because the sooner that that home sells, if there is any equity, then that would be for the benefit of both Mr. Leal and Ms. Leal, and quite frankly, also for the benefit of the son. The court finds that doing this is all right and just. Ms. Leal, the court hereby changes your name to Rocio del Carmen Lopez. And at this time, Ms. Lopez and Mr. Leal, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. The rest of the parties' agreement is hereby adopted and approved. These are the orders of the court, and the orders are due to the court honor before.
June 29 at noon by submission.
That concludes your case. Ms. Lopez, do you have any questions for the court?
No, thank you, Your Honor.
Mr. Leal, do you have any questions for the court?
Just the storage, how's that gonna play out if, let's say, since we owe $9,000 on the storage in the backyard? I'm not too sure how that's gonna play out.
You owe 9,000. So
'Cause we
ostensibly,
acquired it during our
whatever,
marriage. Yeah.
so ostensibly, without knowing anything else, the court here didn't hear any evidence to make any different decision. So, when the house sells,
Mhm.
the proceeds are to be divided equally.
Yeah.
And then, but you need to pay off your debts first. So first pay off community debts, and then you keep the rest if any is left over in equity.
Okay, but let's say if just the house sells and we couldn't break for the storage in the back, which we owe 9,000, because we can't move it, what we would do in that case? Sir?
You get half, and Ms. Lopez gets half. That's what you're responsible for.
Okay, we would divide the debt in half and half?
If there isn't enough in equity to pay it off.
Okay, sir.
All right. You have any other questions?
No, sir, thank you.
Anything else on this case, Mr. Figueroa?
The house has appliances, he's asking if, he can keep the appliances. We can address that.
Just sell everything and split it. All right, yeah. Yeah.
We just want to be sure about the shed, that it's not sold by him outside.
Well, so I've already pronounced and rendered that decision. So once it's sold, split the equity, and if anybody sells it improperly or doesn't give 1/2 of the value to the other party, come back and somebody's gonna.
Okay, no, because we owe 9,000, we're not gonna get any equity out of the storage. I'll just, hopefully we could sell the house.
So what Mr. Figueroa is saying is what he doesn't want is for you to go out and sell the storage.
Oh, no.
And then keep all the money that's there, and then you still have a balance. But I'm thinking that you probably wouldn't want that to
No,
happen.
No.
Right, so
Yeah.
I've
No,
in a legal way, I've addressed that with Mr. Figueroa.
there's no way we can move that storage. It's already stuck.
All right,
Yeah.
Mr. Leal, Ms. Lopez, I wish you both very well. More importantly, I wish your young son all the best. Good luck to everyone.
Thank you. I appreciate it, sir. Thank you.
Any other cases for Mr. Figueroa or Mr. Garcia?
No, Your Honor, that is all.
It's good to see you both. Have a great day.
Thank you.
Thank you, Judge. You too.
Thank you. Move on to our second contested matter this afternoon. Elsa Gomez, Andres Gomez, cause number 2018 FLA 242-1C3. Mr. Ramos is present in person. Mr. Dancaus is present in person. Ms. Gomez is present in person. Mr. Gomez is also present in person. Counsel, when last we left off at 3:14, the court and Mr. Alcantara is present by video conference. When we last left off, Mr. Ramos, Mr. Dancaus, Mr. Gomez, the court indicated that you should talk about what amount of money is due, was ordered and is due, if any, how much time could be agreed to so that Mr. Gomez, if ordered to repay any of this balance back, would have a reasonable amount of time so that you don't find yourself back trying to enforce that order. What were the results of your communication, Mr. Ramos?
We have an agreement, Judge.
Go ahead.
The agreement of the parties is as follows. Mr. and Mrs. Gomez agree to the following. Mr. Gomez will provide to me a certified check that he has currently in his possession, made payable to my IOLTA account. The balance remaining, save and accept interest, Judge, but just pure numbers, giving all the credit to Mr. Gomez for payments that currently made. After this $26,000 payment would be $12,998.33. And I will confirm with the Attorney General's office because I was using their numbers based on their system, Judge. And when I filed my pleadings, I used the numbers as of October of last year. So I don't know what that is. It can't be that much in the last 5 or 6 months that would affect the amount. I can't with certainty tell you the dollar value. What I can provide the court is the dollar value based on my pleadings or my exhibit 3 in my pleadings, Judge. And I want to be fair to Mr. Gomez in that regard first. Second, beginning July 1st, Mr. Gomez agrees to pay $400 towards the remaining balance, Judge. And he indicates if sooner, he'll make bigger payments. Number 3, Judge, based on his current employment at a dealership in the Valley, the Lower Valley, he's almost done with his probationary period. He anticipates getting health insurance on or before August 1st. And I'd like to see if we can reset this matter just to confirm the health insurance, Judge, for the one minor child that remains. Mr. Gomez agreed to pay $5,000 in attorney fees. And tentatively it's 90 days. That's another reason that we want, to reset the matter just for status, Judge. That's not he's gonna try his best to do that, to pay that in 90 days. And other than that, that's it, Judge. Is the agreement to the parties.
I understood the first one, the tendering of the certified check and the balance without interest. And
Yes,
then
certified's right here in front of me, Judge.
the second portion was payment of $400, I guess, per month
Per month, beginning
towards
July
the
1st.
balance.
Yes, towards the balance.
The third, unemployment. So remember, I need to pronounce and render something.
Yes.
So I guess let me ask you, you're not under oath, Mr. Gomez, but do you believe that your employment would offer health insurance for your minor children?
I believe so. I just don't know how much it's gonna be, how much it would change. I think I had submitted that to the message before.
But if so, Mr. Ramos, but if Mr. Gomez's employment covers the children for health insurance, what is the necessity to return? In other words,
well,
why doesn't the order just say you're responsible for health insurance? You cover that.
Yeah, well, it's because the current child support order says that, Judge, but for whatever reason, it's not being provided. So right now, currently, she's paying for health insurance under the Obama package, the Obama healthcare package, and that insurance, Judge, the child does have medical needs.
But it sounds like that's going to continue unless Mr. Gomez, because remember, you're here today, and the court has to take the parties as they are today. So why doesn't the court just order continued public health insurance until private insurance is available?
That's fine, Judge.
Any objection to that, Mr. Gomez?
As far as I know, I do get, I do pay on the deduction on whatever it's for the, I guess it's for the.
What does that mean? You think you're paying for health insurance for your children?
Well, no, for compensating for the insurance that he currently has.
So why doesn't the court just order continuation of that until other insurance is available? Because it's a hypothetical until it happens, and I can't make a decision on hypotheticals.
I would agree.
All right. So that takes care of number 1, number 2, number 3, and number 4 is $5,000 in attorney's fees in 90 days. Is there anything else in this agreement, Mr. Ramos?
No, Your Honor.
Anything else in this agreement, Mr. Gomez?
Not at the moment.
So let me do this, Ms. Gomez, Mr. Gomez, let me have you both raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yes.
Both have answered yes. You may lower your hands. Is your true and correct name Elsa Gomez?
Yes, please.
Ms. Gomez, did you hear the agreement that was told to the court by your lawyer?
Yes.
Is that your agreement with Mr. Gomez?
Yes.
Is that your full agreement?
Yes, Your Honor.
Was anything left out?
No.
Is there anything you want to change?
Not at the moment, sir.
And do you believe that this agreement is in the best interest of your child or children? All right, same questions to you, Mr. Gomez. Mr. Gomez, did you hear the agreement that was told to the court by Mr. Ramos, the lawyer for Ms. Gomez?
Yes, Your Honor.
Is that your agreement with Ms. Gomez?
Yes, Your Honor.
Is that your full agreement?
Yes, Your Honor.
Was anything left out?
I believe no.
Is there anything you want to change?
Not at the moment, Your Honor.
Do you believe that this agreement is in the best interest of your child or children?
Yes, sir.
Mr. Gomez, you're here without a lawyer, and you are under oath. Did anybody force you to enter this agreement?
No, Your Honor.
Did you enter this agreement freely?
Yes, Your Honor.
All right, Ms. Gomez, Mr. Gomez, in your case, cause number 2000. Oh, sorry, Mr. Alcantar, let me give you an opportunity to chime in with anything you want.
Yes, Your Honor. I have no objection. As to the numbers, I can get together with counsel so that way we can have the exact numbers when we prepare the order.
All right, Ms. Gomez, Mr. Gomez, in your case, cause number 2018 FLA 2421C3, the court at this time finds that it again has jurisdiction. The court finds that you have an agreement. The court hereby adopts and approves your agreement in full, finds that you have both entered into this agreement freely and voluntarily. The court finds that it is in the best interest for your child or children. These are the orders of the court. The orders are due to the court on or before
June 29th at noon by submission.
Is that sufficient time, Mr. Ramos?
Yes, Judge.
Okay. Do you have any questions for the court, Mr. Gomez?
Just one thing, Your Honor. Is there the possibility of anything being and I'm sorry because I didn't have an attorney.
It's okay.
But that after this agreement that now maybe some of the prying into my private life can be avoided or situated. Is there anything that the court can do to avoid that?
Okay, so let me be very clear about this. So I don't believe there's any pleadings to support that. Now, I don't know what you're referencing. The only thing that I can tell you is if there is a minor child in this case, both sides have to mutually disclose, unless somebody is going to accuse the other person of physical violence, then there should be some disclosure of your residence, communication, and because you're paying child support, you also have to disclose your W-2s, your income tax returns. And I know that this sounds like it's very personal, but it's very necessary for the benefit of your child or children. Other than that, there should be no other, I don't want to say intrusion, but no other inquiries into anything else. You're divorced, so you each go your separate ways, except for things involving the final separation of your assets, and that's what we're here for, and any remaining child support. That's also why we're here. Anything beyond that is now off limits. Does that answer your question?
Yes, it does. I just wanted to make sure to put it in record because it's.
I don't know what you're talking about, but that's generally the law. Anything else on this case, Mr. Ramos?
Nothing further.
Anything, any questions for the court, Ms. Gomez? Anything else for the record, Mr. Dankhaus?
No, Your Honor.
Mr. Alcantar?
No, Your Honor, thank you.
I wish you all a great day. Have a good one.
Thank you, Your Honor. Have a great day.
And Your Honor, I have nothing further, if I may be excused.
Thank you for your patience and your service, Mr. Alcantar. Have a great day.
Thank you, Your Honor. You too.
Please. One case pending before the court, page 5, case 13, Rebecca Cruz versus Humberto Magallanes, cause number 2025 FLE 1326C3. Court marks Mr. Santos present in person, Ms. Alania present in person, Mr. Tames, the now guardian ad litem of the child, present in person, Ms. Rebecca Cruz and Roberto Juan Ziegler present in person, as is Mr. Magallanes. All present in person. I guess let me get some announcements and then we will take a very brief break before we go straight into testimony if necessary. Anything for the record at this juncture, Mr. Santos?
Nothing, Your Honor.
Ms. Alania?
No, Your Honor.
Mr. Tames?
No, Your Honor.
All right. I think we'll divide this at about 20 to 25 minutes per side. Use your time wisely and we'll take it from there. If you need more time, we'll figure it out, but at least try to stick within that time frame. And we we don't need to give Mr. Tames any time. He's just going to give a report. He's a guardian ad litem. That reduced the court's time. Interesting. All right, stand by. We'll resume momentarily. Court is back in session. We are on the record. This is Cruz versus Magallanes, cause number 2025 FLE 1326C3. Lawyers Santos and Saldaña are present with their respective clients at council table. Guardian ad litem, Mr. Tames, is present, as are Ms. Cruz, Mr. Von Ziegler, and Mr. Magallanes. Everyone is present in person. Mr. Santos, are you ready to proceed? Who is your first witness? Ms. Cruz.
Inaudible.
I'm calling petitioner Rebecca Cruz.
Ms. Cruz, please step in front of the lower bench. And Ms. Flores, start the witness stand video. Ms. Cruz, you're being called to testify. I'm going to ask that you raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
I do, Your Honor.
You may lower your hand and you may have a seat here on the witness stand. As that video begins, I'm going to give you some instructions, Ms. Cruz. I'm going to ask that you answer after the full question is asked. Second. If you hear one of the lawyers object, just pause. I'll let you know if you can answer. Mr. Santos, whenever you're ready, you may proceed.
Good afternoon, Mr. Cruz. Can you please say your full name for the record?
Inaudible.
One more time.
I'm sorry, ma'am. Can you, I apologize, Judge. Ma'am, can you repeat yourself?
Good afternoon. My name is Rebecca Isabel Cruz Rodriguez.
And are you familiar with the child, the subject of the suit, Leonel Magallanes?
I am.
Are you related to him?
He is my son.
And who is his father?
Mr. Humberto Magallanes.
With respect to Mr. Magallanes, were you two married?
Yes.
And the relationship between you all, the marriage, was dissolved in April 2018, is that correct?
September 18, 2018.
I'm sorry, ma'am?
It was in September 18, 2018.
And how old was Leonel at the time?
He was 9 months old.
And who did Leonel live with at the or after the divorce?
We lived with my parents back in Mexico.
Was that with you or with Mr. Magallanes as well?
With me.
With regard to that final order in your divorce, were you all appointed joint managing conservators?
Yes.
So you all had equal rights to the child?
Yes.
And was Mr. Magallanes ordered to pay child support to you on a monthly basis?
He was.
Pursuant to that 2016 order, was he ordered to pay $500 per month?
Correct.
Ma'am, has he in fact paid those $500 per month since the signing of the final decree of divorce?
No.
What if anything has been paid to you in child support by Mr. Magallanes?
Can you explain the question? I'm sorry.
Let me clarify, and that is kind of confusing. I apologize. Has Mr. Magallanes paid child support in accordance with that order?
No.
When did he stop following that order?
June 2nd, 2022, with an additional payment on April 1st, 2023.
So is that the last form of child support that you received from Mr. Magallanes?
Yes.
And what amount was that?
$500.
With regard to being there every day as this child's father, was Mr. Magallanes the one who did that job?
No.
Who's the one that raised this child?
My husband.
What's your husband's name?
Roberto Von Ziegler.
Were you in any way avoiding Mr. Magallanes or preventing him from being allowed to visit with Leonel?
Objection leading.
Sustained.
Ma'am, were you Could Mr. Magallanes have reached you if he wanted to?
Yes.
Did he ever reach you?
After 2020, no.
After 2020, no. How old was Leonel at the time?
2 years.
With regard to the child's needs over the years, with regard to, let's start with his medical needs. Who is the one that's been providing for his medical needs during that time?
Objection. Go ahead.
Me and my husband.
What about his financial needs? I understand that Mr. Magallanes has not paid you $1 since 2023. Who's provided for Leonel's financial needs?
Me and my husband.
Can you describe the relationship between Leonel and your husband?
They have a bond. It's a father-son relationship.
How does Leonel refer to your husband, Roberto Van Ziegler?
Objection hearsay.
Response? Sustained.
How does Leonel view Mr. Van Ziegler?
As his father.
Objection
Is he aware
speculation.
of,
Overruled.
is he aware of Mr. Magallanes and the fact that Mr. Magallanes is trying to seek some kind of possession with him?
Yes.
How does Leonel feel about that?
Objection speculation and objection
I'm going to give
hearsay.
you an instruction, Ms. Cruz. Don't guess, don't speculate, don't make things up. If you know the answer, you should give it. If you don't know, you can say, I don't know. Go ahead.
Ma'am, if you know, how does Leonel feel about potentially meeting with Mr. Magallanes?
He's in distress.
Has he in fact had to reach out, or have you in fact had to reach out to medical health professionals because of this issue?
Objection leading.
Sustained.
Ma'am, have you ever had to reach out to medical health professionals regarding your child?
Yes.
Have you done so recently?
Yes.
What's the most recent medical visit that your child has attended?
Objection relevance.
Your Honor, that's
The
incredible.
grounds are, there are two grounds, voluntarily left with another and financial assistance not being provided.
Your Honor, I think it goes directly to voluntarily leaving the child in possession and in care of another.
I'll allow you some leeway, but either get there or don't get there and move on. Go ahead.
Ma'am, has Mr. Magallanes essentially been out of the picture for several years?
Yes.
Has he attempted in any way to get a hold of you or the child?
No.
Has he voiced any concern with regard to your child?
No.
And can you explain to the court why it is that you're seeking a termination in this proceeding?
I want to maintain the stability and the well-being, emotional, physical, and legal well-being of my son, Leonel.
Is it also true that your husband he also intends to adopt Leonel? Is that correct?
It is correct.
When's the last time you've seen Mr. Magallanes?
February 2020.
Tell me about that. What happened?
Objection relevance.
Overruled. You can get there. Go.
He had a visit with Leonel.
And how was it concluded? How did it end?
Normal.
And after that, did you ever hear from him again?
Yes.
What was the next time that you heard from him?
First, it was on September 2020 and in December 2020.
What was the nature of that conversation?
It was an email regarding visitations.
And that was what year again?
Can you repeat the question? I'm
What
sorry.
year was that again?
Can you change the
What year was that email sent?
2020? I'm sorry.
And since 2020, he's not reached out at all.
No,
How old was your child at the time?
he's 8 years old.
No, old was your child in 2020? I apologize.
On February 2020, he was 2 years and 3 months.
Does he even know Mr. Magallanes' face?
No,
Do you believe that it would be in your best interest for your child to have some sort of relationship or possession scheduled with Mr. Magallanes, the time in which he has to visit?
back then, yes.
What about now? Do you think it's good for your child now?
No,
Why not, ma'am?
My son has a stability. My son has a family. He's a great, healthy kid, and he loves his family and his community very dearly. So that would maybe take that stability and safetiness that he have now.
Is it safe to say that Mr. Magallanes abandoned the child and basically allowed you to raise the child?
Objection leading.
Sustained. Don't answer.
Who was supposed to raise your child since Mr. Magallanes was not in the picture?
Me.
And he knew that, right?
Yes.
Objection speculation.
And he's never
Overruled.
voiced an objection to that, has he?
No.
And it's been like that since 2020.
Correct.
And can you state again for the court, if you, when is the last time you received any kind of financial support, a dollar, a penny, with regard to your child from Mr. Magallanes for support for the INEM?
June 2nd, 2022, with an additional payment on April 1st, 2023.
Pass the witness.
Cross-examination, Ms. Saldaña.
Thank you, Your Honor. Miss, do you prefer Ms. Cruz on the podium?
Ms. Cruz.
Okay. Ms. Cruz, you stated that you received payment on April 1st, 2023, or rather that my client paid child support. Did he pay that directly to you?
Yes.
Did he pay all of the previous child support payments directly to you?
Yes.
And is there there's no account with the OAG's office, right? In fact, the Office of Attorney General, correct?
Objection and proper foundation.
She's answered. Next question.
Thank you, Your Honor. Miss, thank you. You stated earlier that you divorced in September 2018, correct?
Correct.
And in that divorce decree, you were awarded to have the exclusive right to designate where the child resides, correct?
Correct.
And the father, Mr. Magallanes, he was awarded visitation, right? That's called possession and access, correct?
Correct.
And so it was the standard where it's first, third, fifth, correct? Weekends?
Can you repeat the question?
Yes, I'm sorry. Mr. Magallanes was awarded first, third, fifth weekends, correct?
Your objection, Your Honor, the question's confusing. I think it misstates the actual possession schedule.
Court will take judicial notice of its own file.
Thank you, Your Honor. Ms. Cruz, whenever Mr. Magallanes was not ordered to have possession, you were the only other person who was awarded to have possession, correct?
Objection, confusing.
I don't know that it is. You can answer if you understand. If you don't, you need to say you don't understand.
I don't understand.
Okay, who, if anyone else, was awarded to have possession of your child besides you and the father?
Me.
Only you, correct?
Yes.
So by you having the child, you've had the child since the divorce till present day, correct?
Correct.
Only you have had the child from the day of divorce to present day, correct?
Correct.
And the divorce decree allows you to have that child from the divorce to present date, correct?
To my understanding, it is.
So by Mr. Humberto Magallanes leaving the child with you, according to you, leaving the child there, it was actually in accordance with the divorce decree, wasn't it?
I don't understand.
That's okay. Miss Cruz, you stated that you lived in Mexico when you divorced, correct?
Correct.
Was that in Monterrey, Nuevo León?
Monterrey.
Okay. Okay. When did you leave? When did you move out of Monterrey, Mexico?
On 2022.
In 2022. Did you let Mr. Magallanes know?
He had no contact for the past year, and I act accordingly.
Objection non-responsive.
Sustained.
Did you let Mr. Magallanes know that you moved?
Objection relevance.
Overruled. You can answer. You can answer.
I act accordingly to the divorce decree.
Did you let Mr. Magallanes know that? Let me stop right there. Actually, the divorce decree. You make reference to the divorce decree. Are you aware that in the divorce decree, there's a required notice? There are required notices in the divorce decree. You're
Objection
familiar
to
with that?
relevance, Your Honor.
Relevance?
She is ordered to give notice to the other party.
I'll give you the same leeway. Overruled, you may answer.
Thank you, Your Honor. You're aware that the divorce decree has orders that you tell the court and the other party when you're gonna move, correct?
Correct.
Okay, but you did not tell Mr. Magallanes when you moved, correct?
We had no contact.
So that's a yes or no, ma'am?
No.
Thank you. And you did not tell the court either, or the clerk's office that you moved, correct?
I didn't know that was necessary.
Okay. So the answer is no, you did not tell the court or clerk's office, correct?
Correct.
Okay. You stated that it would be a danger for the father to reunite in any way with the child, correct?
Incorrect.
Okay, so it would not be a danger for the child and the father to reunite.
Incorrect.
I'm sorry. Is there any danger for the father to be with the child, in your opinion?
Physically, no.
Okay. During the time that the father was visiting the child, were there any concerns about the child's safety?
Objection, questions
Yes.
confusing.
Okay.
Been answered.
And is that why you would deny visits?
Incorrect.
Why would you deny visits?
Objection, question assumes facts that are not in the record.
Sustained. Don't answer. We can move on or rephrase as you wish.
Yes, Your Honor, thank you. Okay, I'm gonna pass the witness.
That was cross-examination. Anything on redirect?
A few questions, Your Honor.
Go ahead.
With regard to your move, ma'am, that's not the reason that Mr. Magallanes has not been in contact for Leonel all these years, is it?
Objection, speculation. She cannot answer as to why my client would or would not be present.
Don't guess, don't speculate. If you have an opinion, you can give it. Go ahead.
No.
So he could have reached you another manner other than by knowing your address, correct?
Yes.
What other forms of communication could he have reached you by?
Email.
And have he
Phone.
reached you by email before?
No.
He's never sent you an email
After 2020, no.
before 2020.
Yes, we would send emails.
So he could have reached you by email after 2020, after the move.
Correct.
Did he?
No.
And you said that it might not be physically dangerous, meaning that the physical body might not be harmed in the event that the child's forced to have a relationship with this man who does not know. But would it be emotionally harmful?
Yes.
Tell me about that.
My son, he is very emotionally bonded with his family, which is me and my husband. And he referred to my husband as his father.
Objection, hearsay.
Sustained. No.
You were
Mr.
saying, ma'am,
Santos.
about it being emotionally harmful. How else would it be emotionally harmful? Would it confuse the child?
Objection,
Yes.
leading.
Just can I ask you just pause, just wait for a couple of seconds. Let's see if there's an objection. Mr. Santos.
Would it be confusing to the child?
Objection, leading.
Sustained.
Has this entire process been confusing to the child? Having to be told
Objection, speculation.
I haven't heard the question. Let me hear the full question. Don't answer. I'll hear the objection question.
Ma'am, with regard to this proceeding, haven't you in fact had to tell the child that there's a potential that he might have to meet a man who is now his father? A man he does not know.
Leonel does not know.
Didn't you have to tell him that because it's a possibility?
Yes.
And how did he react upon learning that?
He was afraid.
Afraid of what, ma'am?
Uncertainty.
Who does he identify as his father, if you know?
My husband,
Who is your husband again?
Mr. Roberto von Ziegler.
And again, is it your understanding that it's Mr. von Ziegler's intent to adopt the child?
Correct.
Does Lionel want that?
Correct.
Pass the witness.
Anything on recross?
Yes, Your Honor, very quickly. Ms. Cruz, so you talked to your child about this case?
Very briefly.
Okay. And you think that that is in the child's best interest to talk to the child about this case?
I do.
Your child is 8 years old, correct?
Correct.
Did you encourage the child to maybe find peace with the possibility of being back with his father, at least visiting?
I have.
Objection confusing.
You can answer if you understand.
I have.
Okay. And how did you do that?
Talking to him, saying positive words, saying that we're gonna be there for him, we will always be his family, and that he doesn't have to worry. His nuclear family got him.
Okay. So you didn't actually say anything about the father?
No.
Okay. Okay, I pass the witness.
Anything else? Ms. Cruz, you may step down. Your next witness, Mr. Santos.
We call Humberto Magallanes. Or you know what? I apologize, Your Honor. Can I call Roberto von Ziegler?
Mr. Von Ziegler, please step here in front of the lower bench. Pull a microphone as close to your mouth as possible and raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
You may lower your hand. You may have a seat here on the witness stand. As you have a seat, just listen for the questions that are asked. Pause after each question. If you hear one of the lawyers object, just pause. I'll let you know if you can answer. When you're ready, Mr. Santos, you may proceed.
Please see your full name for the record, sir.
My name is Roberto von Ziegler.
And how do you know the child, the subject of the lawsuit, Lionel Magallanes?
Do I know him?
How do you know him?
He's my stepson, but I view him as my son.
What type of relationship do you have with this child?
It's love, and it's a father-son relationship built on trust.
I'm sorry, sir. I didn't mean to cut you off.
Built on trust and love.
Who picks up your Lionel every day from school?
I do.
And what happens every day when you pick him up from school?
We walk from the bus stop to our house, and we talk. You know, we share our day. How was our day? And he has, sometimes that he has called me, "You're my best friend," and it's a very, unique.
Objection hearsay.
Sustained.
Has Lionel ever questioned or had any concerns about his biological father, or why he has a different last name than you?
No, like he hasn't told me anything about that. His dad, his biological father.
Have you stepped in and filled the role of the biological father?
Yes,
For how long, sir?
it's been since 2020. I've been there for him. In 2022, he came to Laredo to live with me, and ever since we've been, very close, and we had a father-son relationship.
Has Mr. Magallanes ever reached out to Rebecca Cruz, you or anybody else that you're aware of, about Lionel since 2020?
No.
And would you have prevented him from having a relationship with the child had he reached out and shown some sort of interest?
No.
But he's shown no interest, correct?
Yes, that's correct.
And Lionel wants to be adopted by you, correct?
Yes,
And do you want to adopt this child?
with all my heart.
Do you think that that would be in this child's best interest?
Yes,
Have you been his father?
yes.
What does that mean to you, sir?
It's the greatest honor of my life.
Why?
because I'm his guidance, to be the guide for a human being, to help him become a better person, a person of faith, a responsible person with integrity. That's what I think that's the greatest gift I have ever received in my life.
And you recognize that this child needed that,
Yes,
and you stood up to the plate and you delivered, correct?
yes,
And you want to adopt this child.
with all my heart again.
Pass the witness.
Cross-examination, Ms. Eleni.
Yes, thank you, Your Honor. Mr. Van Ziegler,
Yes, one second.
when did you meet Miss Cruz?
When?
Yes,
When it was back in 2017.
okay. And when did you start dating Miss Cruz?
One second, it's 2019.
And when did you meet the child?
It was 2019.
Okay. Okay, but you testified that you didn't step in as a stepdad until 2020, is that correct?
As a stepdad, as the person who who cares for him financially, emotionally, and spiritually. Yeah, that's correct.
Okay. Do you recall the month by any chance?
In 2020, it was
Correct.
around, I would say, November. Yeah, I don't recall the exact month.
I pass the witness.
Redirect.
Nothing further from Mr. Van Ziegler.
Mr. Von Ziegler, you may step down.
Thank you.
Mr. Santos, any other witnesses?
Your Honor, we call Humberto Magallanes.
Mr. Magallanes, step in front of the lower bench. Pull a microphone up to your mouth and raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
I swear.
You may lower your hand. You may have a seat here on the witness stand. You can stand next to, do you have a lapel or a portable mic? All right. The interpreter will stand right next to you, Mr. Magallanes. Just listen to all of the questions. Listen to all of the question, and then you can answer. If you hear one of the lawyers object, just pause. You may commence when ready, Mr. Santos.
Mr. Magallanes, why did you stop paying child support in 2020?
Primero que nada, es algo que alguien esté emitiendo, o sea, que todos estamos emitiendo, que cuando pasó todo esto era en épocas de pandemia.
One of the things that everybody is forgetting about is when all this happened was during pandemic era.
Sustained.
Desafortunadamente en esas fechas perdí mi trabajo, pero no dejé de pagar el child support en esas fechas.
Unfortunately, during that time, I lost my job, but I did not stop paying child support.
Después de eso, ¿me podrías repetir otra vez la pregunta, por favor?
Could you repeat the question again?
When did you stop paying child support? You said you lost your job around 2020.
Counsel is inaudible.
Sorry?
Ask the question again, Mr.
You indicated
Santos.
you stopped paying child support in 2020 when you lost your job.
No, no dejé porque me mandaban un cheque de como de alivio, algo así del federal, y yo con eso pagaba el child support.
No, I did not stop. I was receiving a check, relief check from that they were sending to me, and I was paying child support with that.
But there's no proof of you paying any child support after 2020. Correct?
No sé si hay alguna prueba, puedo buscarla en una cuenta de banco que tengo.
I don't know if there's any proof. I can look for it in a bank account that I have.
Sir, you don't think it would have been important to have brought that today in a case where we're alleging you haven't paid child support since 2020?
I'm gonna object since the voluntary or the financial section ground relates to the year 6 months before the filing. So anytime before that really is outside the scope of that ground.
Overruled, you can answer.
¿Cuál que puedo?
What can I answer?
Que si tengo alguna prueba de... No, no tengo, ahorita no tengo ninguna prueba.
No, I
pero-
do not have any proof right now.
Why didn't you petition the court to try to modify child support in the event that, like you said, you lost your job?
Por ignorancia.
Because of ignorance?
Ah,
What
¿puedo
about
decir
your
algo?
child, sir? Why did you stop visiting with your child back in 2020?
Porque pasó lo de la pandemia y yo me comuniqué con Rebeca
Because when the pandemic happened and I did communicate myself with Ms. Rebecca,
y traté de visitarlo en diciembre, bueno, todo ese año, pero al principio del año yo sabía que era un poco difícil por la pandemia,
I did try to visit him at the beginning of the year, during in December, but I knew at the beginning of the year was difficult because of the pandemic.
pero ya en diciembre vi que ya estaba volviendo un poco toda la normalidad e intenté comunicarme con ella y ella me dijo que no era posible.
But in December, everything was coming back to normal, and I did communicate with her, and she told me it was not possible.
Pero pues me fue negada
Objection,
la
hearsay.
visita
And the visit was denied.
y yo también lo acepto, no actué de la mejor manera.
And I also do admit it that I did not
Y
act in the
si
best
tengo que
way.
pedir una disculpa, se la pido aquí frente al juez.
And if I have to
Y lo-
apologize, I do it here in front of the
Y
judge.
si y ahorita estoy aquí para tratar de redimir el problema, no para hacer algún problema más.
And non-responsive.
And I'm here, I'm just trying to remedy my actions. So,
Sustained. Next question.
And Mr. Magallanes, back in September, you had actually reached out and indicated that you wanted to settle this lawsuit, correct?
Objection, relevance, and
Uh,
not only that, it goes to negotiation attempts. And
Sustained. Next question.
Sir, did you agree to in fact terminate your rights voluntarily back in September?
objection that goes to negotiation attempts.
Sustained. Don't answer.
Sir, I'm referring to while in court with your attorney here at our last final pretrial. Didn't you in fact indicate that you are not going to contest this termination?
I'm gonna object as to relevance. At this point, he is contesting it.
If it's part of the court record, the court will take judicial notice. Next question.
And you understand that to be a father, you need to be convicted. It is a responsibility that you're going to carry out.
Objection, he's harassing the client. Now it's just a moral lesson on how to be a father.
I think that's what we're here for.
Don't know that that's harassing overruled, but I don't know that it's relevant either. Next question.
You understand that these aren't rights that you just decide to one day give up. This is a child that's depending on you, but you were willing to give up those rights. Correct?
Cuando él me habló la primera vez, yo no entendía nada de lo que me decía. No
Bueno.
entendía muy bien. Yo nada más decía que sí por ignorancia, no por...
When you called me the first time, I just said yes to everything you said because I was ignorant. I did not understand the significance.
Y obviamente es un miedo que tenía todo este caso, pero por eso, no, al principio no tenía cómo enfrentarlo, por eso traté de conseguir ayuda con la abogada y hacer un esfuerzo por pagar el abogado.
At the beginning, I did not know what was happening. That's why I made the effort to hire an attorney so she could help me because I did not know if I needed to hire one.
But even after hiring an attorney, you had again indicated to the court that you wanted to terminate your rights.
Objection asked and answered,
Mm.
and it's in the record.
I don't recall. Was it asked?
I was trying to get it. It's come up twice, Your Honor. Once when he was in
If it's part of the record and it's repetitive, let's move on. It hasn't been asked, then go ahead and ask it.
And again, you indicated that you wanted to terminate your rights voluntarily in open court after you hired an attorney. You said you were not going to contest the termination.
Objection as to relevance to the grounds.
Well, we're here now. Overruled. Next question.
From 2020 till now, what have you done, if anything, pursuant to your rights with respect to this child?
En 2023 contraté al abogado García
In 2023, I hired Attorney Garcia
para tratar de hallar la manera de pagar el child support.
to try to
Porque
find a way to pay for child support.
le pasé el último correo que tenía de Miss Cruz
Because of the last email address I had of Ms. Cruz,
y él trató de comunicarse con ella, pero no obtuvimos respuesta.
he tried to communicate with her, but we did not receive an answer.
But you hadn't been paying child support. That's why you had sent a correspondence, right?
Pero ¿a dónde la mandaba? O sea, no,
But where would I send it?
no sabía dónde, si estaba aquí en Laredo, si estaba en Monterrey, no sabía.
My question is
I did
this,
not
sir.
know if she was here or she was in Monterey.
Y no
So
sabía dónde
my understanding is that you didn't send it because you didn't know where to send it, is what you're saying?
en algún lapso de ese tiempo tampoco tenía la manera de darlo.
And because there was a lapse in that time that I did not have any way to make it.
But that was back in 2020 when the child support stopped. How was it that 3 years elapsed before you tried doing anything about it?
Perdimos contacto completamente.
Because we lost complete contact.
And today, when you're hearing about this child who's under distress, learning that he might have a relationship with you, doesn't that concern you as to how it's going to ultimately impact that child and not you?
Creo que sí, me preocupa, pero,
Yes, it does worry me.
Pero sé que no es la primera familia que pasa por esto. Y
But
sé
it's
que
not the
hay
first family that
profesionales
goes
que
through
pueden
this.
ayudar solo sé que va a ser un problema, sé que lo puede tener, que puede traer estrés para él.
This is not the first family that goes through this. I know it must cause stress, but there's professionals for that.
Pero estoy en la mejor disposición de hacer todo poco a poco y como el juez o las autoridades me lo digan. O sea,
But I'm willing to do everything little by little, the best way possible, whichever the authorities or the judge orders me to do it.
So you recognize that there might be some trauma and there might be the need of mental health professionals in the event that the court were to order you to have a relationship with this child.
trauma no creo porque soy una buena persona. De hecho, Miss Cruz sabe que soy una buena persona.
Trauma, I do not believe so. Even in fact, Ms. Cruz knows I'm a good person.
De hecho, tengo familia. Leonel tiene un hermano de 4 años y pronto van a ser otro y a mí me gustaría que
Lionel also has a family. I have a son that's 4 years old and there's one coming.
fuera parte de mi vida, pero sé que es algo difícil, pero puede ser algo poco a poco. Yo también me comprometo a pagar el child support y lo que se debe también pagarlo poco a poco.
And I know it's going to be difficult, but I'm putting myself in that I will do everything possible to become a family. I know there's a child support that's owed, and I'm also willing to make those payments.
But you haven't seen this child since he was 2.5 years old. He's now 8.
Sí, I'm sorry, son cosas que han pasado de la vida. Yo también actué,
Sorry, I know there's things that happen in life,
pero estoy aquí tratando ¿cómo se dice? Tratando de arreglar este problema y no estoy
but I'm here trying to fix this problem.
y no estoy aquí de una manera agresiva como lo está usted. No estoy
I'm
de
not
una
here in an
manera,
aggressive way as
estoy
you
de una
are.
manera paz, como desde la primera vez que él me llamó, pero no le entendí. Pero siempre como que siempre fue un poco agresivo.
I've always been here in peace. Not like you that ever since you called me the first time that you've been aggressive, but I've been here peacefully.
Y como te digo, yo estoy aquí desde el primer día me presenté a la corte tratando de dar la cara y tratando de redimir mi error. Que
I've
es
been
al-
here since the first day. I've been coming here trying to redeem myself since the very first day.
no soy una persona una mala persona que está tratando
I'm not a bad person that's trying
de
to
hacer, de que antes era malo y ahorita ya quiero ser bueno. No,
that was a bad person before and now I'm trying to be a good person.
no tengo récord, no consumo drogas, alcohol, que es casi ya lo dejé completamente, no tengo ningún vicio.
I don't have any addictions. I don't do drugs. I might drink alcohol. Drink as less as I can.
Lo único que quiero,
Sustained as to narrative. Next question.
lo único que quiero es tratar de solucionar este
Stop.
problema. I'm sorry.
Mr. Magallanes, you indicated that we've been aggressive with you, but aren't you the one that in fact reached out to us? And I would ask that the court please upload the first upload that we have on baselines.
What document are you, or what number are you asking the court staff to prompt?
We hope either exhibit one or two, whatever it's referred to as one.
Ms. Flores, would you prompt the first document, please?
I'm gonna object again as to relevance. The grounds for the determination have nothing to do.
What, what is that I don't know if it's relevant or not, Ms. Alania. What is that document? Yeah, I think you all know. I don't know.
The witness testified that we've aggressively.
What is the document?
I'm sorry?
What is the document?
The document shows that he's the one that actually reached out to the office. and
What
he's the one that,
is it? A picture? Is it an email? Is it a fax? Is it any objection to that?
No objection.
All right, court staff will prompt.
I'm sorry, what document was that?
I think he asked to prompt the very first thing uploaded.
there are two items uploaded. Sir, do you recognize this document?
Una pregunta, ¿puedo decir algo?
Can I say something?
No, you can
Sure.
answer the question.
My question is, do you recognize this document?
Sí, pero tengo una respuesta.
Yes, but I do have a response.
Sir, my
Cuando-
question is this, do you recognize the document?
Sí,
Yes.
And is it a true and correct copy of what it depicts?
no recuerdo si es correcto exactamente, pero
Is this an email that you sent?
sí.
Yes.
All right, this time we offer exhibiting in the evidence.
Any objection?
It would
Cuando-
just be the same objection as to the relevance.
Your Honor, he opened the door.
I think that's
Cuando-
right.
I'm sorry.
The objection is overruled. This document has been properly authenticated. It is admitted as Cruz 1.
Sir, you understood that we were seeking a termination in this lawsuit. And you understood that if your rights were terminated,
No,
that child support would stop. And you contacted our office to seek to settle it, correct?
Objection leading.
quiero decir algo si pudiera.
I want to say something if I can.
You may answer the question.
Ah, es que no entiendo otra vez. ¿Me puede repetir la pregunta, por favor?
I don't understand the question. Can you repeat the question again?
Sir, you understood the nature of this lawsuit. You had already been served. And you wrote that email in English asking to settle.
Ah, sí.
Yes.
And thereafter, there was a conversation in which you indicated that you wanted to terminate your rights voluntarily, correct?
Pero es que yo no tenía asesoría legal, no sabía que podía. Yo, como te digo,
At that moment, I did not have any legal advice. Like I've said,
cuando te acechan así de buenas a primeras, no piensas claramente qué es lo que tienes, porque
at first you don't realize what they're doing when you first received it.
yo obviamente sé que no había hecho las cosas bien de la mejor manera, asumo mi responsabilidad.
I do accept that I did not do the things correctly. I do assume that responsibility.
Lo único que pido es oportunidad de redimir las cosas.
The only thing I asked for is the opportunity to redeem things.
Any other questions?
Absolutely.
That was direct cross-examination, Ms. Lennon.
Yes, Your Honor, thank you. Mr. Magallanes, you heard mom testify that you paid child support after your divorce up until June 2nd, 2022, and then a last payment of April 1st, 2023. Do you agree with that statement?
Sí.
Yes,
Okay. Now you also stated that you reached out to the mother, Miss Cruz, in 2020, including in December, correct?
Sí.
yes.
What was the response from Miss Cruz to your email?
Que por el momento no era posible.
That at the moment it was not possible.
You also heard the testimony of the stepfather, Mr. Roberto Van Ziegler, correct?
Sí.
Yes,
And you heard him testify that November 2020, right before your last email, that he stepped in to act as the father to your son, correct?
Sí.
yes,
Okay, and that's when things changed with you, right? Correct,
Objection leading.
with your relationship.
I don't no
Overruled,
sé,
overruled, you can answer.
no sé si cambió, no sé lo que haya pasado, la verdad.
I don't know if they changed. I don't know what had actually happened.
Pero yo sí que seguiría seguirlo viendo. Y yo creía que era,
I did not. I did want to continue seeing him,
pero no me dieron la oportunidad de seguirlo viendo en ese momento.
but they did not give me the opportunity to continue seeing him at that moment.
Y ahora me doy cuenta que
Objection
a él sí le
noted.
dieron chance de verlo
Sus-
cuando estaba la pandemia, porque esa era la excusa principal.
Sustained. Next question.
Thank you, Your Honor. Mr. Magallanes, during the divorce, did Miss Cruz, was she living in Laredo with you?
Durante el divorcio no.
Not during the divorce.
When was the last time she was living with you?
Cuando ella, días antes de que ella se fuera a Monterrey en el 2018.
Days before she went to Monterey, 2018.
The same year you got divorced, correct?
Sí.
Yes.
After the divorce, you had visits with your son, correct?
Sí.
Yes.
De hecho, le hicimos una fiesta cuando cumplió un año.
Yes, we in fact made a party for him when we turned 1.
How often would you visit your son after the divorce?
Yo en ese tiempo descansaba cada 8 o 10 días y cada que descansaba iba a Monterrey a ver.
I would be on break every 8 to 10 days, and I would go to Monterey to see him when I was on break.
Were you ever allowed to take the child to the US, to bring the child to the US?
No.
No.
Who did not allow you to bring the child to the US?
Cause for speculation on
It's not called.
improper foundation.
You can answer the question if you know the answer. Don't speculate. Go ahead.
Okay. No, no estoy especulando. La única manera de que yo podía verlo era con su mamá presente.
The only way I could see him was when the mom was present.
And in what city?
En Monterrey.
In Monterey.
How long did those visits last?
Mayormente lo que es una tarde.
Mostly what's one afternoon.
Would you have liked to have had longer visits with your son?
Objection relevance.
Overruled.
Claro.
Of course.
So you were allowed to see your son in 2018, and up until when were you denied visits?
Objection reading.
It's cross-examination.
Overruled.
En 2020.
2020.
Okay, and that's again when Mr. Ziegler testified that he stepped in to act as the father, your son's father, is that correct?
Es algo que yo no sabía, pero pues es lo que dijeron. Sí.
It's something that I did not know, but that's what they said.
Now, Mr. Magallanes, you're familiar with the divorce decree, correct?
Sí.
Yes.
And in the divorce decree, you were awarded the standard visits, correct?
Sí.
Yes.
And the mother was awarded the right to designate where the child resided, correct?
Sí.
Yes.
So did you ever leave the child with anyone other than the mother?
No.
No.
Okay, and in fact, you were following the court order because the child should have been with the mother all this time, correct?
Sí.
Yes.
If you could have been given the opportunity to see your son all these years after 2020 to present, would you have visited your son?
Sí.
Yes.
Do you believe that you're a danger to your son?
Can you puede repetir otra vez? por
Can you
favor?
repeat the question, please?
Do you believe that you're a danger to your son?
No, para nada.
No, not at all.
Okay. Mr. Magallanes, how would you pay child support to the mother?
Objection, Your Honor, there's no indication as to when we're talking about with regard to any alleged child support payments.
And
which-
that's okay because mom already testified that she would get paid directly, so that's okay. I'll ask the next question.
Okay.
Mr. Magallanes, you heard the mother, Ms. Cruz, testify that you would pay her child support directly, correct?
Sí.
Yes.
Did you ever try to open the case with the OAG to try to pay the OAG instead of mom?
La verdad, eso lo desconocía completamente.
No,
por
I did not know
ignorancia.
about that.
I'm sorry, no me informé bien. Bueno, I'm sorry, no.
No, I'm sorry, I was not informed correctly.
Mr. Magallanes, did you ever contact an attorney to try to help you to set up child support payments with the OAG?
Sí, Mr. Garcia.
Yes, Mr. Garcia.
I would ask the court to please prompt our exhibits on case line that we filed.
What
It's the
number?
I don't know the number. I think B1. It's the first.
Court staff will prompt the first exhibit by respondent.
Thank you, Your Honor.
You object on grounds of hearsay, Your Honor.
What is the document?
It's an email.
It's good for one, it's good for both. Overruled.
Thank you.
You'd
Your Honor.
object on grounds of conditional relevance.
Flesh that out for the court. What does that mean? What do you mean?
It would only be relevant in the event that this is an email that was received or seen.
I don't know the answer because I still don't know what it is. I guess ask questions and then I'll figure out whether it is or isn't.
Yes, Your Honor. Mr. Magallanes, you stated earlier that you hired Mr. Garcia's office, correct, to locate Ms. Cruz to start an OAG case? An
Objection, that
office of the
misstates the
Attorney General?
testimony. I don't believe that that's what he testified to at all.
Sustained.
Mr. Magallanes, why did you hire Mr. Garcia, the attorney?
Primeramente porque quería acercarme a pagar el child support para en un momento dado poder.
First, because I wanted to pay child support because I wanted to see Lionel.
Okay, now could you look at the screen, Mr. Magallanes? And are you familiar with the email that you see on the screen?
My last contact I had, that was the email I had for Ms. Cruz.
Okay, and is that the email that you gave to Mr. Garcia, the attorney?
Yes, I gave it to the attorney.
Could the court please scroll up? Thank you. Mr. Magallanes, would you please read the email? Oh, if you could.
Good afternoon. We are consulting for if we can be following his child support payment, what the phone is on child support back payment. We need your address for the transfer to the paperwork and everything without no like without our office to get more information.
Mr. Magallanes, what is the date of that email?
January 11th, 2024.
And could the court please scroll up a little more? And who is this email from?
It's the office of Attorney Garcia. I provided the email so they can communicate with her.
Now, again, you heard Ms. Cruz testify earlier that she did not give you notice as to her new location or her son's new location after she moved out of Monterrey, correct?
It's correct.
So what was the, besides email, was there any other way that you could have found your son or the mother?
No que yo sepa, no.
No,
la verdad no.
not that I know of. No,
Perdí contacto
not-
completamente.
I lost complete contact.
Okay. Mr. Magallanes, you testified earlier that you lost your job in 2020,
Sí.
Yes,
but you also testified that you continued paying child support, correct?
Sí.
yes.
Objection, I believe that misstates the testimony. I believe
It's
the
a subject
testimony
of redirect overruled. Ms. Alania.
Thank you, Your Honor. But you also heard Ms. Cruz testify that she admitted that you paid up until June 2nd, 2022, correct?
Correct.
Objection,
Correct.
Your Honor.
Mr. Magallanes, you are asking the court that your rights not be terminated, correct?
Correct.
Correct.
Do you believe that that is in the child's best interest? That your rights not be terminated?
Yo creo que sí.
I believe so.
Now, you've heard testimony that Mr. Ziegler has stepped in and acted as a stepfather to the child, correct?
Sí.
Yes.
Would your involvement with the child interfere in any way with the relationship between your child and his stepfather?
Objection calls for speculation.
It's what he would do. I'm asking him what he would do.
Para nada.
Overruled.
No.
Mr. Magallanes, if you were allowed to have a relationship with your child, would you support the child maybe getting some therapy?
Objection, it's an incomplete
Claro.
hypothetical.
Of course.
Overruled.
Mr. Magallanes, would you even, for the child's benefit, take it slowly and reintroduce yourself gradually?
Sí, para tratar de causarle el menos daño psicológico que pueda tener y créame que
Yeah, so it would take it little by little so it wouldn't cause any psychological damage.
así como dijo Miss Cruz que tienen un núcleo familiar, yo también lo tengo y él también
As Ms.
pudiera ser
Cruz
parte
mentioned
de.
that she has a family nucleus. I also have one and he could be part of that.
How many other children do you have, Mr. Magallanes?
Tengo uno y otro que está por nacer.
I have one and one that's about to be born.
How old are your children?
4 años.
4.
And would you like your son to have a relationship with your other children?
Claro.
Of course.
Would you ever have voluntarily abandoned your child?
No.
No.
And would you have continued to pay if you had been able to know where your child was and the mother?
Por supuesto. Claro.
Of course.
Okay. However, you have gone through some financial problems as well, correct?
En ciertos lapsos, sí.
In certain lapses, yes.
Okay. And that would include in 2024, correct?
Así es.
Yes.
Okay. And what happened to your job in 2024?
Trabajo en el oil field y es un poco volátil y se bajó mucho el trabajo y perdí mi trabajo.
I worked in the oil field and the work is kind of volatile and I lost my job.
Okay. So not only were you not able to financially during that time period, you also could not locate the mother, correct?
Objection, leading.
Bueno, sí.
Sustained.
Okay, I pass the witness.
Anything else? We have a hard stop in 20 minutes. Anything
Mr.
else?
Magallanes, yes, you had a way of getting a hold of Ms. Cruz. You had her email, correct?
Este correo electrónico, sí.
That email address, yes.
And you sent a correspondence, or you had an attorney send a correspondence on your behalf
Pues,
acknowledging that you had not been paying child support, correct?
así es, y por eso, como ya no contestaron nunca, yo no sabía si ese correcto seguía siendo el mismo.
Objection,
Yes, and since they did not answer, I did not know what happened after that email.
My question is this,
Es
that
la
email that you
respuesta.
just read was strictly related to child support, not one mention of you wanting to visit with this child. Correct?
¿Puedo contestar un poco?
Can I answer a little bit?
Sir, my
Ah,
question
fue-
is it correct that that email is?
Te voy a dar la
about
respuesta.
Child support that
Claro.
you had not paid.
I'm gonna give you the answer, of course.
Yo sabía, soy una persona consciente del problema en el que estaba y sabía que no puedo ir a pedir un niño que no me conoce.
I know the situation, man. I'm a conscious person. I know that I could not ask to go see a
Fue
child
el,
that does
fue
not
el
know me.
primer paso para poder verlo.
That was the
that-
very first step to seeing him.
Isn't that what you're doing right now? Asking
Sí.
to see a child that does not know you.
Sí, creo que hay personas profesionales que se podrían encargar de ayudar.
Yes, but there's also professional persons that can help us.
And you say you didn't abandon your child at 2 years old. What did you in fact do then by leaving him alone to live with Miss Cruz and be raised by Mr. Ziegler if it wasn't abandonment?
Ella se fue a Monterrey.
She left to Monterey.
And you had shared rights, didn't you?
Sí.
Yes.
You didn't exercise those rights.
En ese tiempo habíamos llegado a un acuerdo en paz. De hecho, ni siquiera contratamos abogados para divorciarnos.
In fact, at that time, we had an arrangement. In matter of fact, we did not even hire attorneys to get divorced.
But again, this is a child you haven't seen since he was 2.5 years old.
Pero creo que soy una buena persona
Correct.
que pudiera estar en su vida.
Is it
Yes,
correct?
but I'm also a good person that could be in his life.
I understand. And Rebecca Cruz was not someone that you couldn't find because you had an email address for her. She was easily locatable.
Pues no la pude localizar, por eso contraté al abogado y no la puedo localizar.
No, that's why I couldn't reach her. That's why I hired an attorney to try to reach her.
But you had her email address, right?
Sí, por eso contraté al abogado para que se comunicara con ella de una forma profesional y no nada más. Déjame le mando un email.
But that-
And yes, that's why I hired an attorney so he could send her a professional email, not just me sending her something.
But you had never sent her anything directly.
No,
So it's not that she was denying you or hiding the child from you. It's that you didn't try until child support came up and you try to address that issue because you hadn't paid it for years.
No, no es cierto. Lo de la manutención fue antes. Yo primero tuve contacto mediante el abogado que ellos conmigo.
no, I had contact with the attorney first before they had contact with me.
But with Miss Cruz,
Es que perdí contacto completamente con ella.
I lost complete contact with her.
and you did not try.
Contraté al abogado para tratar de comunicarme con ella.
I hired an attorney to try to communicate with her.
Several years later, about the child support you hadn't been paying for years. correct?
Objection, Your Honor, now it's just getting repetitive.
Sustained. Anything else? Any new questions? New information?
So when was it that you lost your job and stopped paying child support, like you're indicating today?
No dejé de pagar manutención. A ver, ¿cuándo fue eso? Fue en el 2023. En el 2024 fue cuando perdí mi trabajo y me cambié a otro trabajo que ganaba mucho menos.
I didn't
In-
stop paying. It was in 2024 when I lost my job, and then I got another job that was paying way less.
Porque como te digo, yo cometí el error ese de que no me dejaban verlo y
I made
pues
the
perdí el
mis-
contacto con ella.
I made the mistake of they did not allow me to see him, and I just lost contact with her.
Y simplemente estoy tratando de redimirlo.
And you stopped
And
paying
I'm just
child
trying to
support.
fix.
And you stopped paying child support. That's why you hired Mr. Garcia to address the child support issue that you were not paying.
Objection asked and answered.
Sustained. Any new questions? New information?
Possibly.
That was redirect. Anything on recross?
I don't have any questions anymore.
Mr. Magallanes, you may step down. Any other witnesses, Mr. Santos?
No other witnesses. Your Honor.
Any witnesses, Ms. Alania?
No, Your Honor.
Mr. Tamez, would you approach the lower branch and give the court your report and recommendation, please? I'm gonna ask Mr. Tamez for his report and recommendation. Mr. Santos, Ms. Alania, would you like him sworn in? Mr. Santos?
Yes.
Ms. Alania?
No, Your Honor.
I just need one.
He's an
yes,
officer of the court.
I need one. Ms. Tamez, would you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
I do, Your Honor.
All right, Mr. Tamez, go ahead.
Your Honor, I can read a report that I prepared.
Yes, sir.
Judge, I was appointed attorney ad litem, but it clarified guardian ad litem on February 24th, 2026. After reading the petition, I met with the parents and the child, each on one occasion. The mother of the child, Ms. Cruz, has filed a petition to terminate the parent-child relationship on two grounds pursuant to Texas Family Code Section 161.001. The first, Mr. Magallanes left the child alone or in the possession of another without providing adequate support of the child and remained away for a period of at least 6 months. The second provision under 161.001, Mr. Magallanes failed to support the child in accordance with his ability during a period of 1 year, ending within 6 months of the date of filing the petition. Procedurally, Ms. Cruz and Mr. Magallanes were divorced on September 20th, 2018, in cause number 2018 FLA 1153C3. Importantly, Judge, this court divorced the couple through its pro se docket. At the time of the divorce, LM was under the age of 2. The decree gave Ms. Cruz the right to establish the child's residence. The decree further ordered child support at $500 per month beginning on October 1st, 2018. No child support account was established with the Secretary of State disbursement program, and there does not seem to be an order of withholding entered. After the divorce, although I heard testimony to the contrary, but I guess during the divorce, Ms. Cruz moved to Monterrey, Mexico, but is now residing in Laredo, Webb County. She works for Laredo Independent School District. Ms. Cruz reports child support was paid until June 2022, with one payment in April 2023. Ms. Cruz has now remarried, but has no children of this marriage. She states that one of the reasons for the termination is so the child's stepfather can adopt him. As a matter of fact, I think there was a lot of testimony that directed that as being the reason. She further claims it would be in the child's emotional interest to have the stepfather adopt him. Interestingly, on this particular case, Judge, we didn't hear testimony from any professional regarding the emotional well-being of the child currently. Nothing in terms of what the emotional injury would be to the child if it established a relationship with the father, or that this parental rights were terminated. Mr. Magallanes also lives in Laredo. He has a 4-year-old child currently, and as testimony elicited today, has another child on the way. He is gainfully employed, at least when I spoke with him. He was working in the oil field industry, reporting an annual income of $60,000 a year. Mr. Magallanes claims that he had visits with the child after the Ms. Cruz moved to Monterrey. The child was 6 months old when Ms. Cruz returned to Monterrey. But he claims that COVID made travel for visits more difficult and that the relationship became more distant thereafter. We heard testimony today that there were some visitations that were denied and that visitations were restricted. He further claims Ms. Cruz refused visits, but it's not clear how many attempts were made and rejected. He claims he only heard she moved back to Laredo about a year ago. He did claim to me, and he presented some evidence today that he did hire counsel to find Ms. Cruz because he wanted to pay child support and establish a relationship with the child. That was what he told me. I know that wasn't necessarily was established in testimonies today. In 2024, he states Ms. Cruz contacted him seeking involuntary termination at first. He said he agreed, but then he changed his mind and did not want to voluntarily terminate. Judge, as the court knows, the legal standard in Texas is high when it comes to terminations. In Texas, to terminate the parent-child relationship brought under Section 161.001, an involuntary termination, the petitioner must establish by clear and convincing evidence 2 elements. The first element is that one or more acts of omissions enumerated in subsection B1 and 2 of Section 161.001. The second element is that the termination is in the best interest of the child. And I'll cite to NRA DN, which is 169 Southwest 3rd, 685 at page 695. That is a case from the Texas Court of Appeals out of Waco in 2005. It was overruled just for purposes of citation by the Texas Supreme Court on other grounds. Involuntary termination proceedings are strictly scrutinized in Texas, and involuntary termination construed in favor of the parent. And that is from the Texas Supreme Court case of Hollig versus Smith, 685 Southwest 2nd, 18 at page 20. holding further that the natural right existing between parents and their children is of constitutional dimensions. A termination decree is complete, final, irrevocable, and divests for all time the natural rights, as well as legal rights, privileges, duties, and powers with respect to each other. I also rely on the Texas Supreme Court case of Wiley v. Spratland, 543 Southwest 2nd, 349 on page 352. In this case, the Texas Supreme Court said actions which break the ties between parent and child can never be justified without the most solid and substantial reasons. Failure to pay support, judge, is grounds for termination. Remaining away from the child can be ameliorated by various facts, and those have to be taken on a case-by-case basis. Now, while the father has failed to provide child support, I think it is established that one, he may not have had the means at all times. The evidence shows that he attempted to contact the mother to try to make those child support payments. The evidence that was elicited and provided today shows that those efforts were not fruitful. The second ground, obviously, Judge, that the child was left with possession of another. I think obviously the dad legally or the mom legally had the right to possess the child, and the father left the child with the mother. So I don't know that we've established those grounds. There is very little evidence that was elicited or produced today that termination of the parental rights meets the second element, and I think that's the most important. That it is indeed in the best interest of the child that all ties with his natural father be severed. The father has spoken and says that he would like to try to establish that relationship with his son. And I think he has a right to do that. I think there's reason to believe that there were reasons why the mother wanted to terminate the relationship that were not necessarily in the best interest of the child, maybe the best interest of the stepfather, maybe in the best interest of the relationship with the mother. But that's not the grounds that establish that's in the best interest of the child. The child has had very little opportunity to develop the relationship with the father. And I think that's very important. Whether it be by distance, by COVID, by parental actions, which aren't always the child's best interest. I don't think that the child has had that opportunity to establish a relationship. And I don't think we can use the fact that he has not been given that opportunity to establish a relationship as now a sword or a reason to terminate the parent-child relationship. I think there's been very bad communication between the parents, and I don't think that's the child's fault. I think that's the parents that have refused to communicate with each other, have not done a good job of co-parenting. The child, importantly, Judge, has a half sibling, and I think that it's important that that child be able to establish a relationship with a brother or half sibling. He may have another one on the way, apparently. So I think that's important for a child to have a relationship with brothers and sisters, and I think that can be fruitful. He has a family through the father that I think he hasn't had a chance to meet, and I think that's important that he establish that relationship. I think his life can be enriched by that. And the father is willing to take steps to ameliorate the situation. I think that he should be given the opportunity. That doesn't say that I condone the father's efforts or lack of effort. I think that it's important that he take this seriously, as any father should. But whether or not that rises to a level of terminate the parental rights, I don't think we're there. I think that he needs to establish a order withholding. I think he has to be financially responsible to provide for the child. And I think he has to establish a relationship with the child. But for those reasons, Judge, I don't think that we've met the heightened standard by clear and convincing evidence that it's in the best interest of the child that the application be granted.
Mr. Thomas, I have a few questions. And you pose some very interesting contemplations for the court. So when we started this hearing at 4:43, you had on, you filed this report. When did you file the report?
Actually, I didn't file it. And the reason I didn't file it was because I didn't fully understand what my role was.
And here's where the court's going. You prepared this report when?
Today.
Before coming to court?
Before coming to court.
You were wearing an attorney ad litem hat, which is why, which you read into the record, had case law and elements necessary for Ms. Cruz to prevail. Subsequent to that, at your request, and I think it was initially objected to by one and not objected by respondent, to confirm that your true and correct designation was guardian ad litem. So set aside, take off one hat and put on the other, because all of the law and all of the elements, not that they're important to me, but they're certainly not your concern anymore. Tell the court in your role as guardian ad litem as to the best interest standard and how it applies to this case, in your opinion.
How it applies in this case, Judge, I would say that because of actions of parents, I think the father-son relationship has been thwarted, right? Inaction, by both parents. I think it's in the best interest of the child to have that parental relationship with the natural father. I think that it's recognized under the law. I think it's recognized in other cases I've worked with in regard to terminations. That is what I think the courts in Texas aim to do. I think that's what the courts aim to do. And I think that divesting the child of that parental relationship, that's why I think it's under such a high standard in Texas.
But I agree. I think you've identified the standard correct. Well, so the burden correctly, but the standard is best interest.
Right.
And best interest is not parent-centered, it's child-centered. I guess the reason I'm asking is I'm stuck, because so in your role, the standard is best interest, and the testimony the court heard at 721 by admission of dad respondent is that reunification would indeed cause, and I quote, psychological damage that would then require therapy. So the question I have is, and again, you know more and they know more about their situation. I just heard everything today in the time that we've had here. But if true that reunification would cause psychological damage that would cause therapy, how does that affect the best interest standard? And how does that fit in with everything else?
Yeah, I think in any case that I've worked in, whether it be a termination case, where it be a modification, that is always a concern. That has always been, I think, in terms of the evidence, at least that I've developed in cases, through third-party psychologists or counselors, to establish what kind of effect this would have on a child. We don't have that evidence here. I'm going strictly based on what I spoke with the mother about, with the father, and what was elicited. But I don't think that either one of these persons can tell you right now what effect it's going to have. And that there are means to ameliorate that effect. I'm working on several cases right now, Judge, and 2 cases I can tell you about, where the concern is the gradual building of a relationship with a daughter or a son with the parent. And that's why we have gradual reunification. That's why we go through the process of counseling to assist that.
But the question before the court isn't an enforcement on possession. Quite frankly, it's not even an enforcement on child support. The only question before the court is termination or not termination.
Correct. But the second element is, as you mentioned, the best interest of the child. So the question was, what is in the best interest of the child?
Right.
And based on the evidence that has been developed, I don't see that is going to be clear and convincing evidence that it's going to not be in the best interest of the child to terminate. Right.
I think therein lies the rub, because the court can find at this juncture that the only evidence before the court is that it will presumably testified to by both parties cause some mental, emotional, or, in the respondent's words, psychological damage. The question is that preponderance or is that clear and convincing? It's a great question.
Well,
all right.
The standard is clear and convincing, Judge, on termination.
Right. So what I'm saying is, if that was the evidence presented today, where on the spectrum does that fall? I don't know the answer. All right. Anything else for the record, Mr. Tamas?
No, Your Honor, and I'm sorry if I wasn't able to clarify that, but that's...
No, I have questions. I presume that we all have questions. All right. Any questions for Mr. Tamez, Mr. Santos?
Mr. Tamez, is it your understanding that the clear and convincing standard applies to both prongs that you indicated?
I'm not even going to entertain any of this anymore because any questions related, because remember, Mr. Tamez is now here as a guardian ad litem. I specifically, we took off his attorney ad litem hat. So the standard is best interest, not legal.
Very well.
If you have any questions with regard to best interest, go ahead.
Your Honor, nothing from Mr. Tamez.
Any questions for Mr. Tamez, Ms. Saldana?
One quick one. Mr. Tamez, do you believe it's in the child's best interest to not grant the petitioner's petition to terminate an adult?
Objection, Your Honor, and also that calls for an opinion on the ultimate fact.
That's his job.
Yeah, I don't think that best interest has been established, that it is in the best interest of child.
Thank you.
All right. I was not kidding. Thank you, Mr. Tamez. One other question, Mr. Tamez. Anything to put on the record with regard to fees?
Your Honor, the parents both paid what the court had ordered at $750 each. It's probably surpassed that based on what happened today. But any order from the court, if I can put in amount that may be owed at that time. I haven't looked at the time, honestly, Judge. I started working on this today and I've been here the afternoon. I thought it was important to be in person. That's why I've been here. This is a termination trial on the merits, and so that's why I've been here.
I appreciate that. Thank you, Mr. Tamez. All right, Mr. Santos, Ms. Alani, thank you.
But if I can leave that open, Judge, and I can present that.
I'm about to address that. Yes, sir. Mr. Santos, Ms. Alani, I really meant what I said when I said we have a hard stop at 7:45. So let's do this, because I think you know the questions that the court's going to be answering before giving you a final determination. So let's do this. Mr. Santos, you were to prepare an order granting the termination as to the first and the second. In the alternative, Ms. Alani, you're to prepare an order denying the same. You should have both of those in by Thursday. Thursday, the 18th, so in 2 days. It's not going to be accepted on Friday because the county's closed. If you would like to prepare written closing statements, you can do so. You just have to summarize what you believe the evidence showed. It'll be part of the record. And then you'll have a decision after the holiday next week. Mr. Tamez, in the interim, is going to prepare anything that he wants the court to consider. He's going to file that by Thursday. You have a deadline, Mr. Santos and Ms. Saldana, to prepare any objections to his request, and you should get that on file by Tuesday, June the 23rd. If there are no objections, the court will order the payment, absent an objection, later in the week. Thoughts, comments, or questions to any of this, Mr. Santos?
Your Honor, with regard to the written closing statement, the deadline for that would be?
Get it in by Thursday.
By Thursday as well?
Yeah.
Thursday, I'm sorry, Thursday tomorrow?
Tomorrow's Wednesday.
Oh.
All right.
Thank you.
Anything else, Mr. Santos?
Nothing from us, Your Honor.
Ms. Saldana?
And I'm sorry, the order would be due when?
Same day. So Thursday. Everything is due Thursday. Closing statements, if you want, but summarize what you believe the evidence showed and talk about the best interest standard. Talk about whether I think it was met clearly by a preponderance. The question is, was it clear and convincing? It was testified to both sides, both petitioner and respondent, both testified. I think one testified as to emotional damage and the other one testified as to psychological damage that will require therapy if reunification happened. I don't think anybody disagrees that child support wasn't paid. The question is, where is that standard? And how far up did that burden of proof go up? Enough to clear and convincing? Prepare something for the court. It'll be part of the court record, whether you win or lose. You can always take it up on review if you think the court gets it wrong. Ms. Cruz, Mr. Van Ziegler, Mr. Magallanes, I wish all of you well. Have a good day.
Thank you. May we be excused, Your Honor?
Yes.
Thank you.